Hi, Dave.
Hi, Anna.
How are you?
Good. How are you?
I'm well, thank you. So you are live
Thank
on
you.
YouTube. Mhm.
Join the meeting.
Good morning, Anna.
Hey Jeff, how are you?
Good. So no echo this morning.
No.
Hi, Jeff.
Good morning, Jason. How are you, sir?
Oh, just absolutely wonderful.
I understand completely.
Yeah.
I saw your motion come through earlier and didn't know if we're going to need to respond or not. I certainly have no objection with what folks agreed to. I'm a little concerned about some of the things that were not agreed to, but I'm not
Well,
sure how it's going to be handled. So you certainly have our support, and you can refer to that if it comes up.
Okay. Yeah, I think the hearing examiner will get to it and ask what people's positions are, and my position is I did the best I could.
I hear you.
And
Well, you're all dressed up. I guess I better go put my coat on.
oh, you know, so Jeff, is that a porthole behind you? That dark round circle? You're muted.
No, what that is a brass plaque that is engraved with copper that I got in Sousse, Tunisia, many years ago. So basically, it's written in Arabic and is a welcoming message. So it's just a big brass plate back there.
Okay. I was thinking you're trying to remind yourself of your naval service.
Oh, I have enough memorabilia around here. I have my command at sea pennant posted.
Okay.
Some water from when the submarines made a trip underneath the North Pole and got water from at the North Pole underneath the ice and stuff. So all kinds of stuff that won't fit at home. I don't know what I'll do when I shut down here and cart all this stuff back to the home office. But quite a bit of my command at sea pennant from my ship and a number USS Constitution lithograph that I was given. So all kinds of stuff.
Why don't you invite me to come visit you sometime?
I will do that.
You say you don't need it till 10.
Good morning, David. This is Mr. Albright. Just checking in to see how the volume is this morning. Can you
It's
hear me
good,
okay?
Mr. Albright. Yes, sir.
Okay, thank you, David.
David, it's Gideon Elliott. How's my volume?
It's good, sir.
Okay.
Well, now I want to test my volume. How's this?
That's good, Stephanie.
It's okay.
Hey, David.
Good morning.
Good morning to you.
Morning, all.
Good morning, Judge.
Morning.
Morning, Mr. Lee. I'm sorry for the slight delay, some technical difficulties, but we're at 9:02, and I'm sorry for keeping you waiting about that. But I had an emergency motion. Actually, it's the second motion filed on this issue in the last few hours because there was a motion, an unsanctioned arguments made in an email last night that ended up being in a motion this morning that we will address in due course, depending on how many hours there are in the day to address them. All right. So first up, let me hear from the parties. On the issue of administrative notice of the merger proceeding, where are we? Mr. Marks, I'll start with you.
Are we on
Thank
the
you.
record, Judge?
Yeah, we're on the record. I'm sorry. Yes. Just
Good
start
morning,
now,
Mr.
David. Thank you.
Good morning, Mr. Maderos. Pursuant to your honor's directive, Sierra Club, New Energy Economy, and PNM consulted after the conclusion of the hearing, and the parties were able to narrow their differences. PNM and New Energy Economy made some concessions on their differences. There was there were two items that they could not agree on. I have filed a amended Sierra Club motion this morning that and served it on the list about around 8:25 this morning, and indicates that the items that the three parties could agree upon, and then in paragraph 3, identifies two portions of the transcript of Mr. Pedro Azagra Velasquez's cross-examination that New Energy Economy seeks to admit, PNM opposes, briefly gives the parties reasons for that, but Sierra Club would ask that the hearing examiner grant administrative notice or take administrative notice of everything identified in paragraph 1 of our amended motion, which are the documents for which there was no opposition by these parties, and we believe by any other party based on our prior motion, and then make a determination on the item in dispute, the two items in dispute in paragraph 3 of our motion. And we hope that that's been of some assistance, but I was unable to get to a complete agreement.
And are these things, are the items uploaded to Dropbox?
We're working on that. And
And our rules, and you know that it's not just, it's an iterative process, as you know. It's not just the commission, it's not just the hearing examiners creating orders that they spend a lot of time on so that these cases can move, these very complicated cases can move on as expeditiously as possible without inordinate and unreasonable delay, which we are suffering right now. But they're also based on the commission's rules, right? Yes or no, Mr. Marks?
Yes, the hearing examiner is always correct. I mean, certainly on a matter of this, you're correct on the, and that was my negligence, and I'm working to remedy that.
All right, we're not getting off to a great start with sarcasm.
I seriously, Mr. Medeiros, the tribunal is, I respect the tribunal's orders and the tribunal's experience. I mean, the tribunal's, you know, you're in control of this procedure, and I will abide by your orders. So I'm working on it.
And I appreciate it, sir. Thank you.
But Mr. Medeiros, I would ask that we can do it either way, but it'll be clearer if you make a ruling on that disputed portion of the transcript, then we can have a little bit cleaner exhibits.
Examiner Medeiros. This is Mary Almanassi. The items for which the hearing transcript, a number of the items that are on Mr. Marks's list have been uploaded and were uploaded per your order on August 27th. So I just wanted you to know that.
Ms. Nazi, how does your, I attempted to ask you last night or yesterday to see if you could come to an agreement with Sierra Club so that we didn't have duplicative requests for administrative notice of the record in the merger case. How does your request for administrative notice now differ from Sierra Club's, if at all?
I didn't ask for all of the items that Sierra Club asked for, but regarding the testimony of Mr. Azagra Velasquez from—
I'll take that as a yes. There is a conflict still, right?
There is
It's
no—
not entirely, it's not duplicative?
Mr. Medeiros,
Yes.
I am sorry that I have caused you such ire. I don't mean to. I don't know why you are so angry at me, but it's very uncomfortable.
Well, that's clever,
woman.
trying to put that on the record.
I am a woman. I'm an intervener. I am working very hard. I am sorry I didn't yesterday label the exhibits the way that you asked for. I am sorry. I apologize. I will note that neither did the Attorney General, for instance, but I deserve respect.
Ms. Zanazi, on the issue of labeling exhibits, it's not the way I require it. It's the way that the hearing examiner Shannon are required in the merger proceeding too. It's the same rule in the pre-hearing order that exhibits be marked and then identified in the Dropbox folder. And that's consistent with the procedural rule, which says that all exhibits shall be marked. It's not my rule.
I apologize. It's been absolutely—
And so you hurl accusations like that, and then you turn around and act as if, poor me, my ire. That's a very clever attempt that has just been noted for the record as well. So let's just move on, okay? Because it's taking up too much time, and time is the coin of the realm. And this time is going to be taken out of somebody's cross-examination, because that's in order to get this hearing done on time. And it will get done on time. But the inordinate delays, as the record will be made very, very, very clear, it's pretty obvious where those delays are coming from. For instance, marking exhibits on those that you were requesting it taking administrative notice. They're not properly marked. I said from the very beginning yesterday that your exhibits were a jumbled mess, I believe, or words to that effect. Now, it was borne out in the cross-examination of Mr. Falgren when you pulled up that amalgam exhibit that you requested admission of. We haven't even sorted out whether that's admissible or not, but it was stumbling. It was a stumbling mess trying to get through that exhibit because it's not properly marked. And the witness I had to instruct you on how to get the witness to the point in the document where you could even ask questions about it. So do not come back at me and talk about ire. My frustration is born from inordinate experience in dealing with these matters going back many, many years. And I have a record of it. And I will talk about it later in an order, if necessary, that I just issued about where you didn't comply with requirements on applications for a subpoena. Going back to case 13390, that predates my experience with you. So please stop the histrionics and false accusations. Thank you. Now let's proceed. Mr. Nazi, where are we with your motion for administrative notice of the merger proceeding?
There are 3 pages that we didn't agree with PNM on.
Are they the same as the ones that Sierra Club did not?
They are noted in Sierra Club's amended motion, yes. But
Are they the same as the ones that Sierra Club did?
No,
Well, help me out for once.
Mr. Maderos, this is Mr. Marks. PNM and Sierra Club were able to reach complete agreement on the documents that Sierra Club wants administrative notice from the merger case. And we were in agreement coming into this, but our amended motion, we tried to reach complete agreement among the 3 parties, and our motion that we filed this morning identifies the area that New Energy Economy and PNM could not agree upon. Sierra Club takes no position on those 2 sets of pages. If that helps narrow what the issues are, it's a dispute between New Energy Economy and PNM as to 2 pinpoints of the transcript.
So that wasn't even accurate, Ms. Nanazi. The dispute is between you and PNM. Did I hear Mr. Marks right?
yes, I didn't say anything different.
But the conflict is shown in the Sierra Club motion. See how confusing this is?
It's not really that confusing. It's 3 pages. I'm happy to articulate the difference. All I was trying to say was that everything that the Sierra Club has asked to admit is not everything that New Energy Economy sought to admit. I'm fine with everything that Sierra Club is asking to admit. What Mr. Marks just said is true. We tried, we worked out, narrowed a lot of the difference. There are 3 pages that Your Honor has to
Okay.
rule on.
All right. We have this, and we also have another emergency motion. And I'm going to reserve ruling on those things until our first break after I've had an opportunity to review them a little bit closer than I've had the opportunity to do thus far, given that they were filed just a few minutes before the hearing began this morning. So let's continue with the cross-examination of Mr. Falgren with the Attorney General. Mr. Elliott, you have 20 minutes.
Mr. Hearing Examiner, can I just offer one thing? Just so that you have it at your fingertips during the break, the 3 pages are included in NE Exhibit 16, which is now marked, and those last 3 pages that are in that document is where you could look. So I'm just trying to respect your time and effort. Thank you.
Thank you, Ms. Nanazi. Mr. Elliott?
Good morning, everybody. Mr. Hearing Examiner, I certainly don't want to address time at this moment. However, I will note that I've reserved only 20 minutes for Mr. Falgren. I'm hoping I get through it. I will try and reallocate if need be, but you know, I didn't reserve more than I thought I would need. So in the first instance. So I just say that because we've reduced our time significantly. Anyway, Mr. Falgren, good morning.
Good morning. Can everybody hear me well?
Pretty good. Thanks for coming back this morning. I know yesterday was a marathon session, so I will try and make this as quick and painless as possible. But I do have some questions, some more questions than I had even yesterday when I thought I might get a chance to cross-examine you. So I'll go in order of my questions from your rebuttal testimony. So if you would switch to page 5, turn to page 5 for me of your rebuttal.
I'm there.
All right. So I wanted to ask you about the section concerning emissions reductions and the benefits that will occur as a result of the approval. So when you say to serve customers, you're referring to PNM's customers, right?
I would say generally, if you're referring to a specific line, that would help. But
Sure.
I would.
Yeah, I apologize for that. I believe that I'm referring to lines 11 through 12. Let me see. Right. 13. So the question is, do any of the interveners dispute that PNM's customers will save money with PNM's exit from Four Corners in 2024 compared to continuing participation in the plant? And you say that continued, you know what, let's just skip that question and we'll go on to page 6. And I think I'm referring to page 6 anyway. Yes, I am. So page 6, lines 7 through 10. The middle of it's the sentence that begins, the result is that the carbon emissions associated with PNM's generation portfolio used to serve customers will be significantly reduced by the end of 2024 if the commission approves the application. And I guess my question is, we are referring to PNM's customers, right?
In that sentence, we are, yes.
Okay. And you also say on lines 12 through 16 that the shift to seasonal operations is expected to reduce emissions by 20 to 25% starting in 2023. which is a benefit to all New Mexicans, right?
Yes, sir.
So I guess my question is the inverse true? If there's an increase in emissions, would that be a detriment to all New Mexicans?
You'd have to put that in the context, I guess. I think, our statement is generally less emissions is always beneficial. Yes, I guess I would agree that less emissions are generally beneficial. Yes. All things,
Okay.
all else equal.
So in the prior abandonment docket, PNM filed replacement resources, correct? At the same time as the abandonment application.
We did, and then that case was bifurcated, but we did file at the time replacement resources at the same time as abandonment for San Juan.
But in this docket, we're waiting, right? PNM hasn't filed its replacement resources. Mr. Phillips has given us a sense of the availability, but we don't know what the exact mix will be, right?
We have not selected the exact mix. We anticipate that late this year or early next year, yes.
And some of those include gas, potentially?
Yeah, if you look at Mr. Phillips' exhibit, some of them could include, I would define that as flexible gas, if you would. I think if you look at his table that shows the emissions on the PNM system, even using the gas resources will result in significant emission reductions for PNM.
So it's conceivable that even with the seasonal operating agreement, depending on the resource mix that's ultimately selected, the emissions reductions from the seasonal operating agreement might end up being zeroed out, depending on the resources that are selected.
I would say absolutely not. I wouldn't agree with that whatsoever.
That it's impossible.
It's extremely improbable. If I could, I'll explain my rationale. If you
No,
would.
just that it's, I may get to it in one of my questions. If only because I have 20 minutes, I just want to make sure we get through it. Because I guess what I'm trying to understand is the context for the purchase sale agreement and the seasonal operating agreement, or the seasonal operating agreement within the context of the purchase sale agreement. And I guess my question is, was that provision negotiated because PNM was concerned that absent the seasonal operating agreement, emissions could increase if it were to exit the plant?
Could you rephrase that question? I just want to make sure I got it.
Was the seasonal operating agreement important to PNM because it was concerned that if it were to abandon the plant without it, that emissions could increase?
I don't believe that was a primary driver for the purchase sale agreement.
No. The seasonal operating.
I think seasonal operation, if I do that in the larger context, I think there were a number of parties essentially at the table. There's a purchase sale agreement between PNM and NTEC, which is a standalone agreement, if you would. And then there are the interest of all the other parties. I think when you include all the interest of all the parties, then certainly seasonal operation is a key component of it. But again, the purchase sale agreement can stand on its own, but the seasonal operation can't stand on its own.
Right. So PNM wasn't concerned that if it were to exit the plant without a seasonal operating agreement, emissions would increase.
We don't see it increasing, but obviously we saw seasonal operation as a unique opportunity to meet most of the needs of all the stakeholders at the table.
And just, I guess this also gets to my question, and it was negotiated after you had the purchase sale agreement in place?
I would say that they were simultaneous negotiations, but the purchase sale agreement did complete before, and then the seasonal operation.
Sorry, but the purchase
Sale agreement was completed roughly 7 months later.
So
But
what
we were
was
in
it?
discussions. We were in discussions on seasonal operations through that time period.
So was it necessary to NTEC that there be a seasonal operating agreement? Or were they somewhat indifferent in the course of your negotiations?
I don't believe it was a critical component for NTEC to have seasonal operation.
It was more important for PNM.
I think it was more important for APS, SRP, and TEP. And
So-
it would be important to PNM as well.
Okay. So you're familiar with the ETA, yes?
Yes, sir.
Okay. So, and you're aware that the ETA amended the Renewable Energy Act, right?
Yes, sir.
So I am looking at, and it gave the commission new responsibilities in administering the renewable portfolio standards, right?
I believe I can agree with that.
So I'm looking at section 16(4)(b)(4).
Give me 1 second.
Sure,
1
absolutely.
second. And the section again, sorry.
Section 16(4)(b)(4).
Section 16.
Well,
D.
yeah. 62(16)(4).
Do you know what section in the ETA itself is?
Oh, in the bill?
Yeah.
No, I don't have that information off the top of I don't have that information available to me. But subject to
Right.
check, I can read it to you if you'd like.
Maybe if you give me the section you're talking about, I could find it quick.
62-16-4.
Yeah. What's the title? What's the subject?
The renewable portfolio standards. It's the one that lists the renewable portfolio standards for 2025, 2030.
Why don't you go ahead with your question while I'm looking at.
Well, that's the provision that it requires the commission to prevent carbon dioxide emitting electricity generating resources from being sold, reassigned, redesignated, or sold as a means of complying with the standard. And in this case, I guess the first standard would be 40% by 2025 and 50% by 2030. So my question is this: could PNM achieve its 2025 goals of 40% if Four Corners were a part of its portfolio?
Absolutely.
You could.
Well, we could through the 2031. We could through the duration of 2031. And Mr. Phillips describes that in great detail. And what he would say, if you look through Mr. Phillips' testimony in numerous places, he talks about the portfolio models that he did to come up with the $30 to $300 million savings. You'll see in each of those cases what he prescribed there is that each of those scenarios will meet the RPS standards. And specifically, I think on page 25 of his testimony, he will talk about that Four Corners in our portfolio until 2031, we would still meet all the RPS standards.
Okay. So let's switch over to, oh, but I guess what my last question is there. Is that true even if you had, even if you assume there was a no seasonal operating agreement? Or does that assume that there is one?
The seasonal operating agreement doesn't really impact PNM's resource to our customers. Our operation in Four Corners would continue. The assumption there is our operation in Four Corners would continue throughout, as it is, throughout the duration to 2031.
Okay.
Status quo would stay the same for us for operation of it through 2031, and we would still meet the RPS standards.
Thank you. So if we could switch to, if you could turn to page 14 through 17 is where I have my questions here. And this has to do with, well, your criticism of Ms. Crane and also Sierra Club's witness concerning the value of the Four Corners transaction. And I guess my first question is, with respect to the purchase sale agreement's prohibition on PNM voting for early closure, it's my understanding your testimony is that it doesn't make that prohibition really doesn't make a difference, right?
That's correct.
Okay. And
5 minutes, Mr. Elliott, 5 minutes.
I'm going to request to reallocate 10 minutes, 5 from Mr. Phillips and 5 from someone else. I'll figure it out.
You're welcome. It is
Thank
so.
you.
You're welcome.
And you've given us some reasons, and it's because it would require a unanimous vote, right? One of the reasons is that it would require a unanimous vote. It's basically impossible for PNM to single-handedly force the early closure, right?
We pursued early closure. That's not within our ability as a minority owner or as a single owner. Yes, that's correct. PNM cannot require an early vote or an early shutdown.
And the other owners haven't shown any interest in closing the plant before 2031, right?
They're both public and private comments, as I indicate in my testimony, is that they plan to continue, that resource is necessary to meet the reliability needs of their systems through 2031.
So my question is, if the other companies had no interest in early closure, why was it important that PNM cede that right in the negotiations?
I think it's a standard clause, I would say, which is no material adverse effect. And that's a very standard contract term, so that you have to deliver the asset in the same form and function as it was when you negotiated it. I think that was just a clarifying statement in there to clarify that. Again, absent that specific statement, I would still have the same obligations to deliver the asset in the same form and function. Otherwise, I would be bargaining in bad faith.
Okay. And I found it very helpful. You used the analogy of a house on page 16, I think. Yeah.
Yes. I have
That
recent
from the-
experience, I have recent experience, so I can speak personally about that, yes.
But it's a little different here that the house that PNM is selling, you're going to be living in it until 2024, right?
I don't see any difference, because when I executed the sale agreement on my house, I would have done that in May, and I lived in the house until mid-August. So you really have the same effect. So again, I think it's really a good analogy, I think, because yes, after I completed it, I lived in my house for 8 weeks afterwards. So again, I had to keep the house and maintain the house in good conditions. I had to change the light bulbs. I had to do all those things. So I think it's a proper analogy.
So how much is PNM selling its 13% interest for?
Tech will pay PNM $1.
Okay. So I guess when I read that, do you like movies?
Some movies, yes, sir.
Are you a fan of Tom Hanks? I'm a big fan.
Yes, yes.
Do you remember his 1986 movie, The Money Pit?
I do remember it vaguely, yes.
To refresh your memory, that's, the idea is that Tom Hanks and Shelley Long of Cheers fame, they can't afford a house, or they can't afford much house, and they buy a mansion for $1. The bathtub falls through the floor, the chimney falls in, the stairs fall apart. I guess what I read and what I understood was that Ms. Crane was saying that because PNM is basically selling it for $1, that it's something of a money pit. And I guess that $75 million is for NTEC to assume the coal supply agreement, right?
It would assume all the obligations in the coal supply agreement through 2031.
So then did PNM try to negotiate like a greater price with NTEC for the sale?
We discussed what the value would be, but what the agreement that we're able to provide, the only agreement we're able to provide is what's presented to the commission.
Okay.
And I would object to the money pit analogy, honestly.
Noted. So moving on to my other question. Once NTEC assumes the 13% interest, can they, I think it was established yesterday that NTEC could sell the 13% interest to another buyer, right?
The provision in the co-tenancy agreement that includes seasonal operation requires that NTEC, if they were to sell to a third party, would have to have prior written unanimous approval by all the other owners.
Okay.
Under that caveat, then I would concede that that's possible.
So if they sold it for $5, they could. If they sold it for $5, if they sold it for $5, they could make a 500% increase in revenue. Or,
Let's see how the record looks on this here,
okay.
this crosstalk. Hang on just a second. That was an ordinate crosstalk, so let's see where we are with the record to see if it reads decently. So question, if they sold it for their $5, so if they sold it for $5, what's your answer, Ms. Falgren?
If they sold it for $5, they would make $4, but I would presume their legal fees would be more than $4.
Okay, with that crosstalk, if that crosstalk had been allowed to happen, that answer would not have come through clearly. So please, let's not speak over each other. Mr. Gideon, Mr. Elliott, please go ahead.
Let me just ask this, at what point did you learn that PNM shareholders were willing to put $75 million up for the fuel clause or the coal supply agreement?
I don't remember a specific date. It would have been in 2020 at some point, I believe.
Presumably it was during the course of the negotiations with,
Yes, sir.
Hearing examiner, may I just ask for a clarification in the record? Negotiations of what, Mr. Elliott?
the purchase sale agreement.
Okay, thank you.
All right, well, I want to move back to the community benefits. And I just want to ask you, on page, and I guess we'll go back to page 7. And you note that Four Corners is a significant source of funding and jobs for the Navajo Nation. And that if Four Corners continues to operate under, I guess, my question is, if Four Corners continues to operate under different ownership, will there be any impact on jobs?
Could you give me a little bit more what you're proposing, speculating?
Once the abandonment is approved, if it's approved, will there be any impact on jobs?
Both APS and NTEC have publicly stated that they intend no layoffs.
They do.
That they've made that statement publicly, yes.
So with the seasonal operations agreement, operating agreement, the new owners of the 13% will be able to operate the plant with fewer employees.
That's not what I said. You
Okay.
said they would be able to operate the plant with fewer employees. I don't agree with that. But what I said is both APS at the plant and NTEC at the mine have agreed that there are no layoffs as a result of the transaction and also as a result of the seasonal operation.
Okay, thank you for clarifying. I misheard.
5 minutes, Mr. Elliott.
But PNM's application is still requesting funding for the Section 16 costs, the worker assistance funding, right?
Yes, we are.
And you note on page 8, lines 9 through 13, that mitigation of the adverse economic impacts to the local community in the form of Section 16 funds, and not from the 75 million shareholder payment to NTEC. You're referring to the Section 16 funds, right?
Yes,
It
sir.
says it right there. Why was it important to distinguish that the funding isn't coming from shareholders?
I think we were clarifying. I think in Dr. Fisher's testimony, there's a section at the end that kind of gives the impression that the 75 million was the economic benefits, and then his conclusion was there was no certainty that was going to get to the nation. We were clarifying that the ETA provides Section 16 funding that is directed to the state funding that is provided directly to the local communities. So we were just trying to clarify for any confusion.
And the Section 16 cost comes solely from PNM's customers, right?
It is part of securitization.
Why do you think the legislature included the Section 16 provision?
Again, I can't speak for them. My impression would be the ETA was a landmark legislation that included a lot of stakeholders. Obviously, one of the significant stakeholders in the transition is the local communities, and to provide for the local communities.
So going back to the San Juan case, in that docket, PNM also sought approval for the Section 16 funding, and that was approved, right?
Was, yes.
And I think the commission authorized a regulatory asset for that so that PNM could pre-fund it. Is that right?
It was, because I think when we looked at the original ETA, we didn't we didn't or it wasn't contemplated in the ETA that the state's agencies would need to have pre-funding, so there wasn't an abrupt change, when the plant shut down. So I think that was a request from the state agencies to facilitate that they, again, they could start the planning process and minimize the disruption. So yes, we did request. Currently, that's held up in the Supreme Court case, so we have not distributed any funds at the moment. So
You haven't, okay. But are you aware of any workers at the San Juan Generating Station or its associated mine who have been laid off or who are impacted now?
they have been, yes. The mine has been impacted. They have had completed one layoff. They would anticipate another layoff in the coming months.
So those agencies don't have any of the funding available to them to start assisting in the transition?
Not at the moment. We're waiting for the Supreme Court resolution.
50 seconds, Mr. Elliott.
I'll take another 5 minutes, Mr. Hearing Examiner.
All right.
Thank you.
You're welcome.
So that's a question of risk, right? Is that why how much was it? Are you aware of how much money was authorized for pre-funding?
There was $20 million at San Juan. There was $20 million for severances and job retraining. There was an additional $20 million that was for the state agencies.
But the pre-funding that was going to come from PNM, it was much smaller, right?
I think we were looking at 25% of the second amount of the second 20 million.
So 5 million or something like that, 4 million?
Roughly 5 million. Yeah.
And I guess the company's concern is that if it pre-funded that amount, that perhaps the commission in a subsequent proceeding would deny recovery?
It's an unresolved legal issue, so I'm not the lawyer in the room, so I'll leave it as an unresolved legal issue.
It's unfortunate for the workers, though. You'd agree?
Absolutely. I agree 100%.
Did you raise that issue with management?
My management shares my same concerns.
So are you aware who at the company we would need to speak to address this?
I think we need to get the Supreme Court ruling issued.
It's a question of risk, right? And how the company manages it. And it seems as if, if there's uncertainty, you manage uncertainty in other situations. I just don't see, well, this would be testimony and I'm not going to testify. I just, it's very unfortunate. And I'm glad that we're on the record here as to why that's happening.
Noted, Mr. Elliott. Noted.
I'm sorry, Mr. Hearing Examiner.
Your testimony is noted.
Thank you. We're very close to the end. I guess my final question is, while you were on page 42, you say that you didn't receive any directives from your superiors while you were negotiating the PSA. Did you, I guess, so they just let you negotiate it without interference. They said, okay, to the $1 price tag.
I don't think that's what I represented there. I think what we're saying is, was I given specific direction that this had to occur at a certain date, and if it had to occur in a certain manner, if it had to occur, in a certain way. Again, my initiative, was to identify if there were paths. Again, that was our regulatory, the commission ordered regulatory issue for us. It was my obligation to go identify. Then I would bring those options back, and we would review, what options what options might be available.
Okay. And my last question, because I'll be speaking to Ms. Sanchez later this afternoon. Did you discuss it with Ms. Sanchez at any point in time?
I don't believe Ms. Sanchez was involved in the structure of the deal. Ms. Sanchez was involved, primarily to secure the Board of Finance approval that was necessary to file under the ETA. So I would say that was primarily Ms. Sanchez's involvement in the process.
Okay. I just have a couple more questions, I guess. You said that it was more important for all the other parties when you were negotiating the seasonal operating agreement. You said it was more important for all the other parties in comparison to NTEC. Is that right?
I think that's fair.
So, and you said it could stand on its own outside of the purchase sale agreement.
I said it cannot stand on its own.
It cannot. Sorry, excuse me.
Purchase sale agreement can stand on its own. The seasonal operation cannot stand on its own.
And you said that the motivation wasn't to address concerns with an increase in emissions.
Can you ask the question again?
You said it was not the motivation. I'm sorry. You said that the motivation for the seasonal operating agreement was not to address a concern with an increase in emissions, right?
I wouldn't. We'd have to look at the record, but I don't believe that's exactly what I said. I would say it was in our primary consideration. Obviously, it's a benefit and a significant benefit. So it's a beautiful package, I think, that fits all together. And so again, our consideration on the purchase sale agreement, as we've testified to, is customer benefits, which results in 30 to 300 million and allows us to move forward with less carbon on our system. The ability to couple that with seasonal operation obviously provides additional benefits.
I'm sorry, can you start that statement again in addition to that?
Oh, yeah. Yeah, in addition to that, the seasonal operation provides additional benefits, that provides the net benefits for all of New Mexico, if you would. And
so do you think that the commission would be obligated to approve the abandonment if the seasonal operating agreement were not part of the purchase sale agreement?
I think that the purchase sale agreement can stand on its own. I think there are plenty of net public benefits associated with the purchase sale agreement by itself. I think that the ability of the purchase sale agreement to also leverage seasonal operation that provides additional net benefits is a very important consideration for the commission.
Is it conceivable?
Thank you, Mr. Elliott.
I'll take 2 more minutes. Mr. Hearing
Go ahead.
Examiner. Is it conceivable that if the transfer of PNM's 13% interest were approved by all the other parties, that emissions could then increase from Four Corners above what has been agreed to in the seasonal operating agreement? Possible, not probable.
I don't see how emissions would increase. NTEC would operate our 13% shares really in the same manner as we've operated them. There is a take or pay coal contract, which basically for us, Four Corners is on the low end of our batting order, so it's basically running when it's available. So I don't see that a transfer of our share to NTEC can perceivably increase the emissions from the plant, if you would, in any manner.
NTEC could use the low sale price or purchase price as a loss leader, right? They've only bought it for $1. be very cheap for them to sell it to somebody else.
PNM already currently has minimum coal take requirements, and so basically.
I'm sorry,
if you
sir,
look
you
at-
broke up a little bit. The answer again?
PNM already has minimum coal take requirements. So if you actually look at the true dispatch requirement, dispatch differential for Four Corners, and you assume that you're either gonna pay liquidated damages for the minimum coal takes, or you're gonna pay for the coal, the operation, the incremental operation at Four Corners is in the low, almost single dollar kind of digit range, right? You look at that differential. So again, I don't see NTEC having any scenario that has NTEC operate the plant any differently than PNM did.
Thank you, Mr. Falgren. Appreciate your time today.
Thank you, Mr. Elliott.
Thank you.
Sierra Club, Mr. Gerhart, good morning.
Good morning, Mr. Hearing Examiner.
Before I start, in order to move the hearing along and to avoid any more further inordinate delays, I'm going to rule on Sierra Club's motion for administrative notice. And are you with me here, Mr. Gerhart, on this?
Yes, Mr. Hearing.
Just so I have the ruling accurate, I'm going to rule that according to Sierra Club's amended motion for administrative notice of portions of the record in case number 20-0022-UT, which was filed this morning. And let me stop for a second because I'm getting some crosstalk. Somebody has something on that is, I'm hearing an echo in the background. So please turn whatever that is off. Thank you. According to paragraph 1 on page 1, enumerated 1A through 1G, going on to page 2, those items, those pieces of the record in case number 20-00222-UT are admitted. Is that an accurate statement, Mr. Gerhart? Of what you saw?
Yes, Mr. Hearing.
Sorry.
Yes.
Okay, then you can proceed with your cross-examination without any impediment on these documents, correct?
Yes, Mr. Hearing Examiner.
Assuming that pursuant to Rule 1.2.235 D3, D as in David 3, that the documents or portions of the documents have been submitted and have been uploaded to Dropbox. Have those documents that I just mentioned, 1A through G, been uploaded to Dropbox?
Mr. Medeiros, we have a litigation assistant working on that right now. I don't believe that she's finished, but she's working on it right now.
Okay, assuming compliance would. Go ahead.
Sorry, I was going to add that I don't intend to cross-examine Mr. Falgren on any of the documents in this motion, if that's a helpful clarification.
It is, but I thought I'd get them in the record just in case you did, because he may be cross-examined on some of those documents. I'm not sure, but either by you or another party. But assuming those documents are properly submitted in the record by the end of the day, then they are admitted. Thank you. You may proceed. You have 140 minutes. We're at 10 o'clock now, 9:59, and you still have 140 minutes, correct?
Yes.
All right. I'm just going to advise you that perhaps you should break your cross-examination up into 2 discrete pieces so that we can take a break.
Certainly, Mr. Hearing Examiner. I'm happy to take a break whenever you think works.
All right. Thank you.
Certainly.
You may proceed with your cross-examination of Mr. Falgren.
Thank you, Mr. Hearing Examiner. Good morning, Mr. Falgren.
Morning, sir.
Just so we're clear on nomenclature at the outset, I want to note that I'm going to refer to the November 2020 agreement between PNM and NTEC to transfer PNM's interest in Four Corners to NTEC as the purchase and sale agreement, or PSA. And I'm going to refer to the June 25, 2021 amendments to the Four Corners project operating agreement as Amendment 21, just so we're on the same page about nomenclature. Would you please turn to hearing exhibit SC-1? So this is the direct testimony exhibits of Jeremy Fisher that was uploaded to Dropbox. Please let me know when you're there.
I'm here. What page are
Great.
you on?
241, using the page numbers in the upper right-hand corner. So it should be an NTEC presentation titled PNM Exit of Four Corners Power Plant Update.
Very well.
Great. You've seen this document before?
I have, yes.
Could you please stop for a second? Mr. Gerhart, I've got that echo. Is anybody else picking up on that echo?
Yes, Judge.
It needs to stop. I'm not sure where it's coming from, but I'm gonna allow you to proceed. But Mr. Gerhart, and I'll add that to your time. I'm sorry, but the wherever that echo is coming from, it needs to stop. So go ahead.
I apologize, Your Honor. If it's coming from me, I'm not sure why I'm using the same setup as yesterday. Person here in my house, I'll do what I can to try to avoid it. I'm not sure where it's coming from, so I apologize.
Well, I'm not suggesting it's coming from you necessarily, but it's coming from somewhere on the feed. So go ahead. I'm sorry.
So, Mr. Fulgren, the document we're looking at is a presentation that NTEC made, correct?
Yes, it's a presentation made to their member representatives.
And this is a presentation concerning the purchase and sale agreement?
It's entitled PNM Exit of Four Corners Power Plant Update.
I'm sorry, can you read that a little slower? It's entitled?
It's entitled PNM Exit of Four Corners Power Plant Update.
The exit they're discussing is the agreement that became the purchase and sale agreement, correct?
I would agree with that. Yes.
Okay. Would you please scroll down 3 pages to page 244?
Very well.
So if you look at point number 2, it says the additional goal is to mitigate risk of early closure. In addition to avoiding a disruptive exit, we seek to minimize the existing risk that the other owners pursue an early closure for FCPP. Do you see that?
I do, yes.
Okay. So would you agree that when you were negotiating the purchase and sale agreement, you were aware that one of NTEC's goals was to minimize the risk of Four Corners closing before 2031?
I think more appropriate, I was aware that one of NTEC's goals were to preserve the jobs and the revenues to the nation and to NTEC into the nation from Four Corners. And one method obviously could be to minimize the risk of closure. But I think their primary objective, as I would term it, is minimizing loss of jobs and loss of revenue to the nation.
Mr. Falgren, it says right here, the additional goal is to mitigate risk of early closure. So are you saying that you have reason to believe that this presentation is an inaccurate statement of NTEC's goals?
I'm not making that statement.
Would you scroll down 2 pages to page 246, please?
Very well.
So this page discusses conversations with Rainbow Energy Marketers and Guzman Energy. Is that correct?
It discusses, on this page, it discusses Rainbow Energy Marketers and it discusses Guzman Energy, yes.
And PNM and NTEC had approached both of those companies about taking ownership of PNM's share of Four Corners, correct?
PNM had negotiations with those parties on a direct, of those parties directly purchasing PNM's 13% share.
And those conversations fell through. You didn't ultimately sign a contract with either of those entities, correct?
I'm sorry, sir, you broke up. Those conversations fell through and
You did not sign a contract with either of those entities, correct?
We did not sign a contract with either of those entities.
So what specific things did Rainbow Energy Marketers ask for that PNM and NTEC would not agree to?
I can't speak to what the agreements may have been or the issues between those companies and NTEC. I was not privileged to any discussions they had. I can discuss the issues around both of those entities, Rainbow and Guzman, was really a release of PNM of our liabilities associated with Four Corners.
Can you say more about that? Or are you saying they wanted PNM to take on certain liabilities that you weren't comfortable with? Can you just elaborate, please?
Certainly, yeah, I think that's a fairly accurate statement. Is they were assuming that PNM would retain certain liabilities, which were not in the interest of PNM.
So turning back to the page we're looking at, in point number 4, it says, we have devised a straightforward solution. As explained in more detail below, NTEC will first acquire PNM's interest, and sometime between now and 2025, will transfer that interest to a suitable third party. Do you see that?
I do, yes.
So when the purchase and sale agreement was originally negotiated, the party's intention was that NTEC would hold PNM's interest only temporarily and then transfer it to a third party, correct?
NTEC, again, for the original agreement was PNM completing a transfer of our interest with a third party directly.
And did NTEC want PNM to transfer its interest to a third party so the third party could vote against closing Four Corners before 2031?
Again, as I stated, I was not privileged to any conversations that NTEC may or may not have had with any other third party.
But is it your testimony that you, as the lead negotiator for PNM, you did not know what NTEC's motivations and goals were?
As we've covered previously, understand NTEC's goals as they were stated to me. Their primary interest were the preservation of jobs and the preservation of revenue to the nation.
Turning back to the document we were just looking at, would you please scroll to page 257?
You said 257?
Yes, Mr. Lee.
Thank you.
Let me know when you're there, Mr. Falcon. Oh, I said, Mr. Falcon, let me know when you're on page 257.
Mr. Falgren, can you hear Mr. Gerhart?
Hearing examiner, can you hear me?
I can hear you, yes.
Okay,
And
let
I
me
can
go
hear Mr.
right-
Gerhart.
Let me go to the other room and check and see what's going on with the system. Just 1 second.
Thank you, ma'am. Thank you. Okay, well, that's happening. Mr. Elliott, are you there? Just trying to do some
Yes,
housekeeping.
Mr. Hearing Examiner.
Thank you. I had you down taking 39 minutes with Mr. Falgren, so I wanted to follow up with you on cross-examination. You reduced the time with Mr. Phillips to 10 minutes. And how do you suggest you take the rest of the reduction?
I'm in conversations with my colleague, and we're reviewing testimony now in our cross-examination.
Great. Okay, sorry. Thank you.
Yes,
Appreciate
thank you,
that.
sir.
Just trying to fill some airspace here. With
Mr. Hearing
efficient
Examiner,
time.
this is Kyle Tisdale with community groups. As long as we're still feeling, well, sorry, I see Ms. Terwilliger back, so I can hold my question. Thank you.
Thank you, sir.
They're working on getting his audio connected, Mr. Hearing examiner.
Okay, go ahead, Mr. Tisdale.
Yeah, there was some follow-up from yesterday regarding Community Exhibit 5. And I just, you had requested Ms. Terwilliger to follow up with you in the morning, and we didn't have that opportunity this morning. So I just wanted to put a flag in that we might want to circle back on Community Exhibit 5.
Yes, and I do have an update
Join the
on that.
meeting.
All right, I think
Apologize.
Mr. Falgren's back.
I apologize for our technical
All right.
difficulty.
Let's get back to the cross-examination, but thank you for bringing us back to that issue. But let's get back to the cross-examination with Mr. Gerhart. Mr. Gerhart, could you please ask your last question again? If that's not too much of a bother.
Yes, Mr. Falgren, would you please turn to page 257 of SC-1?
Yes, sir.
Thank you. So if you go to the middle of the page, an email from you to Bernard Masters dated October 12, 2020. Do you see that?
I do, yes.
Okay. And Bernard Masters is the general counsel for NTEC, is that right?
He is, yes.
So, and sorry, the subject of this email says Nation Communications. I assume that refers to the Navajo Nation. Is that accurate?
Yes, sir.
Okay. So my understanding is that in this message, you're offering your thoughts on what PNM and NTEC's messaging to the Navajo Nation should be about the purchase and sale agreement. Is that accurate?
Yes, and more directly, I think these are points probably from NTEC, and I was providing maybe some clarification comments of our input on them.
Okay. Would you turn to the next page, page 258?
Yes, sir.
So on point 3, you write, current agreement provides some assurance on continued plant operation. Do you see that?
I do, yes.
Okay. I assume current agreement refers to the purchase and sale agreement. Is that right?
It would, yes.
Okay. And continued plant operation refers to continued operation of Four Corners. Is that right?
Yes, sir.
Okay. So I'm interpreting this email as you suggesting that PNM and NTEC tell the Navajo Nation that the purchase and sale agreement will provide assurances about the continued operation of Four Corners. Is that accurate?
I would characterize it more as NTEC's message to the nation is that the provisions of the purchase sale agreement would provide some limited assurances of continued operation.
And in your email, you agreed with that message. Is that correct?
I did understand that was their messaging. I didn't object to that messaging.
Okay, just to clarify, when you say you didn't object, meaning you believed that messaging was an accurate representation of the purchase and sale agreement?
I think I can agree to that.
Okay. Yesterday, Mr. Tisdale was cross-examining you, and to paraphrase, I recall you saying something along the lines of, it was important to PNM that the Navajo Nation understand the purchase and sale agreement and its implications. Do you recall that?
Yes, sir.
Okay, so I presume that it was important to you to be candid and truthful with the Navajo Nation about the implications of the purchase and sale agreement?
Absolutely.
Okay. What I'm having trouble understanding here is, if you were telling the Navajo Nation that the purchase and sale agreement was going to reduce the risk of Four Corners closing early, why did you not include that same information in your original direct testimony?
I'm not sure I understand your question. But again, I think, yeah.
Okay.
I think I
Did
accurately represented the purchase. My fault. I'll finish if I can. And then my representative is, I think I accurately represented the purchase sale agreement in my testimony.
Sorry, I didn't mean to interrupt you, Mr. Falgren. I didn't realize you were still speaking. Let me try to rephrase. In your original direct testimony, did you tell the commission that the purchase and sale agreement was designed to provide assurance on continued operation of Four Corners?
I think we provided the purchase sale agreement in my testimony, which clearly identified the provisions in 6D, the provisions that are allow for voting were, I believe, were provided in discovery as well.
Okay. Would you turn back to page 258 and please look at point 4.
Did you say 4C?
Yes, Mr. Lee.
Thank you.
C is in cat. So this sentence states, this states, these parties understood the intent of the transfer would limit APS's potential future options on reducing unit output and or early closure, and therefore set up for a strong legal. Do you see that?
I'm sorry,
You
you
do,
broke,
yeah.
I didn't hear after legal.
Hearing examiner, this is Debria Twilliger. I'm losing about every 10th word of Mr. Gerhardt's, which, I think is important that we be able to hear his questions. I don't know if other people.
And I'm putting my hand up because I'm trying we need to try and not interrupt each other. I know you can see this in the hearing room, but you can't see it here necessarily. But yes, Mr. Gerhardt, it is breaking up every 10th word or so. That's why Mr. Lee was asking you what 1C was, because we did not hear the C, for instance. So perhaps earbuds will help.
Is that any better, Mr. Hearing Examiner?
Much better audio, yes. And I see other people nodding as well. Thank you.
I'm sorry, I wasn't able to hear you when I put the headphones on.
That was
do you
much
wanna...
better. I'm sorry. It was much better audio. Much better audio with the earbuds in.
Perhaps could I suggest maybe we take a 5-minute break and I can try to fix my end with the headphones?
Yes, we'll take 5 minutes starting now. We'll be back at 10:26. Thank you.
Thank you, sorry. Mr. Lee, are you still on?
Matt, I'm here.
Yes, sir. Can you hear me, Mr. Gerhardt? Can you hear me, Mr. Marks?
I can hear you, Mr. Lee. Matt, your problem could be bandwidth too. Your video is a little choppy, and you may need to ask permission to go to audio only. If you can hear us.
Jason, I can hear you now.
Okay. The audio is strong.
Jason, can you hear me, Jason?
We can hear you. Can you read something that's about 10, 15 seconds long to see if there's any dropouts?
Sure. So you were recommending that PNM and NTEC tell the Navajo Nation that the purchase and sale agreement would reduce the risk of Four Corners closing before 2031, correct?
That's perfect.
Yeah.
Okay, that's better?
Yes, sir.
Okay, great.
Yeah, on the record, I'll answer for Mr. Falgren.
Sorry, what was that, Jason?
I said I can answer for Mr. Falgren if Mr. Lee wants to pretend we're still on the record.
Matthew, you know that you got to ask about C again, okay? Because it didn't come through.
Okay.
Okay, great.
We'll go back to that.
Matt, when you come back, you can inform Mr. Medeiros that Catherine has gotten everything uploaded, and they're labeled SC8 through SC12.
Okay, I'll do that, Jason.
Mr. Gerhart, can you hear me?
Yes, I can hear you now, Mr. Hearing Examiner.
I'm sorry, my earbuds just went out because I went too far away from the my Mac, so I need to reconnect here. So give me a second.
Certainly.
Whew, I'm back, I think. Am I? Mr. Gerhart?
Yes, sir.
I
Yes,
can
sir.
hear you.
Okay, good.
Cannot see
know
you,
it's-
Mr. Anthony.
Okay, let me do that. Thank you,
Sorry
sir.
about that.
No, I'm sorry. So as I heard Mr. Marks indicate that, and we're back on the record, that all of the documents for which Sierra Club took administrative notice from the merger case have been uploaded. Is that correct?
Yes, that is correct, Your Honor.
Okay, thank you. Those documents obviously are admitted. And it sounds like you're going to be using your earbuds, or it looks like at least.
Yes.
And by the way, about bandwidth issues, I noticed myself that it looked like my picture was blurry as well for a little bit there. So there may be glitches in the system that's not just on your end, but just generally with Zoom. So we'll just have to bear with it. But thank you for fixing the audio. And you may proceed with your cross-examination, Mr. Faulkner.
Thank you. I'll re-ask the last question. I'll start there since I think it may not have been heard. So Mr. Fulgren, we're back on page 258 of Exhibit SC-1.
Can I stop you for a second? Let's go for about another 17 minutes. We'll take a break at 10:45 if that works for you and your cross. Otherwise, I can adjust. So just a heads up that in about 17 minutes, we should take our morning break. Does that work okay for you?
Yes, certainly.
Okay, thank you. Please proceed.
Okay. Mr. Fulgren, back on page 258, if you would please turn to point 4, C as in cat.
Yes,
I'll read that sentence again. It states, these parties understood the intent of the transfer would limit APS's potential future options on reducing unit output and or early closure, and therefore set up for a strong legal battle. Do you see that?
I do, yes.
That at one point during the negotiations, APS had objections to an agreement that would limit its future options with respect to Four Corners.
I'm sorry, you cut out on the first part of that sentence. Sorry, if you could repeat it.
Sure. My question is, the statement I just read indicates that APS was concerned about how your exit agreement might impact APS's future options regarding Four Corners, correct?
Again, I think these are NTEC's representations, so that would have been NTEC's understanding of issues. If I could clarify a little more, at the same time, we were pursuing the seasonal operation agreements as well. I think we're getting dangerously close to dispute resolutions that had occurred between the parties regarding the seasonal operation. And there were some concerns that were expressed, again, through that combination of this, really regarding seasonal operations moving forward.
Okay. Mr. Fulgren, prior to executing the purchase and sale agreement, required PNM to get NTEC's permission to vote in favor of closing Four Corners.
I'm
Is
sorry.
that correct?
You broke off after purchase and sale agreement. Prior to executing the purchase and sale agreement,
There was no contract that required PNM to get NTEC's permission to vote in favor of closing Four Corners, correct?
Nor is there any exit plan for PNM from Four Corners either.
So the purchase and sale agreement created a new restriction on PNM's ability to vote in favor of Four Corners closure without NTEC's consent. Is that right?
I wouldn't necessarily characterize it like that. I would characterize it like the purchase sale agreement provided an exit, the only available exit plan for PNM to exit Four Corners. As part of that, my obligation is to deliver the asset in the condition in which it was negotiated or executed.
Did you ever attempt to persuade NTEC to alter the material adverse effects clause so that PNM could vote in favor of closing Four Corners without getting NTEC's consent?
We certainly discussed each section of the purchase sale agreement at length. You know, and absent a material adverse effect provision in the contract, we would not have a contract.
I'm unclear as to what your answer is. Is your answer yes or no to my last question?
Material adverse effect was a critical part of the contract that NTEC would require, which is a part of any standard contract, in order to reach an agreement. It would be absurd to think that there's an asset you're transferring that I wouldn't have to deliver in a certain condition. So while we discussed it, the provisions that are there, we recognize that that was a critical part of the overall contract.
Mr. Falgren, PNM's objective in exiting was to get rid of its obligations concerning Four Corners, correct?
Our main yes, I would concur with that.
If the plant were to close on a timeline acceptable to PNM, that could accomplish PNM's objectives just as easily as a transfer, correct?
We pursued early closure of the plant to the extent we could. That option was not on the table, so we pursued this option, which allowed us an exit plan, provides our customers savings and environmental benefits.
So I guess what I'm not understanding is, you just said that altering the material effects clause would be absurd, but under circumstances where PNM could accomplish its goals through closing the plant, why would it be absurd to preserve PNM's ability to close the plant?
There's not an option for a purchase sale agreement with that provision removed. If we were going to pursue an early closure, that would have required consent by all the other owners. Those are the two paths.
Mr. Falgren, do you recall stating in your rebuttal testimony that the likelihood of the Arizona co-owners being willing to retire Four Corners prior to 2031 is low?
Can you refer me to a section, please?
Yes. Your rebuttal testimony, page 24, lines 21 through 22.
Very well. Yes, sir. I see that.
In that sentence, when you said low, did you mean that the probability is not 0, but it is not large?
I meant that I don't see a perceivable, conceivable path for that early closure in the time period that we're talking about.
When you say time period that we're talking about, what do you mean?
Again, you know, the current operation goes to 2031. My pursuit with the other owners was very clear, very direct, very contentious to see if there was any potential for an early closure. Basically, all options for early closure, in my opinion, were closed. You know, is there a 1% possibility? I'm not ruling that out, but again, you know, any conceivable path that was available, I would say, was off the table.
Whatever the possibility may have been at the time the purchase and sale agreement was executed, the probability is now 0 during the remainder of PNM's ownership, given the restrictions in the purchase and sale agreement and Amendment 21. Is that accurate?
I would disagree with that.
So you're telling me that under the purchase and sale agreement and Amendment 21, there can be a vote between now and 2025 on closing Four Corners?
It could be, yes.
And how is that?
How does the vote happen, or how is that possibility?
How is that possible under the purchase and sale agreement and Amendment 21?
I think if we look at the purchase sale agreement, TGF 2, page 45, I think it's important to look at the whole of the agreement and the whole of the words and not take the sound bites out of it if we can. So again, this section is on conduct pending closure. If you look at the words, it says, prior to consummation of the transactions contemplated herein or the termination or expiration of this agreement pursuant to its terms, and except to the extent approved by purchaser or otherwise contemplated by this agreement, sellers shall. So NTEC could agree to waive the provision for an early vote, allow that vote to occur.
Are you finished with your answer, Mr. Falgren? I don't want to interrupt you.
Yes, sir. Sir?
Yes, yes. With respect to Amendment 21, there's a provision in Amendment 21 stating that if the purchase and sale agreement terminates or is no longer in effect for whatever reason, then all of Amendment 21 automatically terminates. Is that correct?
Just to be clear, Amendment 21 is my rebuttal testimony exhibit. That exhibit. Referring to the project operating agreement, Project 21. So just for clarity for folks.
Yeah.
alone.
Yes.
That would
Yes.
be my rebuttal testimony exhibit TGF 3. And so your question was, if the purchase sale agreement, if we look at page 3 of TGF 3, entitled Conditions Subsequent to Amendments, it does say there that if the New Mexico NTEC purchase sale agreement does not occur on or before December 31st, 2024, essentially then this agreement would terminate, subject unless other amendments were made.
Okay. Thank you. Mr. Hearing Examiner, you wanted to break in 7 minutes, is that correct?
Proxy, if that works for you.
Okay, yes, it does.
7 minutes, yes.
Okay. Mr. Fulgren, I have some questions for you regarding seasonal operations. So in Amendment 21, PNM and the other owners have agreed to operate one of the Four Corners units seasonally starting in 2023. Is that right?
Yes, sir. I think that's an accurate representation.
Okay. And I believe your position is that shifting to seasonal operations will not increase costs for PNM associated with Four Corners. Is that right?
Yes, sir.
Okay. Is it fair to assume that PNM and the owners forecast that seasonal operations will either be neutral in terms of costs or will provide cost savings?
I think APS as the operating agent would represent that longer term, they would anticipate some potential cost savings. But again, our estimation, our calculations is we just assumed there were no substantial changes in the time period that we're involved in Four Corners for December 31st, 2024.
Okay. And are you, just to clarify, are you aware of evidence from any of the other co-owners suggesting that seasonal operations might increase costs for any of the Four Corners participants?
I'm not, no.
Okay. Thank you. Would you please turn back to Exhibit SC-1, page 225? Let me know when you're there.
Yes, sir.
So if you look at the bottom half of the page, you should see an email dated March 2nd, 2020 from you. Do you see that?
I do, yes.
Okay. If you go to the third paragraph, the second sentence, it says, I am confident that this early closure provision is of significant concern to NTEC, especially as they continue to expand their business model and likely leaning on the cash flow from the Four Corners mine for that expansion. Do you see that?
I do, yes.
Okay. Do you know what, well, sorry, when you said expansion, what were you referring to?
I believe at that point, I was probably referring to their purchase of additional mines.
Those are coal mines in Wyoming?
I believe that's correct, yes.
Okay. Do you know whether NTEC intends to use any portion of the $75 million payment from PNM's shareholders to fund those coal mines in Wyoming?
I do not know that.
Do you know what NTEC plans to do with that $75 million payment from PNM?
I know that they'll pay royalties on a portion of it to the nation. And I would assume it's to offset coal supply obligations that they're acquiring from PNM. A portion of them.
Is there any restriction in the purchase and sale agreement on what NTEC can do with that $75 million?
No, sir.
Okay. Mr. Hearing Examiner, I realize we're 1 minute shy, but if it'd be possible, this might be a good place in my cross-examination to take a break, if that's okay with you. Otherwise.
Of course.
Okay.
Yes, let's take a break for approximately, let's be back at 11 a.m. start. We're going to take our morning break now. And then when we get back, Mr. Gerhardt, I want to have, we're on break now. Okay, we're off the record. Obviously still on YouTube, but Mr. Gerhardt, yeah, by the way, when we're off the record, we're still live streaming. So Mr. Gerhardt, I need to follow up on where we are in terms of cross-examination time when we get back from the break. I'll look at the transcript that I have here in time, and then we'll try and figure out where we are for the remainder of your cross-examination time, okay? All right, thank you.
Great, thank you.
Thank you.
You're on mute.
Mr. Lee, is it any better now with my using the mic?
Yes, sir.
Okay, good, thank you.
You're on mute, Mr. Maderos.
Thank you, Mr. Lee. Mr. Gerhart, I have you having used approximately, and I've got an echo again, for 41 minutes of cross-examination time. We started at 10 a.m. We stopped at 10:46, according to the real-time transcript. We had 2 minutes to deal with the audio, so I'm including that because according to our the pre-hearing order and requirements, the parties are to ensure that they have appropriate audio before the hearing. But we then took a 5-minute break. So I have you at approximately, at any rate, 41 minutes, having used 41 minutes. Does that sound about right to you?
Yes.
Okay, so that would leave you with 100 minutes, not approximately 99 minutes. Well, how many minutes would that leave you with? Out of 140, about 99? Or is that about right?
Yes, that sounds right to me. Yes.
And we'll go until noon, and we'll see where we are at noon. So for about, we have 60 minutes now. Right around noon, we'll see where we are with your cross-examination. Okay?
Yes, I'm hopeful I can finish by noon. I think I'm about halfway through my cross, so
okay.
No promises, but hopefully I can finish by then.
If you can, that's great. I don't want to step on anybody's cross-examination. So let's proceed. And like I said, at approximately noon, we'll see where we are. Okay? And I'll try not to interrupt you till then. Okay, please proceed.
Yes. Mr. Falgren, would you please turn back to exhibit SC-1 to page 219 of the exhibit? Let me know when you're there.
Very well.
This is an email from you dated April 13, 2020. Is that correct?
Yes, sir.
And you were emailing a representative of APS, the operator of Four Corners, correct?
Yes, sir.
Okay. In the first paragraph, the last sentence, you write, "This is even though the fact remains that this current challenge is directly the result of PNM agreeing to support APS strategic needs by agreeing with the contract extension." Do you see that sentence?
I do, yes.
Okay. What did you mean when you said that PNM agreed to support APS's strategic needs?
Again, I think we answered these series of questions likely in discovery too, so we could reference those. maybe, but, yeah, in general, as PNM, you know, did our own analysis to extend our operations in Four Corners, that was also part of APS's strategic needs to extend Four Corners as well.
So this is referring to the contract extension when the prior coal contract expired in 2016?
Correct.
Okay. If you go down to the third paragraph, the last sentence says, PNM has always desired that the Four Corners Partnership would return to the collaborative process APS enjoyed when we all committed to support APS in the contract extension. And then it continues on. Do you see that?
I do, yes.
And is this sentence again referring to the contract extension after the coal supply agreement expired in 2016?
And again, I would say that the owners understood and did our own analysis, supported that extension, but also in accordance with, yes, in the extension for APS. And again, if I put this in context, you know, I'm trying to gain whatever leverage I can to entertain APS to be at the table to entertain an early shutdown scenario. So, of course, I will leverage what opportunity I have. But again, if we go back to the analysis, it was our conclusion that participation was in the best interest of our customers, but also best interest of APS customers as well.
So when you say you were trying to gain leverage, do you mean that you were trying to get APS to support early closure of Four Corners by pointing out that PNM had supported APS in extending the coal contract?
I'm trying to gain leverage to say that, yes, as we all agreed that it was in our best interest of our customers to extend the coal contract, that we recognize that obviously APS being the majority owner probably had a bigger stake. So again, I'm not conceding that we didn't do our own analysis. I'm just trying to point out to APS that that was a critical need of theirs. Our analysis that proved it was beneficial for our customers to continue was in alignment with their strategic needs as well.
Thank you. So back in SC-1, would you turn to page 226, please?
Yes, sir.
So this should be an email from that same APS representative, but from him to you. Do you see that?
Yes, sir.
Okay. So in this email, the APS representative is recounting his understanding of a conversation you had with him. Is that right?
I can't speak to, he makes some statements there. I can't infer what the basis of his statements are, but what he says is that's his understanding.
He first sent you this email, you had
Sorry,
spoken
you broke
with
up.
him.
You broke up. Start again, please.
Sorry, Mr. Lee. My question is, the context for this email is that prior to this message, you and the APS representative had a conversation, correct?
I had many conversations with Mr. Fletcher before March of 2020.
Okay. So if you look down at the second bullet point, it says you have an abandonment filing on 4C you'd like to make, preferably before a general rate case filing, presently scheduled to be dropped around May 1st. Do you see that?
I do, yes.
So what had you told the APS representative that gave him that idea?
Honestly, I don't know how he formed that opinion. I think there are a number of things. I think you asked, one is that was not PNM's position. I think you asked the Mark Fenton, who's the executive director of regulatory, that very question, you know, what was our strategy? It was not a strategy to delay. We had a rate case that was due to file in middle of 2020 that got removed only because of COVID. I think Sierra Club has asked this question really in discovery twice, I believe in your 4th set and your 10th set, in which PNM identified that who are the primary decision makers for rate cases. We identified that the public policy area was Ron Darnell, and I believe in the merger case, Mr. Marks cross-examined Mr. Darnell on that, and Ron testified that was not our strategy. So first, I'm not sure where the misunderstanding occurred, because that was not our strategy. Second, as I would look at it, is just the mechanics of that. You know, it's not a conceivable scenario, I would say. Only because if you look at our process for doing amendment filing, you know, it took us almost 4 months just to get the Board of Finance approval. And at this stage, as you can see, we haven't even identified what options we're even talking about, if you would. You know, what I can remember communicating to Mr. Fletcher is that, you know, as part of the 2020 IRP filing, which I probably characterized as a general rate case obligation filing, that we had a filing that we needed to file in the summer of 2020 as part of the 2020 IRP. Beyond that, I can't speak to what I would recall on why he would form that opinion.
Mr. Fulgren, the email we're looking at is dated Monday, March 2nd, 2020 at 7:16 a.m. Do you see that?
I do, yes.
Can you spell Fletcher?
Certainly, it's F as in Frank, ROETSCHER.
Thank you.
So, Mr. Fulgren, if you scroll up to the prior page, page 225, at the bottom, there's a message from you to Mr. Fletcher on that same date at 8:41 a.m. Do you see that?
Yes, sir.
Okay. So that message you sent at 8:41 a.m. is responding directly to the message we were just discussing, correct?
Could likely be.
Okay. So in your response to Mr. Fletcher, I don't see any place where you told Mr. Fletcher that he had misunderstood you about when PNM wanted to file its abandonment case. Am I missing something?
I don't believe that's in there, no.
So my
Again,
question is sorry, go ahead, please.
And again, I don't think, his understandings, and again, there was somewhat of a contentious relationship between APS and PNM at this time. When I look at his message to me, the critical points that I'm looking forward is moving forward with an agreement, moving forward in the issue. I probably just blew by what he said there. I don't understand what his impressions were, but the emphasis I was looking for is, hey, how are we going to move forward with the discussion? If the intent was that these would be in discovery later, I mean, that's never the intent, right? So it's not like, well, I'm trying to preserve my legal position in discovery. It's, hey, he made some statements. He gave me an opening, I think, and here are some possible options. I focused in on the possible options. Move forward.
Thank you. Would you please turn to the very bottom of page 226? There's the header of an email from you. It should be dated Saturday, February 29, 2020. Do you see that?
I do, yeah.
Okay. So this is an email from you to the same Mr. Fletcher, correct?
Yes, sir.
Okay. Could you turn to the next page where that email continues?
Yes, sir.
So in the second sentence, you say, PNM's timeline is very tight, so my leadership will be asking for an update early Monday. And then it continues. Do you see that?
I do, yes.
Okay. When you say PNM's timeline, is that referring to PNM's timeline for exiting Four Corners or for something else?
That's to completing my pursuit of an exit for Four Corners.
So who at PNM was telling you that the timeline for exiting Four Corners was very tight?
Again, if you look at the context of these are my attempts to negotiate and try to convince and bring APS to the table as well as the other parties. The timeline and the time of essence, the timeline, those are really my direction. Those are my statements. And again, it's just my own need. Again, I was looking at a 2020 IRP filing that was originally going to occur in July 2020 that subsequently got deferred till January of 2021. And then really, if I'm honest, is just a bit of frustration on my part that, I've been dealing with this issue at this point for probably over 2 years, and and really the lack of engagement by some of the other parties. So I'd characterize those statements more in line with that rather than, hey, somebody's given me a directive.
Okay, thank you. Mr. Fulgren, PNM's 2017 IRP recommended that PNM remain a participant in Four Corners until the coal supply agreement expires in 2031. Is that correct?
The 2017 IRP included Four Corners to 2031 as the most cost-effective scenario, and the 2017 was accepted by the commission, yes.
Okay. And in 2019, in the San Juan replacement filing, all of PNM's scenarios assumed that Four Corners was retained until 2031. Is that right?
Subject to check. I wouldn't deny that, but that I'd have to be subject to check.
Okay. But so subject to check, as recent as 2019, PNM was still planning on owning Four Corners until 2031, right?
Where are you getting the 2019 date from again?
Sure. The replacement filing for San Juan was filed in 2019, I believe.
Certainly, yeah, and there at the time, whatever the date was, at the time of the San Juan filing, is we did not yet have a credible exit scenario for Four Corners. So I would agree that that's probably correct.
Okay, so PNM's views on how long it should remain an owner of Four Corners, PNM's view has changed in the span of a few years. Is that right?
I would say that when we run the modeling for Four Corners, in 2008, it showed continued operation. In 2011, if you look at the IRPs, if you look at 14, if you look at 17, those IRPs clearly showed most cost-effective portfolio. As we saw this unique opportunity with NTEC for an early exit, yes, I think then our opportunities are to make use of that unique opportunity for an earlier exit than we had planned previously.
Okay. So the reason that PNM files IRP updates regularly is to be able to assess changes in various factors such as pricing changes, technology changes, regulatory changes. Would you agree with that characterization?
I think so, yeah.
Okay.
It's a planning tool to look at the current state the next 20 years, yeah.
Let's imagine that 3.5 years ago, PNM had said that it was not going to revisit its ownership of Four Corners. In your view, PNM would have then missed out on an opportunity to take advantage of changing conditions concerning Four Corners. Is that accurate?
I don't know. I don't know if I agree with that completely. I think a continual evaluation of Four Corners has developed a unique opportunity. Maybe I would phrase it that way.
Okay. I have a few questions about PNM's obligations after the 2016 rate case that you've referenced a few times. Is it your understanding that PNM was instructed to analyze exit of Four Corners in 2024 and 2028?
I believe I included that provision in my testimony at some location, but yeah, to perform an analysis, financial analysis of an exit in 2024 and 2028, I think generally, subject to check.
have you presented a financial analysis of exiting in 2028 in this case?
We have not in this case, no.
Is there some other case in which you've presented a 2028 exit analysis?
I think those requirements were to file that in the 2020 IRP, and I think if you reference the 2020 IRP, Mr. Phillips talks about that. Again, what we identified is there in 2024, we found a credible exit plan. In 2028, there was not a credible exit plan. And taking the early of the two dates, we would infer was probably the preference of the commission, since the earlier dates were where we actually had an agreement, a potential exit plan.
In the first half of 2020, did you ever speak with Mr. Eldred about potential Four Corners exit options?
Certainly, Chuck, Mr. Eldridge is a part of our executive team, so I would discuss where I was potentially on the path of my options for Four Corners. So he would have been one of the individuals I would have talked to, sure.
Okay, thank you. I have some questions about the $75 million shareholder payment to NTEC under the purchase and sale agreement. So my first question is, who proposed that payment? Did NTEC suggest it initially, or did PNM?
That's a good question. I don't know exactly who identified the issue up front. I know there was quite a bit back and forth around that discussion. And again, I think, it's centered around the future liabilities, maybe parties' independent evaluation of what those future liabilities costs may be. So I think, I mean, honestly, I don't know. I know the conversation was between myself and Clark Mosley, but I don't know if Clark brought it up or I brought it up first. Apologize for that.
No, thank you. So you may have just touched on this, but my next question is, how was that $75 million figure arrived at? And what I mean by that is, how did the parties settle on $75 million as opposed to some other number?
It was just an arm's length negotiation. We didn't have a spreadsheet that we did or whatever. They looked at their side, I looked at our side. That number ranged quite largely, I would say, but it was an arm's length negotiation number.
Okay. I next want to ask you some questions about the recommended decision in APS's pending rate case. So APS has a roughly 2/3 ownership interest in Four Corners. Is that right?
I believe they got a 63% ownership share.
So APS is the largest owner of Four Corners in terms of percentage ownership shares?
APS is, yes.
And APS is also the operator, right?
APS is the operating agent, yes.
So would you agree that as the majority owner and the operator, APS has a large influence over what happens at Four Corners?
Depends. I would not. They certainly have a vote. I think it would be it would probably depend on the topic that you're talking about. I could give maybe a little more color if you would. Certainly when we're talking about capital expenditures,
Please.
certainly when we're talking about capital expenditures, you know, I believe it's a 75% vote. If APS has already got 63% of the vote, obviously they carry a big weight in capital expenditures, if you would. If you're talking about contract terms, you know, modification of the contract, those are unanimous votes. And so then really their ownership share really has little influence on contract provision changes, if you would.
So subject to check, the recommended decision in APS's rate case was issued on August 2nd of this year, correct?
Subject to check.
Okay. And that date is after the date on which the purchase and sale agreement was signed, right?
Purchase and sale agreement was signed on November 1st, 2020.
Okay. And when the recommended decision came out, that was also after Amendment 21 had been signed earlier this summer, correct?
Amendment 21 was signed on June 25th, 2021.
Okay, so APS and the other Four Corners owners weren't able to consider that recommended decision when they were reviewing the purchase and sale agreement or Amendment 21, right?
I can't speculate on what their assessment or risk assessment was, or what they made their decision to sign an agreement on. Better be referred to them.
In your experience, does PNM consider the likelihood of future cost recovery when it evaluates its plans for an asset?
You know, and again, in our discovery responses from Sierra Club, it seems to have made that inference. I take a bit of umbrage to that line of thinking, is that it seems to be a line of thinking that if you punish the utility enough, they'll change the math. The math is always about benefits to customers. And the fact that if we punish the utility enough, that the math changes, I mean, that just really, I take a bit of umbrage to that line of thinking, honestly.
So, Mr. Falgren, your position is that PNM does not consider in any way the likelihood of future cost recovery when it decides on what to do with an asset?
My position is when I have to represent to the commission what's the best path forward for our customers, that math does not change based on what the recovery is. I have to represent what's in the best interest of customers. And that's the burden of proof I have with the commission. Suggest that if you punish the utility, that changed the math, again, that's just upsetting.
So one more question on this. Is it your position that the executives at PNM do not consider cost recovery possibilities when they're evaluating PNM's options?
Again, our representation to the commission, whether it's me or it's my executives, is the interest of the customer. I can't change the math just because somebody wants to penalize the utility. That's my statement.
Would you please turn to Exhibit SC-5?
Mr. Gerhart, would you please identify the exhibit while the witness is looking for it?
Mr. Falgren, on page 5 of this exhibit, there should be your response to interrogatory SC 10-27. Do you see that?
Yes, sir.
Okay. And this is a discovery response that you sponsored?
Yes, sir.
Okay. So you've seen this discovery response before?
I wrote it, so yes.
Okay. Would you please turn to the next page of the exhibit, which is page 6?
Sir.
So in the last sentence of that response, you state, in addition, a disallowance of the SCRs in APS rates would make Four Corners more beneficial to APS customers if customers were not subject to continuing cost recovery for the SCRs. Do you see that?
I do, yes.
Okay. So you're arguing that APS customers would benefit from a disallowance of APS's Four Corners costs. Is that a correct understanding of your response?
What I infer from the question is you're asking me if recommended order would change. Sorry, give me a second to reread it, if it would.
Of course, please.
Yeah, I guess I'm inferring from other questions that were asked in here is that since you're inferring that since there was a potential disallowance of the SCRs, that APS has now changed their opinion. Again, I go back to the previous statement is, you know, they don't get to change the math. PNM doesn't get to change the math for a disallowance, and you know, APS doesn't get to change the math or fudge the math. So if there's less cost associated with the customer's pay, then yes, you know, by disallowing the cost of the SCRs in the APS case, you may have just inadvertently extended the life of Four Corners.
So are you saying that in general, disallowances benefit the utilities customers?
I think there's except until the extent that it hurts the utility, which I think is detrimental to the customers as well.
Okay. So I'm going to move on to a different topic. At any time prior to executing the purchase and sale agreement, PNM state publicly that it would support closing Four Corners before 2031?
You cut off there a little bit. I believe your question was, if any time prior to signing the purchase sale agreement, did we make public statements? The answer to that's yes. We answered an interrogatory that provided those correspondence.
So when did PNM publicly state it supported early closure of Four Corners prior to executing the purchase and sale agreement?
I think you would have to, we would need to find that interrogatory to provide a complete answer. I believe the first potential release was Soon after the San Juan decision was issued, in which we stated that we would then look for potential opportunities if it was beneficial for customers. So I don't know if that was maybe early 2020 time period, again, subject to check, but if we could find that interrogatory, I think that would be a better evidence.
That press release you're just referring to didn't make any specific mention of supporting early closure, did it?
We'd have to look at it. I think it was generally PNM seeking an exit. I'd have to refer to the response. Not sure exactly what it said.
Okay. At any time prior to executing the purchase and sale agreement, did PNM inform the Arizona Corporation Commission that it would support closing Four Corners before 2031?
Not to be coy, but I think Sierra Club did that for us. I think my testimony in this case was offered in the APS rate case. But we did not initiate that discussion with the Arizona Corporation Commission directly.
Well, Mr. Falgren, with all due respect, I don't think you've answered my question because you couldn't have submitted testimony in this case before you finalized the purchase and sale agreement, correct?
I believe my supplemental testimony, I believe my direct testimony was entered into the APS rate case.
Your supplemental testimony in this case was
Direct.
issued at.
Sorry, my direct testimony was issued. I think I was trying to say my direct testimony in this case was issued into the APS rate case as an exhibit. If I believe correctly, from the Sierra Club.
And that occurred after you signed the purchase and sale agreement, correct?
It did, yes.
Okay. So I'm asking about before you executed the purchase and sale agreement. Before that date, had PNM ever told anyone in the Arizona Corporation Commission that PNM would support closing Four Corners before 2031?
We did not have direct communications with the Arizona Corporation Commission. We pursued our early exits via the contract provisions that were provided in the contract.
Prior to executing the purchase and sale agreement, did you ever submit comments in any APS proceeding stating that PNM would be willing to close Four Corners before 2031?
No, sir.
Okay. I have some questions about NTEC that follow up on questions Mr. Tisdale had for you yesterday. So NTEC doesn't need prior authorization from the Navajo Nation for its day-to-day business decisions, correct?
It'd be my understanding that the management committee operates much like a board of directors that establishes the day-to-day operations of the facilities. The Navajo Nation is a shareholder, the single shareholder of NTEC. However, the management committee would have a fiduciary responsibility, obviously, as the board of directors act in the best interest of their shareholder, which is the Navajo Nation.
Entech is headquartered in Colorado, is that right?
I believe their headquarters has moved to Colorado. It used to be in Farmington, I believe.
Okay. You told Mr. Tisdale yesterday that the three main Entech contacts for the purchase and sale agreement were Clark Mosley, Henry Tipton, and Bernard Masters. Is that right?
Yes, sir.
Okay. The executives are not members of the Navajo Nation, correct?
You cut out, I'm sorry.
Those three Entech executives are not members of the Navajo Nation, correct?
I'm not aware of their membership or not.
Most of Entech's executives have professional backgrounds in the coal industry, correct?
I certainly know that Clark Mosley and Harry Tipton have experience in the coal industry.
Most of Entech's business is in mining coal. Is that right?
They have some, you know, if we look at Entech, Entech stands for Navajo Transitional Energy Corporation. I think Entech has an obligation in their original structure to transition the nation to a more sustainable energy. I know they have made substantial efforts in there. They have secured a lithium mine, you know, in support of future battery developments in the area. They have worked hard trying to present renewable projects on the nation. I'm not sure of their success to this point, but I know they have extended a tremendous amount of effort to try to execute some renewables on the Navajo Nation, as well as again their mines, their coal mines that provide probably the majority of their revenues at the moment. But
So you would agree that the majority of Entech's revenues come from coal mining, correct?
I would concede that today. Today that's probably accurate.
Okay. So you were aware that in 2019,
I'm sorry, you
Entech
broke up.
purchased several.
I'm sorry, you broke up before you started. Can you start again, please?
Mr. Falgren, we discussed before that you're aware that in 2019, Entech purchased several Wyoming coal mines, correct?
Yeah, subject to check on the dates, but generally, yes.
Okay. Are you aware that the Navajo Nation president publicly criticized that Entech purchase?
I am aware of that, yes.
Okay. Are you also aware that the Navajo Nation?
Let me clarify that.
Oh, sorry.
Whoa. My fault. That's my fault. That one. I'm sorry. If I could finish that answer and correct it if I could. I'm sorry, Mr. Hurd. I understand maybe not the transaction, but certainly the communications that may have occurred prior to the transaction would be a better clarification of, I think, the frustration of the nation in regards to that purchase as I understand it. If you allow me to continue as you're preparing the next question, is that was actually a key consideration, that frustration of the communication, which led both of NTEC and PNM ensuring that we kept the nation completely informed and had their complete support moving forward with the NTEC PNM purchase sale agreement. And I'll stop there.
Mr. Falgren, would you turn back to Exhibit SC-5?
Well,
Could you take a minute and look through this exhibit to confirm whether all of these responses are responses that you authored?
yes, appear to be.
Okay, so just to confirm, SC-5 contains PNM's discovery responses that you authored, and you've seen these responses before?
Yes, some of them are co-sponsored, obviously, but yes, that clarification.
Okay. Mr. Hearing Examiner, I would move the admission of Exhibit SC-5, which contains discovery responses that Mr. Falgren sponsored.
Any objection to the admission of SC-5?
No, Hearing Examiner.
Thank you. Hearing no objection, SC-5 is admitted. And Mr. Lee, the earlier exhibits, I wanted to make clear that were admitted are SC-8, SC-9, SC-10, SC-11, and SC-12. Those are the exhibits regarding the taking administrative notice of the merger case docket. Is that correct, Mr. Gerhardt?
Yes, Mr. Medeiros.
Okay, thank you. SC-5 is admitted.
Mr. Medeiros, I apologize for the presence of two Sierra Club attorneys at once, but to clarify, we uploaded two versions of 8, one of which excludes the disputed pages. And so, Mr. Medeiros, I would ask that the record, until you rule on Ms. Nanasi's additional request, that the record be clear that the admitted exhibit is SC-8, excluding disputed pages.
Very good. Thank you, Mr. Marks. It's when the exception is a good thing. I'm glad you were on. So SC-8 excluding the disputed part, which we will take up later. Thank you. Please proceed, Mr. Gerhardt.
Thank you. Mr. Falgren, could you pull up Exhibit SC-7? Let me know when you're there.
Oh, that's in here. Sorry. Okay. My apologies. Yes, sir.
Okay. Would you take a moment and read through the exhibit to confirm that this contains discovery responses, supplemental discovery responses that you sponsored?
Yes, sir. This just appears to be some of the supplemental responses to that are the same interrogatories as in SC-5. So, yes, I can confirm that. I provided at least in part,
Okay.
these responses.
Okay. Mr. Hearing Examiner, I would move the admission of Exhibit SC-7, which contains certain supplemental PNM responses that Mr. Falgren authored.
Objection to admission of SC7.
No objection, hearing examiner.
SC7 is admitted. Thank you.
Mr. Medeiros, I have a request, which is I think I'm very close to being done. If it would be possible to break a few minutes early during the lunch break, I can go through my notes, and I think I would have no more than 5 minutes of cross left after the lunch break, if that would be possible.
Yes, so let's break for lunch now and come back at 12:55 or so, right around 12:55, because we're breaking now at about 12:56. So, excuse me, 11:56. So we'll come back at 12:56. Thank you all. Have a good lunch break.
Thank you.
I'm gonna eat the rest from yesterday. Mom's right on top of me. No, I think I'm good.
I said 12:56, so we've got about a minute and a half, excuse me. All right. We're back on the record after the lunch break. Good afternoon, all. Mr. Gerhart, have you had a chance to look over your cross-examination and how much more you may have, if any, with Mr. Falk?
Mr. Hearing Examiner, I have exactly 6 questions left, so hopefully it will not take much time.
Okay. You ready to go, Mr. Falgren?
Yes, sir.
All right. Please proceed, Mr. Gerhart.
Thank you, and I appreciate, Mr. Falgren, you answering all of my questions.
Again, Mr. Gerhart, you're breaking up. And the echo that we hear on occasion, we heard yesterday from PNM and that we've heard today, and then this glitch, it's paramount for the court reporter to be able to take an accurate record of the case. And that's why I keep emphasizing that we need to get the audio stuff straight, okay? Are we all on the same page on that? Mr. Gerhart?
Yes.
Okay, thank you.
Mr. Falgren, I have one question back on the $75 million shareholder payment. When did you first learn that PNM executives would authorize and approve a $75 million shareholder payment to NTEC?
I believe I was asked that question already, was I not? I don't know if it was from you. I think that was sometime in 2020. I don't recall the date. Second quarter 2020, maybe. I don't recall the exact date.
Thank you. I have a question regarding your conversations with Mr. Eldred. Did Mr. Eldred ever tell you that a Four Corners exit agreement needed to be done urgently or on any kind of specific timeline?
No, the timeline was driven by me.
My last questions are about the conversations you had with Rainbow and Guzman about potentially transferring PNM's interest to them. Did Rainbow and Guzman express the same interest in continued Four Corners operations that NTEC expressed?
Yeah, I believe if, and maybe to cut to the chase, if there was a material adverse effect where I wouldn't vote for an early closure, that was in the initial discussions with both of those entities as well.
You said that Rainbow and Guzman had asked PNM to assume liabilities that PNM didn't want to assume. Do you recall our discussion about that?
I do, yes.
Okay. My question is, what specific liabilities were they asking PNM to assume that PNM is not assuming in the current purchase and sale agreement?
I believe it had to do with some of the coal supply agreement and also, well, let me say, in general, it would have been continuing environmental liabilities. That's what I remember is continuing environmental liabilities, and really a full release, I think, on those.
Early full release?
A full release on environmental liabilities.
Did PNM ever try to quantify the cost of assuming those liabilities?
I don't know that we came up with a dollar amount. I think we recognize that wasn't in the interest of the deal we were willing to pursue. I think there is also at least one of the parties was looking for a parental guarantee from PNM for continued obligations at Four Corners, which obviously wasn't in our interest of a clean exit from Four Corners.
When you were talking with Rainbow and Guzman, what closing date was considered in those conversations? Was it the same end of 2024 closing date or a different closing date?
Yes. Yeah. Again, I think the as I represented in my testimony, the 2024 date was really primarily driven by myself, based on the previous 2016 order and allowing time, again, for the process to move forward in a non-expedited basis. So generally that was discussion. I would say we generally had discussions around some potential other dates with all the parties, but again, the only serious discussions we had where parties were willing to entertain an active dialogue was around the 2024 date.
So just to clarify, were any of the potential closing dates you talked to parties about, were they prior to end of 2024?
I think there was some variation on either side to a slight degree. Again, generally 2024 was the date.
Okay. Thank you, Mr. Falgren. I appreciate your answering all of my questions, and thank you, Mr. Hearing Examiner. I have no further questions.
Thank you, sir. Thank you, Mr. Gerhardt. Ms. Beatles, are you ready for cross-examination of Mr. Falgren?
Yes, thank you, Mr. Hearing Examiner. Good afternoon, Mr. Falgren.
And you still have 25 minutes, correct?
Uh-oh, I
Sorry.
hear an echo. I hope it's not on my end.
No, it may have been me, because I asked whether you still had 25 minutes with the witness. Is that correct?
Yes, and I may take all of it.
That's fine. My apologies for interrupting. Go ahead. 25 starting now.
Good afternoon again, Mr. Falgren. Oh, I hear that echo. Is everyone else hearing it? No, okay. Maybe I won't speak so loudly. So yesterday, I believe you testified to this, and I just want to make sure that my understanding is accurate. The seasonal operations agreement is subject to PRC approval of PNM sale to NTEC. Is that correct?
Yeah, if I could maybe answer the question so that the seasonal operation has a condition subsequent, which is the NMPRC approval of the purchase sale agreement. I think I answered the same question. But I just I didn't want to confuse. I don't think the seasonal operation is subject to commission approval required. I just wanted to clarify that yes, the purchase sale agreement, which obviously is subject to commission approval, is a condition subsequent of the seasonal operation agreements.
So approval needs to be obtained, and I am looking at Amendment 21 to the Four Corners Project Operating Agreement. It's your rebuttal exhibit TGF-3. I'm looking at page 3, section 3, small case A. It states that the parties recognize and agree.
I'm sorry, just a minute. Yeah, I'm looking at
PNM rebuttal exhibit TGF-3, page 3 of 49, section 3, lowercase a.
Thank you.
And Mr. Falgren, section 3 lists the conditions subsequent, correct?
Yes, ma'am.
And it states that the continued effectiveness of this amendment shall be subject to the closing of the New Mexico-NTEC PSA on or about December 31st, 2024.
Yes, ma'am.
So in order, I'm just going to walk through the steps and I'm going to ask you to confirm. So in order to close the NTEC PSA, you need to get PRC approval, correct?
Yes, ma'am.
And that's part of what you're seeking in this case, is that right?
Yes, ma'am.
And if you don't get that or are otherwise unable to close the NTEC PSA on or before December 31st, 2024, the seasonal operations agreement is no longer in effect?
Yeah, there's provisions there in the rest of that paragraph that talk about that. Essentially there is a meet and confer, if you would. Parties get back together. But if we don't reach an agreement within, I believe it's 120 days, then the agreement terminates and reverts back. I'll represent to the group that, our discussions with the other owners, the 5 participants in this agreement, we would all recognize that we don't see a path forward if the PSA is not approved. Contractually, there is a meet and confer time. I just want to make sure I represent that.
Okay, so contractually there's a meet and confer time, and what you just described is speculation, right? Like you said what the parties would probably,
I said, but our understanding is the parties.
Were you offering opinion on what the parties would probably agree to?
I don't believe that's what I said. I said the understanding and discussion we had, actual participation, not speculation, the actual conversations we've had with the 5 parties, is that we did not see a path forward without the purchase sale agreement approval.
And I'm sorry for that crosstalk, but that was helpful. So you and next topic, I'm also getting a little distracted because there's a little echo on my end, and please alert me if it's a problem. for others. You and Mr. Fenton also repeatedly refer to your application requesting abandonment securitization, but not replacement, as a bifurcated approach that is consistent with commission precedent. So could you please confirm that that is based on the way the commission handled the San Juan abandonment case?
Again, I mean, if you could point me to my testimony where I say that specifically, it might help me.
Well, I am referring to testimony that you have provided in response to cross-examination where you describe this as a bifurcated approach. Do you not recall your using that reference?
Yes, I thought you were referencing, my apologies, I thought you were referencing my testimony when you referred to that. Yes, I think, you know, as we saw in the San Juan case, we did file the replacement resources together. The commission chose to bifurcate those. And then I think what we've seen recently as well, another example is in the Palo Verde lease abandonment and replacement resource case, is the commission has also chose to bifurcate that case as well for replacement resources.
Mm-hmm. So those two cases are the only precedent that you could be referring to, is that right?
You know, those are the recent cases that I'm familiar with.
Okay.
And they are our two most recent abandonment cases.
In the San Juan case is the filing that was brought under the Energy Transition Act, correct?
Correct. Yes, correct.
And the ETA provides that the utility or the commission may defer applications for needed approvals for new resources to a separate proceeding, provided that the application identifies adequate potential new resources sufficient to provide reasonable and proper service to retail customers. Is that right?
Mr. Medeiros, this is Mr. Marks for Sierra Club. This strikes me as friendly cross-examination.
Beatles?
That wasn't my intent. I am going to try to make the point that when the commission had to decide the San Juan abandonment and financing matter, that it also had pending before it specific projects for approval.
I withdraw my objection, Mr. Medeiros.
Thank you, Mr. Marks.
So you are aware of my ultimate question now, Mr. Falgren. So if you agree with that, we can move on. Is it the case that when the commission was acting on PNM's application for approval of San Juan abandonment securitization, it also had pending before it specific replacement projects for approval?
If we recall that case, PNM had proposed a number of scenarios and we had a recommended scenario, but the case was bifurcated. Ultimately, PNM's preferred scenario was not selected, and so therefore the ultimate selection of the replacement resources occurred sometime after the abandonment order was issued.
The replacement hearings occurred from January 22nd to 31st, 2020. Is that right?
I don't remember the exact dates, but we had a bifurcated case, and again, the ultimate resource approvals for San Juan occurred sometime after the abandonment proceeding concluded.
Do you have any reason to doubt that the hearings in the replacement docket occurred in January 2020?
I don't.
Okay, and would you agree, or do you, let me see, would you accept, subject to check, that the commission issued its final orders in the abandonment and financing docket on April 1st, 2020?
But it didn't approve that, but it did not approve the replacement resources until after that.
But would you accept, subject to check, that the financing and securitization orders were issued on April 1st, 2020?
Subject to check?
Yes, and that the Part 1 replacement order was issued on April 29th, 2020?
I don't recall that date.
Would you accept that, subject to check?
Accept that subject to check?
And would you accept, subject to check, that the Part 2 replacement order was issued on July 16th, 2020?
Subject to check.
Okay, so by the time the commission issued its final order in the abandonment and financing portions of, on PNM's, on the abandonment and financing portions of PNM's application, the replacement hearings had already occurred, correct?
Subject to check, but no,
Okay.
but no final decision was made.
Okay. I want to ask you quickly about the obligation in the 2016 rate case to perform an analysis of continued operation of Four Corners for PNM. And that requirement was in the stipulation, is that correct?
That's my understanding.
Have you ever read the stipulation in the 2016 rate case?
I've read parts of it at different times. Obviously, I reviewed that section of it. And again, I think I speak to that in my direct testimony, starting on page 10 and 11. So I've reproduced that section of that stipulation on page 11 of my direct testimony.
So by entering into that stipulation, PNM agreed to and accepted that requirement, right?
Again, I wasn't part of the 2016 rate case. I understood that as part of the final order.
Will you understand the significance and effect of PNM signing on to a stipulation, right?
I'm not sure how to answer that question. I understand how the process works. I understand this provision was provided in the final order.
And do you understand that PNM signed on to the stipulation?
Generally, that's my understanding, yeah.
Okay. And do you understand that by signing on to the stipulation, PNM agreed to accept and abide by the provisions in it?
Objection. Hearing examiner, I believe this is the second time Ms. Beatles has asked this question.
Overruled. Ms. Falgren?
Yes, sir. I understand the concept of a stipulated agreement. I understand the concept of the final order.
So my question is, do you understand that by signing on to this stipulation, PNM agreed to accept and abide by its provisions?
Objection. Hearing examiner. This is the third time Ms. Beatles has asked the question now.
Mr. Hearing Examiner, he's not responding.
Please answer the question, Ms. Falgren.
Yes, I understand the obligations of signing on to a stipulated agreement.
And my next question is simply that the requirement to perform a cost benefit analysis on the impact of an early exit from Four Corners as of 2024 and 2028 was for purposes of its 2020 IRP. Is that right?
That's my understanding, yes.
PNM was not required to pursue an exit from Four Corners. Is that right?
I'll let the stipulated language, the final order language speak for itself. It says perform a cost benefit analysis was the obligation. Did not require an exit.
Five minutes, Ms. Beatles.
Oh, thank you. So you have repeatedly referred to the benefits to the ratepayers of an early exit from Four Corners, but there are benefits to the company, right?
If you would explain further.
Well, aren't there benefits that inure to the benefit of the company separately from the benefits of savings that ratepayers should enjoy?
If you could articulate, I think in the examination of Ms. Nanasi, I think we talked about certainly that PNM as a utility has been pursuing ESG goals, and our early exit of Four Corners obviously is in alignment with our strategic direction for those ESG goals. But I'm not sure I understand the question.
Well, you answered it, so your understanding is accurate. Would another benefit be, and maybe you answered this in response to Ms. Nanasi, but would another benefit be the avoidance of further prudence disallowance?
I don't agree with that characterization, no.
That wouldn't be a benefit to the company?
Again, it's not my area of expertise. That's not what my testimony represents. If you're asking my opinion, I do not believe that. I believe the Energy Transition Act was enacted between, since the last rate case. This case is a filing under the Energy Transition Act. I don't believe my testimony covers any of those particular topics.
I'm just going to go on since I have just like a minute or two. You were answering some questions from Mr. Elliott for the AG's office, and I think that he attempted to ask this question, but we didn't quite get a solid answer. Who has the authority at PNM to release the pre-funding, the 25% pre-funding of just transition assistance, even though the appeal is still pending?
I don't know the answer to that question. Again, it's a legal dispute. That would be a combination of probably individuals discussing that. But again, it's pending the resolution of a legal dispute.
Yeah, you've established that earlier on questions from Mr. Elliott. What I'm asking you is who, either the office or the individual, has the authority at PNM to release the 25% pre-funding of just transition assistance, although that appeal is still pending?
Objection, asked and answered.
Dahlgren, go ahead.
I don't know the specific individual. Obviously, it would probably be a discussion that would occur at what we would call our EPC level. I don't know the particular officer that would make the final decision.
Would Mr. Eldred have that authority?
I don't know that Mr. Eldred is no longer in the CFO position, so I don't know that. I would not care to infer that he is the decision maker in that case. I don't know the particular officer that would have the final decision.
Would Mr. Terry?
I do not know the officer that would have the final decision.
Okay, and you also said that you were upset about with the thinking that if you punish the utility, you change the math. And setting aside context in which you made those comments in earlier cross-examination, you're not suggesting, are you, that customers should pay for the cost of imprudent utility decisions, right?
I'm not sure how you got that from my conversation.
But that's not what you're suggesting, right?
That's not what I'm suggesting.
Okay, and you would agree that there must be restraint with respect to the cost of investments that utilities can pass through to ratepayers, right?
I generally understand the prudence review process.
Mhm. Okay, I have no further questions. Thank you.
Thank you, Ms. Beatles. Mr. Harris? For the Water Utility Authority? Do you have any cross-examination for Mr. Falgren? And if so, how much? Mr. Harris? I've asked that Mr. Harris unmute himself.
Oh, excuse me. Mr. Hearing Examiner, I have probably about 20 minutes of questions. The question I have of you is, if I only take 20 minutes, can I take the extra 10 and apply it to a subsequent witness?
Yes, you may.
Okay, then I'll reserve 20.
Okay, thank you.
Good afternoon, Mr. Falgren.
Good afternoon, sir.
And I have some general questions. I think you can probably.
Mr. Harris,
Yes,
I haven't started the clock, but you just can't do a general reservation. At some point before the end of the day, could you give me an idea about where you want to move that time?
Yes, I can tell you right now, I'd like to move the extra 10 minutes to Mr. Phillips.
To Phillips. Okay,
That's
so that's 15 with Phillips.
Correct.
It's much cleaner this way.
Okay.
Yeah, and so you have 20 with Mr. Falgren starting now. Thank you, sir.
Okay. Again, good afternoon, Mr. Falgren. I have some general questions regarding what you have testified to as baseload capacity generation. And it's my recollection, well, your testimony states that the Four Corners Power Plant is baseload resource providing firm power. That's correct?
I might have used the word traditionally referred to as baseload power, but yes, generally I agree with that statement.
Okay. And you were asked some questions yesterday regarding the San Juan units and the Palo Verde units and whether those were also baseload. Is that correct?
I remember answering those questions, yes.
And they are baseload.
What I'd term is traditionally baseload, yes.
Okay. And the amount of capacity that PNM has either gotten approval to abandon at the Four Corners, not the Four Corners, but the San Juan is 497 megawatts. They're requesting approval for abandonment of 114 megawatts of leased capacity at Palo Verde and some 200 megawatts at the Four Corners facility. Is that correct?
Yes, sir. I think those numbers are accurate.
And that, subject to check, is about 811 megawatts. And in your exhibit TGF-5 to your direct testimony, you list PNM's resources. And would you agree, subject to check, that the resources that could be listed as baseload firm capacity is a little over 800 megawatts?
That number doesn't sound right to me.
Well, excuse me. It's almost, I have to reiterate that. if you total up that firm capacity, it's some 2,348 megawatts, subject to somewhere in that neighborhood.
If you're talking about all base load, so we would add up the conventional steam coal units, we would add up the nuclear units. Those totals there, just PNM share, would amount to about 1,100 megawatts by my quick math.
Well, I was looking at the conventional steam, the gas-fired, natural gas-fired, and it would include the Four Corners, but I added up that total to something like 1,791 megawatts, and then when you add in a nuclear at 402, I came up with 1,832.
Okay.
Okay, but my only point is that if PNM has been given approval for the abandonment of the 497 megawatts and is asking for approval of the additional megawatts, that's a significant portion of PNM's traditional baseload firm generation, over a third.
I don't disagree that we're on a very aggressive path to carbon free. Yes.
Okay, but all you'd have to do is add up the total that PNM has requested to be abandoned or has gotten approval to abandon, and divide that by the number of megawatts that PNM has displayed on TGF5, and that would give you the answer to what percentage of its firm baseload resources that PNM is requesting to abandon.
I think I generally understand your question. I generally agree with it. I'm just trying to clarify and if you add up the conventional steam, if you're referring to the natural gas combined cycle as firm baseload capacity and nuclear.
I'm sorry, if
capacity,
you're referring to the natural gas.
the natural gas combined cycle and the nuclear, and you're referring to those as firm dispatchable baseload capacity, and then you're taking the amount of megawatts that we requested abandonment and the San Juan, Four Corners, and Palo Verde lease returns, then I would believe that's accurate.
Okay. Well, my only point is that the replacement capacity for the San Juan, the approval was solar. That's correct?
They were 4 projects for San Juan that included a solar and battery combination.
Correct. But the actual
4 projects.
Excuse me.
I'm sorry, much of the.
There were 4 projects. Each of them were a solar battery combination.
Correct. And the actual generation is the solar, and then the energy storage is the battery.
I would refer to it as the majority of the energy the energy for those replacements comes, that may be a little too simplistic approach to it. The solar fields provide energy. The batteries provide the majority of the capacity requirements the system needs.
Correct. Okay. And PNM's replacement resources that it's requested for Palo Verde is also solar with combination battery storage?
There are 3 projects. 2 are solar with a battery, and 1 is a standalone battery.
Correct. Okay, my only point leading up to this is that, would you agree that with the request for abandonment of its firm conventional resources, that there's going to be a need that's not satisfied with the intermittent resources for firm capacity as replacement for the Four Corners.
I don't think I agree with that whatsoever.
Okay. Well, you're familiar with Mr. Phillips' testimony, correct? You cited it in your testimony.
Yes, sir.
Okay, and I can refer you to his testimony if you want to take a look at it, but in his proxy replacement folio, he states in aggregate over the Palo Verde and Four Corners power plant replacement period of 2023 to 2025, PNM would expect to add approximately 360 megawatts of flexible combustion turbine resources. Now I can cite you to the page, but
Would you please?
certainly. That's in Mr. Phillips' direct testimony at page 27, line 2.
I'm there, if you will repeat your question.
Yes, that Mr. Phillips is saying in his testimony regarding the proxy replacement portfolios, and I'll read it and you can agree if I accurately read it, that PNM would expect to add approximately 80 megawatts of storage, 50 megawatts of solar, and 360 megawatts of flexible combustion turbine resources. That I read it accurately?
You did. I think you left off the last part of that sentence, which I think is important, perhaps, to the discussion, which states if there are no technology restrictions placed on proxy replacement portfolio.
Okay. Thank you for that correction. Do you disagree that in order to move forward on all these abandonments that Mr. Nichols or Mr. Phillips seems to be saying you're going to need 360 megawatts of combustion turbine resources?
I don't believe that's what Mr. Phillips is saying, no. I think if you look at the table below that, if you look in particular at PNM table NLP-1 that's on the same table, what Mr. Phillips is talking about is more of a wider scope there. If you're looking at about the replacement resources for Four Corners, excuse me, Mr. Lee, I will slow down. If you look at the first column there, which is exit FCPP 2024, and if you look down in the second row there, which says 2025, there it shows a combustion turbine of 80 megawatts, a storage of 57 megawatts, and solar of 57 megawatts. And those are the replacement resources for that technology neutral scenario 1 that are replacement resources for Four Corners. You look in the third column or two columns over where no new combustion scenario 2, he lists 156 storage and 95 of solar. So that's a more appropriate look at the Four Corners replacement resource scenarios. Again, you could ask Mr. Phillips follow-up questions on those.
I will, but under the technological neutral scenario 1, he would say that that would require 360 megawatts of flexible combustion turbine replacement power.
Again, I think if you look at the Four Corners replacement resources, it's the column down below. I think the model run that has unrestricted, if you go up above, you add those totals in, down below is what you should look at for the Four Corners, the distinction on the Four Corners replacement resources.
Okay, but there are no, I believe you agreed with me, but there are no firm traditional generation replacement resources for San Juan or for Palo Verde. So that the only places that replacement resources for combustion turbine would come in would be for Four Corners replacement.
I disagree with that, and if I could help explain a little, maybe might bring us closer together. And as I started out, you described, you know, I made a distinction that Four Corners, Palo Verde, and San Juan are what we'd call traditional baseload. You know, the utility industry has changed substantially, obviously, in the last decade. We would refer to those more as must-run resources, or, you know, the term baseload is basically kind of an antiquated, becoming very much an antiquated term. What we look at is, again, the capacity requirements that it brings. So a solar field does bring some capacity to it. There's a diminishing return, which we call, you know, electric load carrying capacity. As the more solar you bring on, the less electric load carrying capacity you have.
I'm sorry, there's diminished return.
As you bring on more solar, the electric load carrying capacity of each increment goes down. As you bring on batteries has a capacity component as well. As you continue to bring on more short-term batteries, that ELCC, we call it, continues to decrease. But I would object to that is, you know, in Mr. Phillips' modeling analysis, it's about serving the load through both capacity and energy needs. And the replacement resources, as described by Mr. Phillips, meets both the energy and the capacity requirements of the system more directly to achieve a loss of load probability that provides for a reliable system.
Well, thank you for that. But am I incorrect in saying that for a technological neutral scenario, is that the most cost-effective scenario?
If you look on that NMP table, NLP-1, and if you look at the NPV values at the bottom, that would show that a technology neutral scenario 1 is less costly to customers than a scenario 2.
Correct. And I believe, am I incorrect, that when Mr. Phillips is talking about 360 megawatts of flexible combustion turbine resources, that would refer to the technologically neutral scenario?
That's what it says. That's why I completed the rest of that sentence with that clarification up above. Yes, sir.
Okay. So the most...
5 minutes, Mr. Harris, 5 minutes.
Thank you. If the commission were to accept replacement, well, strike that question. If the technological neutral scenario plays out and combustion turbines were added to PNM's system, wouldn't that increase the amount of carbon emitted that would offset the carbon reduction at PNM would enjoy from exiting the Four Corners point?
No, and I'll answer that two ways if I can. Again, if you look at Mr. Phillips' testimony, and if you look at there's a chart on page 29 of Mr. Phillips' direct testimony. That chart clearly shows that either one of the scenarios, there's a substantial reduction in CO2 on the PNM system. If I answer that a different way, which is if you look at PNM's exit from Four Corners, and let's say you postulate there's a potential PNM replacement of gas, Four Corners continues to operate, If you look at that scenario, and you do some quick math, the seasonal operation provides for a 20 to 25% reduction in emissions from the plant. That's the equivalent of almost a 400 megawatt coal plant being shut down in 2023. That's the equivalent, again, of a 400 megawatt coal plant that's date certain in 2023 being shut down. So if we did some math on the carbon emission reductions from that, let's say a gas plant conservatively is half the carbon emissions as a coal plant. That's 800 megawatts of gas plant. If we do a comparison on the capacity factors, so again, the aeroderivatives that Mr. Phillips is talking about there are generally in the order of a 5 to 10% capacity factor. So if you take the capacity factor of a 400 megawatt coal plant being shut down and a 5 to 10% capacity factor on an aeroderivative, you would have to add nearly 8,000 megawatts of aeroderivatives to equal out the equation. So again, I would contest that the PNM system will see substantial reductions in carbon. The overall emissions.
I'm sorry, can you start that statement again?
I would contend that the PNM system emissions will see substantial reductions as reflected in NLP-4, Mr. Phillips' testimony. And just to the example we went through, the overall emissions for the state and the public at general is going to see substantial benefits. And the speculation that some gas, aeroderivative gas, would offset emission reductions at Four Corners, it would require, again, 8,000 megawatts of aeroderivative additions, which, again, would be completely outside of reasonableness.
Okay. Well, thank you for that answer.
When you say aeroderivatives, is that AERO?
Yes, sir.
My only point was that there would be some gas emissions from the combustion turbine. And you've explained that that is very small compared to the amount of carbon emission reduction due to seasonal operation. You agree with that?
Yeah, I would, and also I would point out, if you look in the Palo Verde case that we have, and if you look at those scenarios, the necessity for flexibility on our system to integrate more renewables is spelled out pretty well in that case. And what you'll see is actually, when you look at the scenarios for that, adding aeroderivatives can actually result in less carbon emissions than not adding aeroderivatives, because what it does is it gives you the opportunity then to maximize the use of the solar in particular on your system. So again, just to speculate that a carbon emission, that an aeroderivative is going to just increase emissions, you've got to factor it all into the entire modeling that shows how are you going to meet the system needs. And again, the increased flexibility that aeroderivatives bring can actually result in reductions in your overall carbon emissions.
Okay, well, thank you for that answer. You've educated me. I have no further questions, Mr. Hearing Examiner.
Thank you, Mr. Harris. Mr. Borman? I have you down.
Thank you, Mr. Hearing Examiner. I think I'm scheduled for 25 minutes.
That's correct.
And I will probably use most of that. I don't know if I'll use quite all of it.
All right, I'll try and give you a 5-minute warning, as I've been trying to do, unless I get distracted. So please
Thank you.
start.
Okay. Good afternoon, Mr. Falgren. Could you turn to your direct testimony and specifically page 5?
I'm
Did
sorry.
you say page 5? You broke up.
Page 25 of your direct testimony.
Very well, I am there.
Okay, and here you identify near-term resource additions that were approved by the commission in case number 19-00195-UT. Do you see that?
I do, yes, sir.
Okay, and you identify a 300 megawatt solar PPA coupled with a 150 megawatt storage battery ESA, correct?
Yes, sir.
And in addition to that, a 50 megawatt solar PPA coupled with a 20 megawatt battery ESA, correct?
Yes, sir.
And a 200 megawatt solar PPA coupled with a 100 megawatt battery ESA.
Yes, sir.
Yes, and then a 100 megawatt solar PPA coupled with a 30 megawatt battery ESA.
Yes, sir.
Okay. Now, when were each of these go into service?
They were originally anticipated to go in service in June of 2022.
Okay, and all of them?
I think the 50 megawatt, it's subject to check, the 50 megawatt solar, 20 megawatt battery may come on slightly before that.
Okay, well, what is their current status?
Currently, as we've reported to the commission, in the open hearing meeting, I believe the last two on that list are experiencing some difficulties or identified difficulties in achieving their original commercial operation date.
Okay, so the last two of those, and that would be the 200 megawatt solar PPA coupled with the 100 megawatt battery ESA and the 100 megawatt solar PPA coupled with a 30 megawatt battery ESA, those two facilities are delayed, is that correct?
They're either delayed or they've identified to us they're experiencing some difficulties with their COD dates, yes.
Okay. Are there any difficulties with the other two facilities?
I don't believe we've had any official communications. I think all of the current providers are experiencing some equipment constraints due to COVID pandemic. But I don't believe I've received any official notification on the other two.
Okay, well, let me ask this. When do you currently anticipate each of these facilities to go into service at this point?
I think the first three projects on the list, we'll see. I think the 50 megawatt solar, 20 megawatt battery will be available on its current COD, which will be before June of 2022. I believe the 300 megawatt solar, 150 megawatt battery, there's some potential delay in some of the solar, but that should be cured sometime in 2022.
So when would you expect that to go into service?
I believe that the majority of it will be in service in June of 2022. There will, may apparently be some solar that would be deferred for, I'm going to say, a couple of months. And then
how much
the
solar is
200
that?
mega. Sorry.
I'm sorry, I don't mean to talk over you. How much of that solar would be deferred?
Could potentially be up to 150 megawatts.
So it could be about half of it.
It could be for the first month, and then solve there in the subsequent months.
Okay.
And then the 200 megawatt solar, 100 megawatt battery, we're in discussions with them on what that looks like. Looks like, again, potentially half of that solar may be delayed or so.
How long?
And the 100 megawatt solar and the 30 megawatt battery, that's the Rock Mount project which we've presented. And currently we're looking at options for that. We see the significant potential for a transfer options for that last project. That project would likely be online sometime in early 2023 or before the summer peak in 2023.
Could you spell Rockmount?
Yes, sir. ROCKMONT.
Okay, thank
know you.
Oh. Thank you. Are you finished?
Yes, sir. Sorry.
I think you gave me an anticipated in-service dates for all of those facilities except for the 200 megawatt solar PPA with the 100 megawatt battery ESA. I did not hear an anticipated date for that.
I believe, again, we're still in discussions with that one. I anticipate a fair number of those resources to be online, potentially 100% of the battery, potentially half of the solar, and that would be cured by like October or so, I think, of 2022.
Okay. Now, is it correct to say that the La Jolla Wind Project, which is not one of these replacement resources, has suffered some delays as well?
There were force majeure for COVID-related delays on the La Jolla project as well.
Okay. What's the current status of the La Jolla Wind Project?
I believe they're in service.
It's in service now?
Yes, sir.
Has PNM, or I guess I'm not sure exactly who's responsible, if it's PNM or they filed the notification with the commission that the facility is in service?
I would have to check on that, sir.
Okay. Now, you testified yesterday that the RFP for the Four Corners replacement resources was issued March 8th. Is that correct?
Yes, sir.
Okay. And I think you also testified that these bids have been received and are being, is that right?
Are being, you cut out.
I'm sorry, are being evaluated.
Yes, sir.
Okay. When were those bids received?
Sorry, I thought I had a timeline here. From memory, I think they were received probably in June or so.
Okay. At what stage of the review process are they now?
I believe we're into the modeling stages. So we would have, if I could explain more, we generally have three categories. One is really initial screening. The second one is to identify best in class scenarios. So that's identifying the best solar, the best battery, the best wind, different technologies. Then what we do is we advance those to what we call phase 3, which then goes into the modeling, the resources to identify the preferred portfolios, the low cost portfolios to represent those.
Okay.
So we've
those, I guess, those kind of that process. Where exactly are you? You're in the modeling part, you said?
Yes, sir. We're in phase 3, and
Phase 3.
we are in the modeling, developing different scenarios, different portfolios that again represent the low cost portfolios for those resources.
Okay. And I think you also stated yesterday that you anticipate coming to the commission for approval of those replacement resources in Q1 of 2022. Is that correct?
Yeah, we were originally hoping to do Q4 this year. If we can still make that, we would. But again, to be, we would maybe looking at Q1 of 2022.
Okay. So, and again, yesterday during your cross-examination, and again, if I'm misstating something, please correct me. But I think you stated that the reason PNM filed this application when it did, which was January of this year, was that such a prompt filing was required under the terms of the agreement with NTEC. Is that correct?
I'm not sure if I characterize it that way.
Well, how would you characterize it?
Yeah, I would characterize it that the purchase sale agreement has a date certain of March 2022 for a filing. I think there are a number of things that trigger off of that. One is obviously NTEC's desire to understand the regulatory certainty of this transaction. The other thing, as we've talked about before, is that seasonal operation is scheduled to initiate sooner than later. I think parties are looking to make long-range forecasts. All the 5 parties are looking to make long-range forecasts. So again, date certain for that. And again, I would represent that when we go out for an RFP, as we did in the San Juan case, I think a number of the providers, developers, have concern if there's still regulatory proceedings that exist on the abandonment filing. So I think that may be the reasons that we've moved forward.
Well, it sounds like, I mean, you basically just confirmed what I asked, is that the early filing was required under the PSA. That's the agreement with NTEC. Is that correct?
That's one of the reasons I stated.
Okay. And I think you've also stated that you were involved in the negotiations with NTEC regarding the PSA. Is that right?
I was, yes, very much so.
Well, being that you were involved in negotiations with NTEC, was there an effort by PNM to push back on the timing of the filing of the abandonment application?
I think we discussed the timeline. And again, I think PNM would suggest that the March date is an appropriate date. Again, I think as we've seen in the last several cases, and we've heard from the commission since that, is there's disdain for expedited cases. And obviously, I think a lot of the stakeholders that are in this proceeding have commented on expedited proceedings as well. We knew the agreement was filed. You know, there's no need to delay the filing. And I think the filing, allowing the filing to proceed forward, allows a more orderly and timely process of the entire process, not only the abandonment, but also certainty for the developers on moving forward.
Well, was the timing of the filing a provision that was desired by NTEC?
It was a yes. I would say that it was a desire of NTEC. The March date was a desire by NTEC.
And was PNM interested at all in pushing back and seeking to delay that filing?
I didn't think that PNM had an urgency to delay the filing. I think, you know, if anything, we get criticism is if we know something, we don't file it more immediately. So I think filing it more immediately, we understood was probably the more appealable approach.
As someone involved in those negotiations, would you state that, or do you believe that both PNM and NTEC possessed equal bargaining power in those negotiations?
I believe that there was, yeah, I would agree with that, is that there were two parties, arm's length negotiation, and obviously, yeah, that they were conducted arm's length and with equal bargaining power positions, yes.
Could PNM have walked away from the agreement with NTEC if the deal was not good enough?
Obviously, that answer is yes, but we didn't have another viable option available.
So then my follow-up question is, would PNM have walked away from the agreement if it was not good enough?
I think PNM, as ordered by the commission, was to look for an early exit opportunity out of Four Corners. We found an opportunity to save customers between $30 and $300 million, provide some environmental benefits. I think it would be difficult for PNM to walk away from a deal such as that.
Okay.
And particularly since it was the only deal available that satisfied those criteria.
Now, I believe earlier today, Mr. Elliott asked you some questions about the seasonal operating agreement. Do you recall that?
I believe so, yes.
Okay. Well, let me ask this. Would PNM agree to transfer the Four Corners facility to NTEC under the PSA if the seasonal operating agreement didn't exist?
As I stated, I think to Mr. Elliott, the purchase sale agreement can stand on its own. That was signed on November 1st. We did not complete negotiations on the seasonal operation until June 25th. The seasonal operation cannot stand on its own.
So, and I want to make sure I'm understanding this dynamic correctly. PNM would go forward on the transfer of Four Corners to NTEC without the seasonal operating agreement, but would not enter the seasonal operating agreement without the transfer. Did I state that correctly?
I don't think it's, the only exception I'd say is PNM would be willing to, or PNM would. The seasonal operation agreement was a 5-party agreement, and that has a condition subsequent that the purchase sale agreement is approved.
Okay.
So I just want to represent that correctly. But
And, okay, are you through?
yes, sir. Sure.
Okay. Now, I think you also said that if the purchase and sale agreement with NTEC does not go through, you do not believe that there is a path forward. But if the purchase and sale agreement with NTEC does not go through, you do not believe that
Sorry, you're breaking up, but if the purchase and sale agreement with Intech,
does not go through, you believe there is no path forward for the seasonal operating agreement. Is that correct?
Yes, sir. That's my belief.
Well, why not? Can you tell us why not?
I believe I talk about that in my testimony. I'll let my testimony speak, and I'll reference that. But you know, to save your time, if you would. But you have to have, it's a delegate agreement that has multiple stakeholders in it. In order for the seasonal operation to move forward, it requires an entity or entities that can achieve the minimum or mostly achieve the minimum load requirements of a single unit, which PNM and NTEC shares together are close to that equivalent, or are that equivalent. Absent that, then the other owners are not allowed to idle their particular ownership shares, which is a requirement of the operating agreement, which is they'll have to continue to adhere to the current operating agreement, which requires them to operate their minimum share requirements.
So would all of the other operators or owners oppose such a transaction without the purchase and sale agreement?
Again, it's not. I don't see it's physically possible. And again, it's a combination of PNM and NTEC shares moving forward. You know, what PNM achieves out of that is customer savings, environmental benefits, and then our exit and then our eventual exit out of the plant. So PNM willing to operate those additional megawatts further into the future for that one single unit operation is a key component of seasonal operation.
Well, if all the parties agreed, couldn't it be changed to make it so?
Again, I don't believe that which party is going to subject themselves to the additional minimum requirements from the seasonal operation would be the difficult thing.
Well, that's what I'm asking. And I guess then it sounds like the answer that you're giving me is none of the parties would agree.
I don't believe, that's why I say I don't see there's a path forward if the purchase sale agreement and NTEC's acquisition of the full 20% doesn't move forward. That's why I say the ownership discussion has been, we don't see a path forward contrary to that transfer.
Why does the purchase and sale agreement change that dynamic?
Why didn't it?
Why does the existence of the purchase and sale agreement change the dynamic such that the parties are willing to agree to that?
Because it provides that NTEC then has a full 20% share obligation in the unit. So then seasonal operation is allowing them to move 20% on each of the units to a one unit, which then provides them a 40% share in a single unit, and NTEC's operating that and basically meeting almost the full minimum take requirements on that single unit. And that's why the purchase sale agreement facilitates the seasonal operation.
So it's not the purchase and sale agreement, it's the share that NTEC would have as a result of that purchase and sale agreement. Is that what you're telling us?
Yeah, from an operational standpoint, I think that's accurate.
Okay. I don't have any further questions for Mr. Falgren. Thank you.
Thank you, Mr. Borman. Ms. Falgren, I don't want to take up a lot of your time. I know how taxing and exhausting this has been. I truly appreciate your hanging in there with us and doing so well. I just wanted to follow up on this regarding the seasonal operation agreement. I understand what you're saying about the, I guess what you just described about the full minimum take requirement, the advantages. Is that an advantage that NTEC saw in the seasonal operation agreement in agreeing to it?
Yes, I think that was one of the compromise positions that allows NTEC some value in the equation.
Did you have to persuade and explain that to them, the value of the seasonal operation agreement?
Explain that to NTEC.
And the other co-tenants?
Again, seasonal operation was a concoction out of my brain, so I did explain
Right, that's
that.
where exactly, and you know where I want to go with this, don't you? I want to know when you started negotiating it. You know exactly where I'm going.
Yeah, so I started negotiating in early 2018, actually. And I'll tell you the seasonal operation, and again, that was one of the original ideas I proposed to the parties. The seasonal operation I started with was, again, an opportunity for APS, SRP, and Tucson to take PNM share. That would have provided them additional summer capacity, would have allowed them to not potentially build other carbon emitting resources to meet their summer capacity, would allow them then to idle our shares during the shoulder months and move forward. That was the brilliant idea I thought I had. The other parties were resistant to that because they felt like many of the environmental groups would significantly oppose that because they would be shown as having additional coal capacity. And so that got taken off the table.
So that was 2018. And then you filed the case without the seasonal operation agreement, right?
Yes, sir.
So you revived the seasonal operation agreement concept with the parties, with the your counterparts approximately when?
Again, we kind of continued to evolve that as we got, I would say probably that evolved later part of 2020, that concept. Certainly that concept was on the table when we signed the PSA with NTEC, that could be a potential path and consideration. And then we continued to negotiate that through where I think we announced the agreement in principle in April of 2021, and we signed the agreement in June. So really, again, that idea, the bigger idea of the seasonal operation coinciding with the purchase of sale agreement would have been the latter half of 2020, I would say.
Well, we're getting tighter. We're getting tighter on the numbers now, slightly closer. The seasonal operation agreement, my order ruling on the sufficiency of the original application was when? Wasn't it February 2021?
Something like that. Yes, sir.
And so, and that's approximately when the seasonal operation discussion started to heat up?
Again, I would represent that we had discussions on seasonal operations probably late third quarter, early fourth quarter of 2020.
What impetus would you have had? I'm sorry.
Oh, go ahead. Sorry.
I'm trying to rush through this for you more than anybody else.
Sure.
But I'm sorry. What impetus would you have had to present the seasonal operation agreement without an order ruling on the insufficiency of the application?
I'm sorry. What impetus would I have without?
Well, let's assume that the ruling on the application was that, you know what, the application's fine. Just proceed, PNM. would we have seen the seasonal operation agreement?
I believe so, yes.
When?
Probably on the same timeline that you saw it now, June.
As a negotiating tactic, as part of the proceeding, or how? It doesn't make sense to me otherwise.
I think it's an important consideration because I think a number of parties, have maybe inferred that, our exit's going to result in carbon emissions. I think the two are tied together, and we wanted to present the commission a full view of that, the purchase sale agreement does provide for that. I think the hope of myself in particular was that we were always going to implement seasonal operation as part of the purchase sale agreement, and that we were moving forward as fast as we could with all the parties. So I would have loved to have presented that. I mean, PNM had to put significant pressure on the other owners to do the release on April 1st of the agreement in principle for seasonal operation. But we were moving forward as fast as we could. So I couldn't have represented that. I probably could have brought it any sooner than I did because I was pushing as hard as I could.
That's fine. And that's a fine answer. I just want you to understand, I'm not criticizing the seasonal operation agreement. I'm trying to understand how and when it came about.
Absolutely.
And on a different subject, very quickly, I noticed that, let's look at, for instance, at your rebuttal testimony on page 12. This is one place where you talk about the shift on base load, the concept of base load. There on page 12 at the bottom, at around line 19, you say this capacity consideration, meaning suitable replacement resources to meet capacity needs. This capacity consideration is particularly important because PNM is already undergoing a significant change in its resource mix to provide more flexible operations to respond to increasing amounts of renewable resources that are more variable in their production. Now, when I last visited this issue with you, addressed this issue back in case number 19-195 UT, you and your colleagues who work for you seem to be emphasizing the reliability and the necessity of base load in its slightly different philosophical way than you are now. Have I detected a philosophical shift in how you view base load and how you view the renewables coming online? And specifically in this regard, storage capacity from batteries?
I think we still share the same views, and I guess I think our position there would remain the same, which is firm dispatchable resources, not necessarily a baseload capacity, but firm dispatchable resources. And as we advocated in that case, some of the aeroderivatives we thought would have provided a better reliability component for our system and allow us to move forward with that. It's still an issue we're going to have to deal with, is that reliability component that provides those.
I'm sorry, can you repeat that statement?
Yeah, I mean, we still, can you tell me where you left off? Sorry.
Reliability component for that system and allows us to move forward with that.
Yeah, allows us to move forward with, the further transition of more renewables on the system. Again, that's that flexibility that allows more renewables. I think on the battery components, our concerns there were really our familiarization with batteries and the potential issues that we would see with maybe a single failure event. We've seen a large single failure in Australia on a battery event. And really we were trying to emphasize at that time the importance of understanding batteries maybe at an operational level before we, now we're adding, if you look at the Palo Verde resources, we're up around 650 megawatts or so. We're working hard now to try to get up to speed on the control systems for those batteries and provide them. We don't question, I don't think we ever question that batteries can provide that firm capacity, but more on a limited time basis. I think it's to me, it's probably more a recognition of the commission and the commission's order and the direction that we appear to want to go in the state. And so we're just getting our heads around that and making it happen, I guess, is probably more what I would term. If there's a shift, it's that shift.
So there has been a shift.
Again, I think the order from the commission gave us a clear signal that we want to move forward with with the higher battery penetration. We recognize that, we respect that. Again, it's my job to make it happen. I'm trying to make it happen.
And APS has ordered how much battery storage?
I believe there were around 2,000 megawatts or something, someplace in my testimony.
And have you been out to Moss Landing?
I have not. I think parts of my team have been, but I have not.
Oh, good. So you have actually gone out there to look, your team has actually gone out there to look at that extensive facility.
Yes.
Okay. This is that I just wanted to understand that a little bit better. Really, for now, I think that's all I want to trouble with you with. So, Mr. Williger, do you have any redirect?
Examiner, yes, I do. I think before I do my redirect, we need to address Mr. Tisdale's issue regarding the operating agreement for the Navajo Transitional Energy Company. We were able to locate a more updated, it's an amended and restated operating agreement of the Navajo Transitional Energy Company. It was signed on May 30th, 2019. That was an SEC, as in Securities and Exchange Commission filing. So PNM renews its, we asked that Community Groups 5 not be omitted because it's not the most recent document. And we renew our motion to strike regarding that testimony.
Mr. Tisdale.
Obviously, I've not had a chance to review that new operating agreement. I would ask Mr. Williger whether, my questions of Mr. Falgren on the operating agreement were with respect to the relationship between the different membership committees. And if those aspects of the operating agreement hasn't changed, then I think that all of the line of questions to Mr. Falgren are just as relevant.
So, Mr. Tisdale, you represented that as the operating agreement, did you not?
I represented that as the operating agreement that I had. To the best of my knowledge that I was able to determine that was the most. I accept that Mr. Williger was able to find a more recent version, but the version that I used was submitted in federal court testimony by NTEC's CEO.
But assuming that it's not the actual operating agreement in effect, I think it would be unfair to the witness and unfair to PNM to have that document in the record when we don't know what the changes have been to the operating agreement. Because while you focused on certain parts of that document, that whole document would come into the record, and that's not the operating agreement. Therefore, go ahead.
I would just say that there has been no Navajo officials nor NTEC officials who have been made available as witnesses to this case. And
I saw that argument. I saw that argument. We dealt with that motion already.
Correct. And my only response to that, Mr. Hearing Examiner, is that the commission would therefore not have a very relevant document available to it in making its determination relative to the relationship between the Navajo Nation and NTEC.
But it's not the current operating agreement, is it?
Apparently not.
Okay. Objection of PNM to CG5, Community Group 5 is sustained, and testimony around the questioning of that document is hereby stricken. Now, redirect.
Yes, thank you, sir. Mr. Falgren. You've had some questions from various interveners regarding the APS ROO. Is that correct?
I'm sorry, I lost you. Can you start again?
Sure, Mr. Lee, sorry. Mr. Falgren, you had some questions from various parties regarding APS's ROO. Is that right? That was issued on August 2nd?
Yes, ma'am.
Are there other rulings that the Arizona Corporation Commission have made that might be relevant to this discussion?
There are. I'd like to highlight them. In December of 2014, the ACC ruled that APS could acquire Southern Cal Edison's portions of Unit 4 and 5, and that those capital expenditures for that were prudent and included in rates. Again, that was in December 2014. In November of 2018, there was actually a separate proceeding on the SCR prudency, where the hearing examiner identified in that hearing that the SCRs were prudent and should be included in rates. Subsequently, the commission did not act on that hearing examiner's recommendation. Also, I think which is relevant is in December of 2020, the ACC ruled in their final order. This is not a recommendation, it's the final order. They ruled in the Tucson Electric rate case on the prudency of TEP's or Tucson's involvement in Four Corners, including the SCR. And their conclusion was the Sierra Club has not presented any factual or legal basis to support a finding that TEP's investment in Springerville Units 1 and 2 and Four Corners was imprudent at the time it was made. Accordingly, we reject Sierra Club's recommendation regarding Springerville units and the Four Corner power plants. Again, I'll represent that in Springerville, was progressing to a seasonal operation. And again, the Four Corners those rates were completely included, including the SCR rates, with the depreciation schedule to 2031.
Okay, Mr. Falgren, since the issuance of the APS ROO on August 2nd, is there any indication, or do you have any indication whether APS has changed its mind as to the 2031 expected retirement date for Four Corners?
I'll reference that APS Pinnacle West had an investor relations call on August 5th. Again, August 5th was after the August 2nd release of the ROO, in which the CEO for Pinnacle West, APS, was quoted as—
Objection, Your Honor.
Where's that coming from?
Ms. Nanasi.
State your objection, please.
It calls for a hearsay response.
Denied, excuse me. Overruled. Please proceed.
Jeff Goldner, the APS CEO, was quoted, which is available online. If we didn't have the capacity out of Four Corners, there was nothing else in the West. There was nothing else that we could go get. There was no other resource that we could use to keep the lights on. And so you have to continue to operate it. That was his quote from the investor call on August 5th.
Can you spell Goldner?
G-U-D-N-E-R.
And Mr. Falgren, since the issuance of that APS ROO, has there been any initial indications from any of the commissioners at the ACC as to their opinion or concerns regarding the ROO?
Objection again, Mr. Medeiros.
And the objection is?
Again, it calls for a hearsay response.
Mr. Williger?
Your Honor, you've made a ruling on the hearsay issues in front of this commission, particularly in front of you, that there's a more liberal policy used regarding hearsay. I did not ask a leading question. And Mr. Falgren, if he has information or knowledge as to this, and if it's public information, he should be allowed to provide it.
Overruled. Please answer the question.
The Arizona Corporation Commission Chairwoman issued an open letter on August 26, 2020, in which she states in parts, as you know, the closure of FCPP 7 years earlier than its originally planned retirement date in 2038 will have devastating financial consequences for the Navajo people and communities, and have relied on the operation of for their continued financial economic support. In addition, the RO's SCR denied, based in part on the utility's decision to close the plant 7 years earlier, could have an impact on the Commission's ability to provide business certainty and regulatory stability for future clean energy investors.
Mr. Falgren, somebody tried to put that in front of my face, that particular letter and the discussion you're having. Mr. Williger, is that in the record somewhere?
Hearing examiner, I believe we have it as a potential exhibit in our Dropbox, but we have not introduced it yet, obviously, or asked for it.
Okay. This all sounds kind of familiar. So I just wanted to highlight that it all goes, frankly, let's try and, there are permissible hearsay objections, but it really fundamentally does go to the weight that I'm going to give stuff like this. Go ahead.
I appreciate that. We understand that. Mr. Falgren, you got questions on the material adverse effect language. Do you recall those questions?
I do.
Okay, and in particular, regarding whether it's probable that NTEC would agree to PNM voting on an early closure of Four Corners. You recall those questions?
I do.
Is there any reason, Mr. Falgren, to believe that NTEC would entertain or at least negotiate on PNM voting to close the plant in spite of the material adverse effect language? Do you have any reason to believe that?
I do, and again, that's why I was trying to be specific through my testimony that said NTEC's interests are preserving the jobs and the revenue to the Navajo Nation. NTEC, if you look at their name, they're a transitional organization. Part of their objective is to transition to a more sustainable energy source. If we look at, again, that provision, what it says, and why I've continued to point that out, is it says, except to the extent approved by the purchaser. And then if you go down below, where we want to focus on the cease operation, I'd like to read that sentence incomplete. It says, or at least that portion of the sentence, says, making no affirmative vote as a facility owner to reduce the production from or cease the operation of the plant prior to the coal termination agreement. Well, if you look at seasonal operation, that clearly has resulted in a reduction of production from. But NTEC has engaged in that conversation and allowed PNM to again sign the provisions of the seasonal operation, because the provisions, again, allowed for the retention of jobs, and it allowed for the revenue requirements for the nation to continue. And again, that's their primary focus. So again, if those provisions were available and parties wanted to close the plant earlier, they could approach NTEC then to negotiate and again have those key parameters available in the negotiation. And again, then I believe that NTEC would engage and participate in those conversations for a further closure, as long as those jobs and revenue requirements were provided for.
Okay, that's all my redirect. Thank you very much, hearing examiner.
Thank you very much, Mr. Williger. All right, Mr. Falgren, thank you so very much for your testimony. As always, being a key witness in every case that you're in, I'm going to excuse you, but respectfully request that, if possible, if anything comes up, we might be able to hear from you again. during the proceeding?
Understandable, yes. Understandable, and yes, sir. I'll be available whenever you need me.
Thank you so much, sir. You're excused.
Mr. Hearing Examiner?
Yes, sir.
Yeah, I would, I respect your earlier ruling with respect to Community Exhibit 5. I would simply request, I have not seen a copy of the apparently new operating agreement that Ms. Terwilliger referenced. Is it possible for her to provide that to me so that I can review that and perhaps we can circle back around for potential reconsideration of that exhibit? Just simply because I have not had the opportunity to review the document that Ms. Terwilliger represents is more recent.
Ms. Williger?
Hearing examiner, I would be happy to share that with Mr. Tisdale. My only representation was I was able to find this document with some fairly simple searches on the internet. So it was out there and it was easy enough to find, but I'm happy to provide that to you. More than happy. I can shoot you the link right away, Mr. Tisdale.
Thank you so much.
Ms. Terwilliger. Sorry. Thank you, Ms. Terwilliger. Thank you, Mr. Tisdale.
Thank you.
All righty. Up next, we have Ms. Sanchez. I think we should probably get started with the cross-examination or the presentation of Ms. Laura Sanchez.
Hearing examiner, if we could just ask for like 5 minutes for us we need another lawyer to come into this room, and Mr. Falgren, the whole switcheroo with the rooms, that would be great if we could do that.
All right, let's take 10.
Okay,
we'll be back at 2:45 approximately. 2:45. Thank you all.
Thank you.
Ms. Sanchez, can you speak?
Yes, can you hear me?
Yes, I can hear you. Thank you. Hello, Mr. Gifford.
Good afternoon, Mr. Lee. How are you?
Good.
All right, we're back from a brief break. Mr. Gifford, good afternoon.
Good afternoon, Your Honor.
Would you please call PNM's next witness, please?
Yes, thank you, Your Honor. PNM would call as its next witness Laura Sanchez to the virtual stand.
Ms. Sanchez, would you raise your right hand, please? You do solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Ms. Sanchez. Could you please state your name for the record and describe your role?
Sure. My name is Laura E. Sanchez, and I am the Chief Policy and Legal Advisor, it's a mouthful, at PNM Resources, Inc.
Thank you, Ms. Sanchez. And do you have in front of you what's been pre-marked as PNM Exhibit 7, the direct testimony of Laura E. Sanchez?
I do.
And is this the direct testimony you caused to be pre-filed in this case?
Yes, I did.
And do you have any corrections to that testimony?
No, I do not.
And if I were to ask those same questions to you here today, would you give the same answers?
Yes, I would.
Your Honor, I would move the admission of PNM Exhibit 7, the direct testimony of Laura E. Sanchez.
Any objection? Hearing none, PNM Exhibit 7 is admitted.
And Ms. Sanchez, do you also have in front of you what's been pre-marked as PNM Exhibit 8, the rebuttal testimony of Laura E. Sanchez?
Yes, I do.
And that is the rebuttal testimony you caused to be pre-filed in this case. Is that correct?
That's correct.
And do you have any corrections to that testimony?
I do.
Could you
First,
please,
starting at, I'm sorry.
now, could you please direct us to those?
Yes. At page 12 of my rebuttal, line 20, PNM apostrophe S should be PNMR apostrophe S. And I have a second one, and that's at page 29. Line 6. And on that line, the words starts with a parentheses, and the open parens, return of, close parens, should be stricken. And after the word return should be inserted on investment.
And Ms. Sanchez, those corrections have been uploaded into the Dropbox and is what we have moved to be admitted here today. Is that correct?
That's correct.
And Ms. Sanchez, with those corrections, if I were to ask you those same questions today, would your answers be the same?
Yes, they would be.
With that, Your Honor, I move the admission of PNM Exhibit 8, the rebuttal testimony of Laura E. Sanchez.
Any objection? Hearing none, PNM Exhibit 8 is admitted.
With that, Your Honor, the witness is available for cross-examination.
Thank you, Mr. Gifford. Bernalillo County, Mr. Albright, good afternoon.
Good afternoon, Mr. Hearing Examiner.
I have you down for 20 minutes. Do you still have that amount of time with Ms. Sanchez?
I do, Your Honor.
Okay, please proceed.
Thank you. Good afternoon, Ms. Sanchez.
Good afternoon.
My name is Jeff Albright. I'm with J. Albright Law LLC, and I'm here on behalf of Bernalillo County. So I do have a few questions, probably more questions than I have time. So I'll try to be succinct with these. But I do want to clear up a couple of questions. If you turn to page 2 of your direct testimony, PNM Exhibit 7, please.
Yes, sir.
Okay, and at lines basically beginning about line 4 and running through line 7, you talk about a special purpose entity or issuer that will be a wholly owned subsidiary of PNM. Do you see that?
Yes, I do.
Okay, is that going to be a wholly owned subsidiary of PNM, or is it going to be a wholly owned subsidiary of Avangrid?
Mr. Albright, that is actually a subsidiary of PNM. So through the ETA, it does provide for a subsidiary, a special purpose entity to be created by the qualifying utility. In this case, that would be PNM.
Okay, and related to that, if you'll turn to page 17 of your testimony as well, the direct testimony.
I'm there, sir.
Okay, and then at lines 12 through 14, you state PNM may form a special purpose entity, which will be a wholly owned subsidiary, and special purpose entity will issue the energy transition bonds. Do you see that?
I sure do.
Okay, so that may shouldn't be there, or is it optional, or I'm just it wasn't clear to me.
Yes, and thank you for that question. Let me take a moment to just make sure I understand the context of this, if you could.
Absolutely.
Okay, thank you so much. So yes, the reason there's a may in that sentence is because if you look at the next sentence after that, I referenced Mr. Atkins, who will be testifying later on in this proceeding. And basically, it depends on rating agency as well as investor preference on whether PNM will create a separate special purpose entity for the Four Corners bonds, as opposed to the bonds that are being issued for, in conjunction with the San Juan generating station bonds. So those are two different transactions, but it is permissible for the same entity to issue both bonds, but it's not clear yet whether that will be the case. So there could be a separate entity created like the San Juan entity.
And that was going to be one of my questions. I didn't know if it was the same entity for both San Juan and for the Four Corners or not. So thank you for that clarification.
I'm sorry for stepping on you, but it could be the same entity, but it does not have to be.
And then at page 3, you list a number of exhibits that you sponsored. Do you see that? And again, I'm talking about the direct testimony.
Yes, I see that.
Okay, would you turn to LES-2, the estimated upfront financing cost for issuance of the bonds?
Yes, I'm there.
Okay, so when you're talking about the upfront financing costs here, and I assume then that these are for the Four Corners or these for San Juan? It wasn't quite clear in the context of page 3.
Yes, these are for Four Corners. These are the estimates for Four Corners.
Okay, and with regard to the legal fees that are there, the $2,300,000, I believe in your testimony, and please correct me if I'm wrong, you state that those estimates are based upon similar transactions elsewhere. Is that a fair statement?
Yes, Mr. Albright, I do believe that I say that. If you want me to look specifically at my testimony, if you would give me a reference, I'm happy to confirm that.
I think I have it marked somewhere, but I was just trying to get a general feel. And similar transactions, now are those legal fees that would be associated with the, but I'll strike that. When we talk about bonding, and I believe it's down the bond counsel costs for the NMPRC bond counsel costs, same table LES 2, Exhibit 2, and line 13. You have 0 listed there with a footnote, no cost assumption made, cost to be updated upon any State Board of Finance approval of reasonable fees for PRC staff bond counsel proposals. Did I correctly state that?
Yes, that's what it says there in footnote 3.
Okay, so the legal fees that are listed in line 3, what legal fees are those? And do you have any kind of estimates on bond counsel costs for NMPRC? Compound question, but the two are related.
Yes, I understand. So the legal fees that are estimated in line number 3 are actually related to the transaction itself, the bond counsel, as to the bonds that will be issued. So you have counsel usually for the issuer. I mean, you can imagine there's multiple lawyers, much like a regulatory proceeding, but you have multiple lawyers representing all the parties in a bond transaction. In this case, it would be the legal fees related to the issuer counsel, which usually handles a lot of the basic bond drafting. They review prospectus related to the bonds. They're involved in the structuring and the pricing and the marketing. They essentially represent the issuer, which in this case would be the special purpose entity. So those are the legal fees and the estimate related to that. And I should also add that often legal fees, and not just in these kinds of transactions, but
All right,
in
can you
other
start that
bonds-
statement again, please, and slow down?
Maybe I was just going to say maybe to slow down just a little bit. So
Yes, I'm
for
sorry.
my benefit as well.
I get so excited with bond law. No, but I will slow down. So with legal fees, they're often a derivative of the overall size of the bond issue. And that isn't just with corporate bonds or with these kinds of bonds, but it's also with public bonds, for example. It's often some percentage of the overall amount of the bond proceeds, right? So that's what that number represents. Now, to your question, as far as line 13, there is a provision as part of the ETA to have basically the financing costs that are upfront cover the cost of staff to hire their own bond counsel to do the review that they may need to do in doing any kind of review related to the bonds once they are issued. So that is something that hasn't yet occurred, and it would be something that probably would be better asked of a staff witness. In this case, we don't know exactly what kind of cost that would involve for a public entity doing that kind of review. It's a little bit unusual, but there's also in here, and the reason it references the State Board of Finance is they would be the ones sort of being the check on the cost for bond counsel related to the PRC. And I'll add that the State Board of Finance hires their own bond counsel routinely to do reviews of public financings.
Okay, and so is it fair to say that the legal fees in line number 3 could very well be legal fees for attorneys outside of the state of New Mexico, or at least where that number came from is when you were looking at comparables?
Well, I will say that the comparables relate to other utility securitization financings. And I believe Mr. Atkins in his testimony has an exhibit, and I'm going to forget exactly what the number is, but I know there's an exhibit in his testimony that lists the number of securitization financings for utilities that he's been involved with, and there's something like 25 different ones that he's listed there. You'll note that in all of those, except for the very last one, which is, I think, the San Juan procedure that we went through a couple of years ago, in all of those are all out of state. So when we talk about looking at comparable legal fees, they will, by design, be out of state, only because this is a new law. Obviously, the ETA is new here in New Mexico. We haven't had any bond financing issued here. So you are correct that they are based on estimates from out of state. However, there are very competent bond counsel here. And I say that as somebody who was a member of the bond counsel world for a little while here in the public finance arena. But there's very competent bond counsel here with a variety of firms. And so that could potentially be adjusted one way or the other.
Okay, and these costs, all of these costs together, LES2, are, when they're listed as upfront financing costs, these are in addition to any actual securitization, correct?
Yes, Mr. Albright. These are separate costs, and they're listed out as separate energy transition costs in the ETA. So these are in addition to the securitized amount that is known as the abandonment cost. Yes.
Okay. I'm going to skip around a little bit here as well. Just again, for the sake of time, would you turn to your rebuttal testimony, PNM 8 and page 1? I want to call your attention. Are you there, Ms. Sanchez?
Yes, I'm sorry. I am
Okay,
there.
no, that's all right. So in lines 19 to 21, you lay out the organization of your rebuttal testimony. And you state there as one part that you state, I also reiterate how this case is distinct from and not interrelated with the merger case 20-00222-UT. Do you see that?
I sure do.
Okay. I'd like you to turn to Bernalillo County exhibit number 6, please. It's on the Dropbox, and it is labeled and was identified as potential cross-examination.
Yes.
Okay, and would you turn to page 3 of, and this is by way of background, this is PNM Resources Notice of Annual Meeting and Proxy Statement 2021. And this was public record, easy enough to pull from and define. So we've identified it as an exhibit. And would you turn to page 3, please?
Yes. No.
Under the merger with Avangrid section, 2020 business highlights, if you go down to the 4th sub-bullet under the first bullet, it says facilitation of PNM Resources continued commitment to exit coal with the approved abandonment of the San Juan coal plant in 2022 and continued efforts to exit Four Corners coal plant prior to the expiration of ownership and coal supply agreements in 2031. Do you see that?
I do.
Does that change your statement on page 1 of your testimony?
It does not.
So you don't believe that the merger with Avangrid, as far as it says expected to close, providing for, and then that's one of the elements that's listed. So that doesn't change your opinion at all?
It doesn't. What I'm discussing here is whether the two cases are interrelated, whether they should be combined or one is a condition of the other. And my experience with this case, it was developed completely separately from any kind of merger case. So this is an update that you're referring to, that you've referred me to on page 3 of this exhibit. And it looks like this is an update of the things that are worthy of business highlights that were being presented at that point I think it's been, also there's been testimony already in the record that the two conditions that were part of the merger agreement, and again, I did not work on the merger agreement, but I know there's at least one exhibit out there that I reviewed that has excerpts from it. But I know one of the conditions, or the only two conditions, related to Four Corners divestiture was filing of the Four Corners abandonment and a signed PSA, purchase and sale agreement with NTEC. And those have been fulfilled already. So to my understanding, that's simply the highlight that's going on here.
Okay, I'd like you to turn back to page 29 of your direct testimony.
About 5 minutes, Mr. Albright, about 5 minutes.
Thank you, Mr. Hearing Examiner.
I'm there.
And again, somewhat time limited, but lines 15 through 21, you talk about, in addition to the debt service, there will be some other ongoing expenses. And at line 17 and 18, well, beginning at line 18, you say that these other ongoing costs are estimated to be approximately $474,965 annually. Do you see that?
I do.
Is that still a good estimate that you have with regard to the ongoing costs? And I assume that when you say ongoing costs, are those costs to consumers?
Well, let me refer you on that point, and it's actually up at the top on line 14 of that page. I
Okay.
referenced the table LES3, which spells out what that $474,965 figure, the different buckets that encompasses. And so if we look at LES3, that spells out what these different fees are. This is a cost, basically these ongoing financing costs are also costs that can be included per the ETA in the energy transition cost. And so as you can see, these are different kinds of also ongoing legal fees, ongoing auditor fees, administration fee, and all of these are still fees that will be incorporated as ongoing annual costs. They will be rolled into the bonds. So essentially what happens is that there's an energy charge that is collected. That energy charge is sized so that it covers debt service as well as these annual ongoing costs. And then that's how that gets paid. So it is a charge that will appear on all customer bills.
Okay, so a couple of questions on that. I was going to go to LES3. With regard to, for example, so we're talking a little less than $500,000 each year after the bonds. I assume this is after the bonds, after the securitization, after the bonds are in place. Is that correct?
That's correct.
Okay, so for rating agency fees, $72,000 a year, why would that be a recurring expense after the issuance of bonds, unless there's some attempt to refinance, for example?
Well, this may be a question that might be better suited for Mr. Atkins. I'll be completely honest with you, because I have not been involved in past securitizations the way he has. But my understanding is that there is the need to have agency review of essentially the entire bond, the income stream, the debt service, to make sure that they are continuously being paid appropriately, that the bonds are being serviced appropriately. But again, that's all subject to check, and I think Mr. Atkins would probably be the best person to ask about that ongoing cost.
Okay, because I saw PNM servicing fee up there, and that's what I thought that would encompass. So some of these just aren't clear to me as to what they are, but since it was here with your testimony, I thought I would ask you about it as well, but I can defer that to Mr. Atkins.
I appreciate that, and I'm sorry. Yeah, now that you mention it, when I'm looking at this, I know you're out of time, but I just noticed that I have a typo in here, and we did not upload this, Mr. Hearing Examiner, into Dropbox, but completely my fault. I should have caught this. I see that there's a typo on line 11. That should say total estimated ongoing costs instead of estimated upfront costs. And I'm certain that's because I used the template from the LES2 table into LES3, and so I failed to change that word. I just wanted to let everybody know that. I'm sorry.
So this is on LES 3, Ms. Sanchez,
That's correct. LES 3, line 11.
line 11.
And I
What should the
believe,
change be?
Mr. Hearing Examiner, with that, I would move for the admission of Bernalillo County Exhibit number 6 into the record, please.
Now, Mr. Albright, I checked, I just went to Dropbox and downloaded your zip file, all your exhibits. And I also checked against the one that I had already downloaded a couple of days ago before the hearing, and I do not see any marking of Bernalillo County Exhibit 6 on either the old one that I downloaded or the one that I just downloaded a few minutes ago. Could you identify where you marked this exhibit, Bernalillo County Exhibit 6?
Yeah, I don't know if you can see that or not. It's marked on the bottom. I'm not sure which copy. We had changed those and uploaded. It may show as a mirror image here, but it was Bernalillo County 6 is the only one that we labeled and submitted for cross-examination. I will check to see if there's been some error in the downloading of the Dropbox.
Somebody could correct me if I'm wrong, but if you look at what I downloaded off of Dropbox just a few minutes ago, that BC6 label does not appear.
And Your
on
Honor,
the
my
document.
apologies if it's not on the one. I know we resubmitted it with, I thought we had I had confirmation that we had resubmitted it with that label, as I just showed you, but I will reconfirm that, and if not, we will make sure that gets done.
Actually, when did you do it? Because I'm just refreshing this page. It just shows that it was modified as of August 26, 2021. So those new documents, if they had been done since then, they're not appearing, at least in this browser that I have open.
Sir, now I'll have to check that and get back to you, Mr. Hearing Examiner.
All right, thank you.
And I will do that and ensure that we get the right copy in there.
Okay, thank you, sir.
All right. Thank you, Mr.
So I'm not
Hearing Examiner.
for now, I'm going to defer admission until I hear back from you that that's actually been done.
Yes, sir.
Because otherwise it becomes an issue for the court reporter waiting on exhibits that were admitted that actually are not ready for prime time.
Understood, Mr. Hearing Examiner. Thank you. And thank you, Ms. Sanchez, for your answers and the testimony.
Thank you, Mr. Albright.
All right, up next is Mr. Bartel, San Juan County. I think you have 10 minutes with Ms. Sanchez, is that right?
Thank you, Mr. Hearing Examiner. I may want to move 5 minutes from Mr. Baker to this cross-examination.
Okay. 15 minutes then with Ms. Sanchez.
Yes.
All right, please proceed.
Ms. Sanchez, do you have the Board of County Commissioners for San Juan County Exhibit SJC1 available to you?
Yes, I do.
And your affirmation appears attached to these interrogatory answers and responses to requests for production of documents, correct?
I believe that it does. I'm looking just to confirm.
Should be the last page of the exhibit itself.
I'm sorry, the copy I have doesn't have that attached to it, but that might just have been my user error on my part. Let me look at this one here. Okay, yes, I see that.
Okay. So let me turn your attention first to interrogatory 1-14, which is found on page 7 of Exhibit SJC 1. Do you have that?
I do.
Now, in this interrogatory, PNM is being asked whether it contends that the provisions of NMSA 1978, Section 62-18-3 apply to the replacement resources part of this application. And after the objections, there's a statement that PNM is requesting the commission approve the abandonment of PNM share of Four Corners as of December 31, 2024. Do you see that reference?
Yes, I do.
Now, that doesn't exactly answer the question, does it?
Well, Mr. Bartel, in order to answer the question, you would have to go back and look at the statute in 6218.3 of the ETA and match the date that's on there with the date that's referenced in that statute, underline A. So I think that it does answer that, but I can walk you through that if you prefer.
Well, let's do that. Do you have a copy of the statute available to you?
I do. I'm actually looking at the 6218.3 now.
All right, so let me ask you to take a look at subsection A, which is where we find the date. And you would agree that the sentence states, quote, for a qualifying utility that abandons a qualifying generating facility in New Mexico prior to January 1, 2023, a qualifying utility shall, no later than 1 year after approval of the abandonment, apply for commission approval of competitively procured replacement resources, end quote. Do you see that?
I do see that.
There's nothing in that sentence which says that the other provisions of this statute would not apply to an abandonment that occurs after January 1, 2023, is there?
Well, Mr. Bartel, I would reference you over to section F of that section there. So subsection F, and if you'll permit me, starts with, as used in this section, quote, replacement resources means up to 450 megawatts of nameplate capacity, and it goes on to discuss what that means. So it reads in replacement resources into the definition of the location of resources, and essentially it also ties that to a generating facility, qualifying generating facility that is in New Mexico and prior to January 1, 2023 is being abandoned. My answer to this refers back to that same date, saying that Four Corners is being abandoned as of December 31, 2024. So it's after the date certain that's in the statute, which means that this section that's specific to the location of resource development is specific to a different qualifying generating facility, which would be one that we've already been through, San Juan Generating Station, not the Four Corners.
But Ms. Sanchez, if you read the sentence, the triggering date applies only to the time within which PNM, as the qualifying utility, must apply for approval of replacement resources. Isn't that right?
I disagree.
It doesn't say anything about what happens if there's an abandonment that takes place after January 1, 2023, does it?
You're right. It doesn't say anything about that, which means that this section wouldn't apply to something that is not constrained by the January 1, 2023 date.
And in fact, Mr. Fenton in his testimony specifically relied on this section to justify the bifurcated approach that's being taken in this case, where the request for approval to abandon is not coupled with a specific request for approval of specified replacement resources. Do you recall his testimony on that?
I don't believe he was referring to this section. He was referring to the requirements in the financing order application, which discusses a separate proceeding that the commission or the applicant can request. Not this section that has that language. It's in the section related to what needs to be in the financing application.
If we go further into subsection A of this section, in the second sentence, it talks about as part of that competitive procurement, and then it refers to the criteria in subsections B and C as being applicable. There's no reference there to the requirements of subsection F, is there?
Well, I would disagree with you because it's referring to replacement resources. When it says as part of that procurement, it's referring to the competitively procured replacement resources. And replacement resources, for purposes of this whole section, are defined in subsection F.
Isn't it true that PNM's application to abandon and securitize the cost of abandonment of the Four Corners Power Plant is brought entirely under the provisions of the ETA?
Sorry, can you repeat your question?
Well, the company is invoking the specific provisions of the ETA that allows for securitization on a very beneficial basis as part of the grounds for seeking approval of abandonment in this case. Isn't that right?
This case is being brought as part under the ETA, yes.
That's correct. And the only statute, the only provisions in the ETA which specifically address the determination of replacement resources is found in section 3 of the ETA. Isn't that right?
Section 3 of the ETA is the only section that defines replacement resources. That's correct.
So wouldn't you agree that it is inconsistent for PNM to be invoking the beneficial parts of the ETA in terms of the securitization provisions while attempting to reject the part that has to do with replacement resources?
I disagree with your characterization. I don't think that we're parsing out beneficial versus non-beneficial parts of the ETA. The ETA speaks for itself, and this particular section, even though you may disagree, Mr. Bartel, has a very specific date certain of January 1st, 2023, and in subsection F, it defines replacement resources very specifically and states that definition applies to this section. It doesn't say it applies to the entire ETA, and if it did, it would be in section 2, not in section 3, where the definitions for the entire ETA reside.
Well, we'll leave the resolution of this a little bit later, I guess, in the case briefing. Let me turn your attention now, Ms. Sanchez, to your responses to interrogatories 1-11 and 1-12 of Exhibit SJC1.
I'm there.
So actually interrogatories 1-11 and 1-12 ask essentially the same question, just with respect to San Juan County and then with respect to the state of New Mexico. And it asks for PNM's understanding as to whether assets owned by INTAC, the Navajo Transitional Energy Corporation, are not subject to the taxation of, in the first instance, San Juan County, and then the second instance, the state of New Mexico. And in the substantive answer to both of these interrogatories, you state, quote, PNM does not know the tax status of INTAC assets, end quote. So my question to you is, did PNM make any inquiries with INTAC with respect to its view of the taxable status of its assets?
Mr. Bartel, I worked, and I'm sure you saw this from my resume, LES1. I worked at the State Taxation Revenue Department for some time. In fact, I worked with your wife, and she's lovely, and you should say hi to her for me. In any event, I'm sure you're aware that giving tax advice is always dicey, right? And so part of my concern in this situation was to weigh in on, or to have any kind of opinion about the tax implications of a private entity, especially with regard to your esteemed client, San Juan County, and my former employer, the State of New Mexico Tax and Revenue Department. So the truth is that that was not part of my inquiry, certainly. I can't speak to anybody else as part of this transaction, but asking the tax status of Intech's assets for the purposes of your questions was definitely not part of my review of this case.
Okay. So I take it you are familiar with the purchase and sale agreement, which is Exhibit TGF-2 attached to Mr. Falgren's testimony?
I am familiar with it, yes.
Okay. And you would agree that nothing in that document speaks to whether or not Intech would continue to pay local property taxes, for instance, after the transfer, correct?
Subject to check. I don't remember any provision related to that issue, no.
And are you aware that Intech acquired the Navajo mine in 2013?
I subject to check. That sounds like the right time frame. It's not my area, but that sounds correct.
3 minutes, Mr. Bartel, 3 minutes.
Thank you. Are you aware that Intech has paid no state or local property taxes since 2013 with respect to the value of the Navajo mine?
Again, I don't know the status of their tax status on their assets. I do know that it is an entity of the Navajo Nation. I believe it's an enterprise of the Navajo Nation, and the Navajo Nation has sovereign powers, taxation being one of them. So it wouldn't surprise me entirely, to be honest with you, but I'm not aware of their tax status, unfortunately.
Do you have available to you Community Group Exhibit number 6, which is the enabling legislation for Intech?
I believe so. Give me just a moment to find that. All right, yes, I have that in front of me.
So section A1 starts on page 1 of 12. States in part, the Navajo Nation Council hereby approves the creation, formation, organization, establishment, and operation of the company, Intech, which will, subject to the limitations set forth herein, act as an arm and subordinate instrumentality of the Navajo Nation. Going down a couple of lines, quote, including without limitation the benefits, protections, and defenses associated with sovereign immunity and authorities of association and affiliation with a sovereign entity, et cetera. Do you see that reference?
Yes, I do.
And is it your understanding that one of the attributes of sovereign immunity, as it would apply in the instance of the Navajo Nation, is that it is not, in fact, subject to state and local taxation?
Well, again, I'm reaching back somewhat to my background, but that, as I said before, it does not surprise me. There's very reasonable policy considerations when it comes to Navajo Nation not being taxed by outside entities, by other entities. It's a sovereign nation.
So if in fact, after the transfer that you're seeking approval of the commission to enact or to consummate with Intech, there's the property tax revenue stream is being cut off to the local entities, including San Juan County, you would agree that it becomes even more important for there to be a serious look at where the replacement resources are being located, which in turn could be taxed and replace some of that lost property tax revenue, wouldn't you?
Well, I can agree that certainly replacement resources and the siting of them are an important consideration to any transaction. I think that PNM or any other utility is involved with. But I will also add that in this particular case, we're talking about the ETA, and there's some very important provisions in Section 16 of the ETA that require transfer of funds to the local community, well, essentially to the state agencies for the purpose of providing benefits to the local communities to address some of the issues you're talking about. And the local community in this case would include San Juan County. In fact, that's defined as the affected community. And that would be certainly a big part of the reason that this is a beneficial application to be bringing under the ETA right now is because of the opportunity for $16.5 million to be transferred to 3 state agencies that would assist with the economic development, worker displacement, as well as Indian affairs issues that will come up through this transition.
All right. Mr. Bartel, we're several minutes over. Are you?
I'm finished. Thank you very much for indulging me.
Thank you, sir.
Bartel.
Mr. Tisdale? CCAE, Ms. Zur waived cross-examination in an email to me received around lunchtime or earlier. So up next is Mr. Tisdale for community groups. Yeah, you have 30 minutes with Ms. Sanchez. Do you still have 30 minutes?
I do have 30 minutes. We'll see how far we get in that time. I might also request to borrow some time designated for other witnesses, if that would be okay.
Subject to perhaps taking a break, we'll see, because we're going to need one more brief break before we finish today. So please proceed. I have you at 30 now.
Okay.
So go ahead.
Thank you so much. Good afternoon, Ms. Sanchez. How are you?
Good afternoon. I'm good, thank you.
All right. You stated earlier that you are the Chief Policy and Legal Advisor for PNM, correct?
That's my title, yes.
Yep. And you are also an attorney?
I am an attorney.
Okay, great. As evidenced by the testimony that you just provided with Mr. Bartel, you have experience with the Energy Transition Act, is that right?
I do.
And you're also familiar with the proceedings and this commission's decision regarding the San Juan Generating Station abandonment, is that correct?
Yes.
In particular, you have familiarity with the ETA Section 16 funding mechanism, is that correct?
Yes.
In your direct testimony, which is at page 8, lines 20 and 21, you state that this case parallels the abandonment and financing proceeding under the ETA for San Juan Generating Station. You see that?
Yes, I do.
And you still believe that these cases parallel?
Well, I just want to sort of take a step back. The questions that's being asked is actually, how does this differ from the previous case? So what I was leading with is that it parallels. In other words, it's similar to what had been filed, but then I go through and talk about the distinctions in the rest of that answer.
Yeah, fair enough. Thank you for that clarification. Your direct testimony also estimates that there will be $16.5 million in Section 16 funding that is available in this case, correct?
Correct.
How does that amount compare to the Section 16 funds that were made available in the San Juan case?
Well, and now you're going to really test my memory, Mr. Tisdale. Because I don't have that document right in front of me, and so I don't remember what the exact amounts are. But I can tell you how they are derived. They're derived as a percentage of the overall amount of the bond proceeds. And so given that it's a percentage, and this amount that's being securitized in Four Corners is less than what was securitized or proposed to be securitized in San Juan, it will be a lesser amount, yes.
Okay. Under the ETA, when do Section 16 funds become available to the three agencies?
The ETA states that at the time of issuance, or I believe it says within 30 days, and I can go back and check the exact reference if you need that, but I believe it says that within the 30 days of issuing the bonds, that the percentages that are outlined in the ETA are to be transferred to the three different state agencies that are tasked with administering those funds.
Do you recall that PNM made a commitment to pre-fund a portion of those Section 16 funds in the San Juan case?
I do remember that, yes.
And there's already been testimony here today regarding the percentage of pre-funding being 25%. Do you recall that?
If it was stated earlier, I believe you. I was paying attention, but I have to admit I was distracted from time to time.
Yeah,
I was also reviewing.
Fair enough, Ms. Sanchez. Do you recall the general purpose of PNM's commitment for pre-funding? Like why they were making that available early?
Yes, I believe the purpose was in order to assist the local community in being able to deal with the transition that was heading their way a little sooner than waiting until the bonds were actually issued, which are proposed to not be issued until later. At the time that I think the application was going through was in 2019. The proposed closing of San Juan and issuance of the bonds wouldn't occur until, I believe, June 2022. So the idea was to try to pre-fund those so that the community had some time to access those funds and try to make some changes locally that could help with that transition.
Thank you for that. Has PNM made those pre-funded amounts available to the communities or the relevant state agencies pursuant to the commitment that they made in the San Juan case?
Well, let me just explain that the commitment, and to be very specific, the language was that it would be funded upon a final non-appealable order. And of course, as you know, in the ETA, there are provisions for an appeal, reconsideration by the commission, as well as an appeal to the Supreme Court. Our expectation, I think at the time that that was made, is that it would be a non-appealable final order of the commission, meaning after that amount of time had lapsed, right, 30 days after or whatever the time frame is, and it was actually appealed. I believe one of the parties in this case was the appellate there, the appellant, I should say, and because of that, it has not been final. So part of the problem is that without it being a final non-appealable order, the funding hasn't moved forward. There's been, unfortunately, a bit of a limbo in place.
And I'm not going to test your memory or how closely you are paying attention. There has been some other questions earlier about who at PNM might have authority to release those funds. My only question to you is simply, does PNM have the discretion, even though this legal challenge is taking place, does PNM have the discretion to make those funds available?
I think that under, when PNM made that commitment, it was part of the financing order that was approved by the commission. And that financing order is what spelled out the timeline, the language that I mentioned about a non-appealable final order. That's what was approved by the commission. Part of the question, at least in my mind, and I think that where I'm going with this is that if you were to, I don't necessarily think we would have the discretion without going back to the commission to have a discussion about whether there's some finality to the transaction. Again, because it was part of the financing order. this being new law, obviously, and all of us sort of learning as we go, others may have other opinions about this, but I believe that because it was part of the financing order and we're expected to follow the orders of the commission, that's something that would need to be addressed by the commission.
Are you aware of the immediate need of these funds to address ongoing layoffs at San Juan?
Well, I think that ongoing layoffs are certainly a concern in general for the company and for the entire PNMR family. I do think that the sooner that the community could receive these funds, the better. One thing to remember, though, is that it isn't a direct transfer from the company to the community, right? It wouldn't go, for example, to San Juan County or to the Navajo Nation. It has to go, as part of state law, it goes to state agencies that then determine how to administer those funds. So not to sort of punt this issue, but the state agencies have a responsibility for determining how best to use the funds, what kind of process they will have for applying for some of these funds. And I believe there was also a provision for an advisory council of some sort, an advisory committee at least, or an advisory group. I don't remember what the exact terminology was, but some sort of a community advisory process so that the agencies would have some input into how these funds should be allocated.
I think you're exactly right on that point, Ms. Sanchez. And are you aware that there actually has been a community advisory process that was underway, but ended up getting shelved when the pre-funding amounts weren't available?
At some point, and again, I'm remembering very briefly at least a couple of emails of people inquiring about a process that had been happening or that was talked about happening. I wasn't a part of that process, and I haven't heard about any of it recently. However, my recollection wasn't that it had anything to do with the funds not being available, because of course the advisory process didn't anticipate pre-funding anything. It wasn't sort of a process that hinged upon pre-funding. It's a process that's established based on when the proceeds are actually transferred, which under state law is supposed to occur when the bonds are issued. So I actually think that it was more of a pandemic process and a shortage of resources for those state agencies than it was having anything to do with the appeal or the pre-funding not happening. But that's my understanding. I don't know that for certain, and I certainly don't speak for any of those state agencies or the administration.
Yeah, no, that's definitely fair enough. There's been testimony in this case already regarding the legal standard to be applied to this case, being that of the net public benefit standard. And do you agree that this is the correct standard to be applied?
Yes.
And
I didn't hear an answer.
No.
Oh, I'm sorry. I said yes, Mr. Lee. Sorry about that. I'll speak up.
And do you agree with prior PNM witnesses that Section 16 funds are a significant component of the public benefit that PNM is claiming in its application for abandonment of Four Corners?
Yes.
And your rebuttal testimony, beginning on page 36, line 20, I'll give you a moment to locate that.
Did you say 36?
Page 36, correct? And then starting at line 20, I believe.
Yes.
Are you there?
I am. I'm sorry.
Okay,
yes.
great. Thank you, Ms. Sanchez. It states PNM agrees with Ms. Kitso that transparency and advance notice is absolutely necessary to a just transition. And for this reason, PNM has proposed funding the just transition funds at the time of PNM's abandonment with advance notice of the transition to give the community time to plan and resources to help with that planning. Is that correct?
Yes.
Okay. So let me just, to be clear on that, are you suggesting that the estimated 16.5 million in Section 16 funds will be available once and if the commission approves PNM's abandonment application, or at the time when NTEC would assume PNM's share of Four Corners?
So pursuant to the ETA, we would be proposing as part of our application that the transition funds be funded when the bond proceeds are issued. That's what's required in the ETA. And that is at the time of abandonment. So I'm not referring to the time of approval of abandonment, but I'm talking about at the time of abandonment. The bonds are, and Mr. Atkins can give more information about this in his testimony, but they're anticipated to be issued as close as possible to when the abandonment occurs. Right now, it's expected to occur 12/31/2024. The bonds would be issued very soon thereafter, but it's a holiday, of course, New Year's Day. So sometime in very early January 2025.
Yeah, thank you for that clarification. I wasn't entirely clear, so that really helps. So given the delay in the availability of these funds until the earliest, 2025, do you think that undermines to some extent the public benefit PNM is claiming relative to that funding?
No, I don't, because what I'm talking about in this section about proposing funds as soon as possible to help with the transition, we're talking about a transition for a community that will see layoffs and job loss and big industry moving at the time the plant closes. Right now, and I know there's been testimony already in the record as to this, but from my understanding, that's right now looking at 2031 when the plant will actually close. So this is actually 6.5 years earlier than that is when that would occur, when the funds would be transferred. And so that's what I'm referring to here, is that giving as much advance notice as possible for this community, 6.5 years in advance, for them to be able to determine how best to address this big change in their economy is really imperative for a community that's being impacted like this.
Thank you, Ms. Sanchez. I appreciate that. I'm going to transition a little bit. I appreciate all that background on the ETA. That is helpful. I'm going to transition a little bit in my questions. And if you would turn to your rebuttal testimony on page 34, line 1.
I'm there.
Okay. You state that pursuant to the PSA, NTEC is not assuming any responsibility for any of PNM's plant decommissioning and coal mine reclamation obligations. Is that correct?
Yes.
So I'd like to better understand the scope of what PNM believes these obligations include, if you will. Plant decommissioning is governed, at least in part, by the lease agreement between the Navajo Nation and plant operators. Is that your understanding?
So I will just caveat my answer with, I believe Mr. Falgren is much more knowledgeable about the details of the Four Corners, but subject to check, I do believe that that's part of what will determine plant decommissioning, yes.
Okay. And part of the requirement there is for full plant demolition rather than, for example, a retirement in place scenario, which was contemplated in the San Juan case. Is that your understanding?
At this point, that's my understanding.
Okay. To what extent are the reclamation obligations for San Juan Mine? For example, does this generally involve some earth moving and reseeding, or what does reclamation look like in the context of a coal mine like Navajo Mine?
That's an excellent question, Mr. Tisdale, but unfortunately, I'm not involved in any part of that aspect of PNM's business. So I couldn't really speak to exactly what it means. I would only speculate, and it would be probably not very useful to you or to the hearing examiner if I did speculate on that.
Are you aware that coal ash has been buried in portions of the mine?
I don't have any knowledge of anything specific. If you can point me to something in the record that I might be able to review, perhaps I could do that, but I unfortunately don't deal with that aspect of our work here at PNM.
Okay. Yeah, so why don't you turn with me to Community Exhibit 1, if you have that available.
Take this one. I'm sorry. Give me just a moment.
No worries.
And we have both electronic and paper, just so that we don't get lost here. But sometimes the paper is easier, and sometimes the electronic is easier. Okay. Go ahead.
Okay, so Community Exhibit 1 is the direct testimony of Carol Davis.
Yes.
I'm also going to be referring to Community Exhibit 2, just so that you are aware of that. And in Ms. Davis's testimony, among other things, she introduces what is identified as Community Exhibit 2. And this is an expert report assessing coal combustion residuals and associated groundwater contamination at Four Corners. Do you see that?
I do.
And you also have Community Exhibit available to you as well, Community Exhibit 2 available? Yeah.
Yes, I'm looking at it now.
Okay, great. So looking at Community Exhibit 1, in Ms. Davis's answer that starts at page 3 and beginning at line 8, she summarizes some of the conclusions in that expert report. Do you see that?
I do.
Okay. So that includes over 51 million tons of coal ash being disposed of in 6 unlined wet impoundments on Four Corners property. Is that correct?
I see that, yes.
Okay. And that an additional 33.5 million tons of coal ash have been dumped off-site in abandoned mine pits at Navajo Mine. Do you see that?
I see that also, yes.
And it also speaks of an estimated 4.9 million tons of fly ash that were transported off-site. Do you see that?
Yes.
And so just to be clear for the record, I know the expert report is entitled Coal Combustion Residuals, or it speaks of coal combustion residuals, and it speaks of those throughout. That is synonymous with coal ash, just so that I am clear for the record, and you are clear on that front as well. So if I say coal ash, I'm talking about coal combustion residuals and vice versa, okay?
I'm going to take your word for that. Subject to check, Mr. Tisdale.
Okay, thank you, Ms. Sanchez. So all of these amounts total over 89 million tons of coal ash. And you see that Ms. Davis has calculated that this total, if it were stacked on a football field, would reach 7.9 miles high. Do you see that?
I do see that.
That's a lot of coal ash. Ms. Sanchez, are you generally aware that coal ash is full of toxic substances that, if not properly disposed of, can leach into groundwater sources?
Generally, yes.
Yeah. Are you aware that most of the coal ash generated at Four Corners was disposed of in either unlined wet impoundments or were dumped in abandoned mine pits?
Well, based on what's on this page and what you read, assuming that that's what's in this attachment, I have no reason to disagree because I have no knowledge of that. So yes, go ahead.
So I promise to circle around to stuff that I think you will have more direct knowledge of, or at least I hope. So I'm just trying to provide some of this background. So thank you for bearing with me here. So turning to Community Exhibit 2, which is the actual expert report. And I'm going to use the pagination at the bottom of the page. So on page 1, at the bottom of page 1, and then following on to the top of the next page, page 2, the expert report concludes that APS and APS is the majority owner at Four Corners. So APS has generally done a poor job of assessing the geology and hydrology of the FCPP, or Four Corners Power Plant, in particular with regard to detecting and evaluating contamination and resulting from the disposed CCRs, so coal combustion residuals at the power plant. Do you see that?
Your Honor, I'm going to object. This is outside the scope of Ms. Sanchez's testimony.
Well, Ms. Sanchez does actually talk about environmental liabilities, for which coal combustion residuals are certainly one. That's actually all the questions I have with respect to the expert report itself. So I'm happy to move on, but I would say it's certainly within the scope of what Ms. Sanchez included in her testimony.
Yeah, that's fine, but I'm not sure how helpful it is to the trier of facts, so let's move on.
Okay.
And by the way, we have about 5 minutes left on the original 30. Mr. Tisdale.
Okay. I will go ahead and borrow, I think, an additional 20 minutes of time, if that's okay.
From whom?
I've got 5 minutes reserved for Ms. LaSalle. So all of staff witnesses. So there's 5 minutes for Ms. LaSalle, 10 minutes for Mr. Tupler, and 5 minutes for Ms. Deschanel. So I will borrow all of that 20 minutes if that is okay.
It makes the back end of this hearing, it helps the back end of this hearing, but for right now, yes, we'll then add 20 minutes. I've got that right, correct? 20 minutes?
Yes, Your Honor. And then with the 5 left, that would be 25 remaining. Is that correct?
Right. So let's 25 starting now.
And you did say that you wanted to take a break in here at some point. I'm happy to do that now if you'd like, or I'm happy to continue, whatever you prefer.
Ms. Sanchez, would you like a break right now?
Well, it sounded like Mr. Tisdale was about to ask a question, and I don't know if there's still an objection. So I don't want to leave that if we can wrap it up. I'm fine either way. Really,
okay,
it's
well,
your prerogative, Mr. Hearing Examiner.
Let's keep going. Mr.
Okay.
Tisdale, let's just keep going. And I think we're moving on to the next topic, correct?
Correct. Yeah.
All right.
So your rebuttal testimony, Ms. Sanchez, on page 34, lines 7 through 13, acknowledges that PNM remains on the hook for environmental liabilities, including environmental mitigation. Is that correct?
Yes.
And these environmental liabilities would include groundwater contamination from coal ash. Is that correct?
Yes.
Your rebuttal testimony makes a distinction between pre-closing and post-closing environmental liabilities. Is that correct?
Yes.
And in the
But
purchase,
I will also, I'm sorry
No,
to take over you.
please.
Just to add to that, and I mentioned this in that section, that's based on what's in the PSA. So it's not just sort of me saying that, it's a reflection of what's in the PSA between PNM and NTEC.
Yeah, and I'm actually going to have you turn to that PSA if you would. So that is in PNM Exhibit 4, it was included as an attachment to Mr. Falgren's direct testimony.
I'm gonna grab the hard copy if you'll give me just a moment.
Yeah, no, great.
Okay, I'm there.
So I'm going to ask some specific questions about some of these provisions, but starting just generally, what is your understanding of the relationship between the pre-closing environmental liabilities and the post-closing environmental liabilities?
Generally, my understanding is that PNM has responsibility for pre-closing liabilities, and I say this in my testimony. Post-closing liabilities are being assumed by NTEC. However, I do know that also in my rebuttal, I mentioned, because I think one of your witnesses talks about CERCLA liability, and I know you mentioned that before, which is essentially also called Superfund. There's also requirements with regard to operator, the term operator under CERCLA, with where transfer of an asset or transfer of property like this doesn't necessarily undo the obligations under CERCLA. So one of the things I state there is that, again, this is under federal law. CERCLA is a federal law that is administered by the EPA. So my point in the parts that I talk about this issue is that this transaction does not obviate responsibilities under CERCLA or under any other federal EPA jurisdiction. And additionally, Navajo Nation EPA also has some oversight here as well. And I know that there's some schedules or a list of some of the items that are part of the, I believe, the PSA with regard to Navajo Nation EPA permits and licenses. And so both the Navajo EPA as well as the US EPA, they both have responsibility here. And so again, my point is just that this transaction doesn't obviate whatever liabilities exist under those laws.
Thank you for that. That is helpful. I appreciate that, that additional clarification. Turn with me, if you would, to section 2.3 of the PSA. And using the pagination at the bottom, I believe that starts at the bottom of page 18. And this section describes the assumption of liabilities, which is what I believe NTEC will assume upon closing. Is that correct?
Yes.
And then subsection C there, do you see that?
Yes, on page 19.
Yeah, so that describes pre-closing environmental liabilities, which I understand are those liabilities that PNM will remain responsible for. Is that correct?
Yes, that's my understanding.
Okay. So I'm particularly interested in the last provision of this paragraph, which states such pre-closing environmental liabilities on or after the closing date, but in all cases, excluding any of the foregoing liabilities or obligations, including remediation, arising in connection with decommissioning. Do you see that language?
Yes, I do.
Am I correct in my understanding that because of the exclusion language, that any remediation in connection with decommissioning is something that NTEC is responsible for?
I'm going to object, Your Honor. This calls for a legal conclusion.
Ms. Sanchez is an attorney. She has spoken in her testimony about the PSA. I'm trying to understand what the terms of the PSA are.
I'll also object for lack of foundation.
Overruled. Go ahead, Ms. Sanchez.
Sure. So I understand what you've read there, and I need to go and look at the, as lawyers do, I need to look at the definition of what is, the way that remediation and decommissioning is defined in the agreement. It's been quite a while since I've reviewed this. But I will say that, my understanding is that there are, this doesn't change certain, obligations that PNM has, but I need to confirm what those look like, because I think that, again, it's just been a long time since I've looked at this provision in detail. Even since we filed rebuttal testimony, it's been quite some time, and my brain is full. So I don't know if it's best to take a short break where I can do that, or if you want to just have me do that while I'm here, Mr. Hearing Examiner.
Let's do that while we're here.
Well, curiously enough, Mr. Tisdale, as I'm sure you probably already know, remediation is defined, but of course decommissioning is not specifically defined. And remediation has a lot of the words perhaps that you were talking about before with regard to disposal, cleanup, treatment, containment. So in any event, going back to the section you were talking about, remind me again, we were on paragraph C of page 19. The last sentence, is that correct?
I have to admit, Mr. Tisdale again, we lost him for a second.
I'm sorry.
I apologize.
All right.
Can you hear me? I'm up in Taos and my internet just crashed, but looks like I'm back. So I sincerely apologize for that.
No worries, you're back.
Answer, Mr. Tisdale.
The joys of Zoom, huh?
No, okay, what I was actually asking, because I had reviewed remediation, but of course decommissioning does not appear to be, unless I'm missing it, it's not in the definition section. Do you happen to, and I'm sorry to ask you this, but do you happen to know if there's another place within the agreement that has the decommissioning spelled out? Because it's not spelled out in the definition section.
Yeah, and that was my problem as well, Ms. Sanchez, is it was not clear to me, and so I was hoping that you'd be able to help with that.
Unfortunately, I did not draft this document, and I have reviewed it as part of my my general review of the case and drafting of rebuttal specifically for that section. But of course, I don't remember. I mean, I know in general what decommissioning means, but usually with capitalized terms like this, you have as you all know, you have some sort of a definition, and there isn't one in here. So I'm sorry.
So you generally agree, however, that the scope of decommissioning and remediation requirements are quite relevant here.
I think that with regard to the PSA, sure, they're I think part of the agreement. There's certainly something that's spelled out as specific terms. What do you mean by relevance? Do you mean relevance to the transaction that we're here for?
Well, who's going to be responsible for those costs going forward once the PSA, if it is approved and that transfer occurs? It's quite relevant who's going to be on the hook, whether it's PNM or NTEC, for what could be very substantial costs.
Well, I think that obviously there's a reason why environmental liabilities in general are spelled out in an agreement like this. I think those are large issues and terms that need to be spelled out, which they have attempted to do in this agreement. I will say, though, that again, Mr. Falgren is probably, and I know he's already gone, but maybe around later again, he's probably the best person to ask these specifics of, given that he was involved in the negotiation of this agreement. All I can do is read it as much as you have and have, reflect upon the terms.
Yeah. Is it your understanding that coal ash contamination, such as we talked about before, that would generally fall under the definition of remediation?
Give me just a moment. I'm referring back over to definition of remediation, and now I'm looking at the definition of hazardous substances, excuse me, just to confirm that. I think it's hazardous, why am I having such a hard time? Hazardous substances in this PSA has a pretty broad definition, and there's in fact a large, it basically says any other or any other substance that is listed or regulated under any environmental law because it poses a hazard to human health or welfare.
That is a substance that is listed or regulated, and slow down, please.
I'm sorry, Mr. Lee.
That's quite all right.
All right, so yes, it says I'll just start over with that clause. I'm at page 6 under hazardous substances, and subsection C there, it says any other chemical, material, or substance that is listed or regulated under any environmental law because it poses a hazard to human health or welfare or the environment. My point was that that's a pretty broad definition, and in fact, if you look above that, it does talk about hazardous air pollutants. So in my lawyer brain, of course, provided that coal ash fits that pretty broad definition, then I would think that remediation would encompass what you're referring to as coal ash.
And PNM has been an operator at Four Corners for almost 60 years. Do you happen to have, or does PNM have an estimate of what its reclamation liabilities are in terms of a dollar amount?
Well, just a quick correction to your question and the framing of it. We actually have not been an operator for 60 years. We've been an owner. So we don't operate this plant. We own a minority percentage of it, 13%. So APS is actually the operator of this. So does that change your question?
It does. My apologies, Ms. Sanchez. I was using the definition of operator under CERCLA, which PNM is an operator there. But the gist of the question, I think, does remain is whether there is an estimate of what the amount of those liabilities are for PNM.
So I believe that we do have an estimate related to, I know there's a lot of cost estimates related to what our liabilities would be, and most of those cost estimates are in, or all of them, as far as I can remember, are in Tom Baker's testimony.
Okay.
But I do also know that there is a study that has to occur with regard to decommissioning, and I believe that happens periodically, but there is one that is supposed to occur with regard to decommissioning of Four Corners that will also inform what the costs are, I think, for all of the owners. And the best person probably to ask about that would be Tom Falgren.
Okay. We've got a few minutes remaining. What happens to the post-closing liabilities that NTEC would be responsible for if they're unable to meet those obligations? I
think you had a blip in your in your internet, but I think you said closing. It sounded like closing, but
Let me go ahead and repeat the question.
thank you.
Hopefully it'll come through more clearly. So what happens to the post-closing liabilities that NTEC would be responsible for if they are unable to meet those obligations? Who pays
I would
them?
need to, yeah, and I would need to probably spend a little bit more time with what the agreement states and review what's required under federal law. I do think that at some point, again, CERCLA was designed to deal with Superfund sites. I mean, that's what it's known for, is to deal with this sort of contamination that has occurred. And the liabilities under that would survive regardless of whether this transaction goes through or not, right? So there's still a federal requirement. So unfortunately, it would take me some time to determine a reasonable answer to your question.
Okay. I'm going to move down. I might circle back around to that, but let me, for sake of time, I'm going to move down to your rebuttal testimony on page 33, lines 11 through 13.
In just a moment. Tell me again what page?
Page 33, and then lines 11 through 13, I believe. And this recognizes essentially that the commission has capped costs that PNM may recover from customers for surface mine reclamation. Do you see that?
Yes.
Is it your understanding that this cap would include reclamation and remediation of the estimated 33.5 million tons of coal ash that has been dumped in abandoned mine pits?
Well, I do see that I referenced Mr. Falgren's direct testimony there, and I'm not sure, I can't remember if the mine reclamation is spelled out specifically in that direct testimony, but I do know that the cap that we're referring to there means the cap on the amount that can be collected from customers. We're not talking about the cap on the overall costs of remediation.
Am I correct that the cap has already been reached?
I believe that's correct.
Okay, thank you. How would costs be recovered from the 51 million tons of coal ash disposed of in wet impoundments at Four Corners property? And in that, let me just clarify, I think there's a distinction between the mine reclamation, which has the cap of what can be recovered from customers, versus what's been disposed of in these wet impoundments at Four Corners property. So there's a distinction there. And so I'm wondering how that money for the remediation of that 51 million tons of coal ash at Four Corners property, how would that be recovered?
I don't know, to be honest with you. I think you might consider asking Mr. Baker about, he's our cost of service guy. He may have a better answer, but I don't know an answer to that.
5 minutes, Mr. Tisdale.
Oh, thank you. I appreciate that. So you don't know whether that would be recovered from customers or whether that amount would be recovered or that shareholders would cover that amount?
I don't know.
Okay. So I think we've covered, the coal ash can cause the groundwater contamination. You've agreed with that, correct?
That it can? I'm sorry, did you say that it can cause groundwater contamination? Yes, I would agree generally with that.
Yeah. So I'm wondering about what happens with respect to the environmental liabilities that could occur from the groundwater contamination and its relationship to communities and individuals' health that that intersect with that groundwater contamination. So I'm going to provide a hypothetical, and you know, and I'll see what your response is to that hypothetical. So if there were a class action lawsuit, let's say, against Four Corners operators, and I'm using operators in this sort of CERCLA sense, so it would include the 5 owners of Four Corners Power Plant. So if there's a class action lawsuit for violating environmental laws in the handling of coal ash and resulting groundwater contamination, would PNM be responsible for the pre-closing liability that is determined?
Like a law school exam hypothetical here, Mr. Tisdale. But I'm going to do my best here, and I will say this much: there's joint and several liability under CERCLA, and I do think that even, you know, as I've already testified in my rebuttal, as operator under CERCLA, which is a different definition than we're using as operator of a plant. But operator liability under CERCLA is not something that just goes away because you transfer an asset. So I would think if there was a class action lawsuit, and as we both know as attorneys, generally a good plaintiff's lawyer is going to bring in as many people as possible to be joint and several defendants there to determine where the liability stands. So I think that PNM would not be, obviously there'd be a defense, and I'm not here as a lawyer for PNM. I have a policy position, but I think in any case and any hypothetical, as you're discussing, I think there would still be PNM, NTEC, APS, anybody APS worked with as a contractor, vendors, everybody would be brought into that litigation. So I don't think anybody's, and I don't think that we're representing that we're looking to walk away from this transaction in terms of environmental liability.
No, I appreciate that. And I'm not suggesting PNM is trying to walk away. I'm just trying to better understand the potential scope of what those liabilities could be. And there is that sort of pre-closing, post-closing distinction. What about those post-closing liabilities? What happens in the event that NTEC can't pay?
I think you asked me that already, and my answer unfortunately has not changed. I don't know what would happen.
And this is, I think, the last, just we're narrowing in on time, but I've got just like maybe 2 more questions.
And we have 20 seconds.
Okay, so maybe one question. Are you aware of, or have you or PNM offered any evidence in the record regarding NTEC's financial condition, setting aside what might have been proffered through discovery? But I'm interested in what has been affirmatively provided by PNM to the commission as part of its application. So any information that PNM has offered regarding NTEC's financial condition as sort of affirmatively as part of its application. Are you aware of any such evidence?
I am not.
Okay. Thank you so much, Ms. Sanchez. I greatly appreciated your responses, and I am sorry for the internet hiccup there that bounced me off, but thank you so much.
Thank you.
That's okay, Mr. Tisdale. That was a very nice recovery of your connection.
Okay.
Ms. Sanchez, we're going to take a 5-minute break, but before I do, I want to let you know that I feel kind of squeamish when we're getting into the legal discussions we are, but I understand that you are answering in the capacity that I expressly qualified you as, and that is as a regulatory policy expert, correct?
That's correct.
Okay. Thank you, Ms. Sanchez. we're going to take a 5-minute break. So please, Ms. Sanchez, consider yourself on that break. I'm going to take a question from Mr. Albright in the meantime. Go ahead, Mr. Albright.
Yes, Mr. Hearing Examiner, just want to let you know we uploaded Bernalillo County Exhibit 6 to the Dropbox. I left the old one in there so people can compare and see that they are exactly the same except for a label. It was inadvertently not loaded. It was inadvertently loaded without the label on the 26th when we went through that. So my apologies to everybody for that. I would remove the old one or try to remove it, but I am shorthanded here since my paralegal's husband just who's in the Army EOD just returned from overseas. So she's off right now, deservedly so. So
absolutely.
But people can compare the two and just to make sure that the one I was using today is the same one that was in the that we downloaded. It's the same one that I was making reference to earlier.
Yeah, I see that it was the file was modified, or the file was modified on September 1st at 3:55 p.m. So are you renewing your request for admission of BC6, which is now properly marked?
Yes, Mr. Hearing Examiner, I am. And again, that's going to be the only exhibit that we plan on introducing during the hearing. And I'll be using that as cross-examination for some other witnesses.
Is there any objection to the admission of Bernalillo County Exhibit 6? Hearing
Your Honor,
none. Go ahead.
No, based on the representations of Mr. Albright, we have no objection. That it's
Thank
the
you,
same
sir.
exhibit that had been preloaded without the exhibit mark.
It looks to be, it's black and white now. I thought it was color before, but assuming it's the same exhibit and that now that it's properly marked, Bernalillo County Exhibit 6 is admitted.
Thank you, Mr. Hearing Examiner.
Thank you. And
Thank
for
you.
the parties out there,
Thank you, Mr. Gifford. Appreciate it.
to the extent that please make sure that all your exhibits are properly marked, consistent with both the pre-hearing order, which is expressed on this and was expressed in the merger case, and not only that, but the commission's procedural rules that in compliance with both sets of rules or orders, if you will, in the case of the pre-hearing order, that everything is properly marked and identified in the folder, in the Dropbox folder, in the actual PDF itself. As I think you'll see if you look back at the pre-hearing order, it's pretty clear what is required there. So let's take 5 minutes. Ms. Nanazi, we'll come back at 4:30. Do you still have, how long do you have with Ms. Sanchez? You unmute yourself, please.
I'm sorry, I have 30 minutes.
All right. Well, at 4:31, we'll start with we'll do your cross-examination, Ms. Sanchez. Thank you.
Thank you.
When you're ready, Judge.
Thank you, sir. Okay. Before Ms. Nanazi starts, we have, after New Energy Economy, we have Sierra Club with, well, New Mexico Attorney General first has 50 minutes, 50-50. Mr. Elliott, are you there?
I sure am.
You still have, hi,
Hello.
you still have 50 minutes with Ms. Sanchez?
Yes, keeping in mind that I still have those minutes that I need to reduce from my other cross, and as we speak, I'm in the process of checking off questions that may have been asked and answered.
Okay, and then after that, Mr. Marks or Mr. Gerhart, Mr. Marks is on 45 minutes with Ms. Sanchez?
No, my cheat sheet has us down for 30 minutes with Ms. Sanchez. And,
Oh, I'm sorry.
and
I was in the wrong box. My bad, sorry.
But we will not use that. My estimate is 15 to 20 minutes, and when that time comes, I'll ask to move some time that I won't use to Mr. Graves. So we'll be,
I'm not going to change it right now when we get to you, though, but I just want to get an idea before. And then right after that is 50, the Water Utility Authority. Mr. Harris?
I don't believe we're going to use all that time, and we'll probably move some of it to Mr. Phillips.
And then staff, 40 minutes. Mr. Borman?
Yeah, I won't be using all my 40 minutes. I think it'd probably be.
Okay. Oh, I'm sorry.
I think it'll be more like 20 minutes is what I would use.
All right. Realistically, though, I think we're not going to get to that point today. So unfortunately, Ms. Sanchez, you're going to have to appear tomorrow morning. I'm sorry, but we just have too much to get through.
Okay,
So,
no problem, Mr. Hearing Examiner. Thank you.
thank you. So with that, it's Ms. Nanazi's turn. New Energy Economy has 30 minutes with Ms. Sanchez. Please proceed, Ms. Nanazi. Before you do, I'm sorry, Mr. Elliott?
Mr. Hearing Examiner, only for the purposes of childcare, can I anticipate that we'll be ending at 5 again today?
We will be discussing some housekeeping matters or some pending stuff. We're not going to have argument today, but we're going to be discussing what we're going to be doing in the morning.
Likely,
Ms. Sanchez will be on. Those matters do not pertain directly to the Attorney General's case. So you may be excused at 5 p.m. or now or whenever.
Thank you very much.
Thank you. Thank you, sir. All right, Ms. Nanazi, I'm sorry, your 30 minutes begin now.
Good afternoon, Ms. Sanchez.
Good afternoon.
Does the ETA require the commission to approve an abandonment regardless if the abandonment is in the public interest?
I believe I discussed this in my testimony, and there does need to be a public interest showing.
Is there a net public benefit to allowing coal to continue to burn?
An interesting general question. That's not what we are purporting to include in our application. I'm sorry, I'm not exactly following.
Is there a net public benefit to allowing coal to continue to burn?
I don't know how to answer your question, Ms. Nanasi, because we articulate what the public benefit is in our application, and we don't. Continuation of coal in our portfolio is not a part of that.
But in this application, by the sale from PNM to NTEC, coal will continue to burn, correct?
The plant will continue to operate, yes.
And so there will be further burning of coal. Is that right?
There will be, yes.
And so is that a net public benefit?
Well, I think that to answer that question, I would have to also add in that the continuation of jobs on the Navajo Nation and in the San Juan community, which brings with it economic benefits, would need to be part of that consideration as well. I think there's some economic justice issues here, and so that's part of why I'm having trouble answering your question. Net public benefit would assume that there's a number of different factors that go into the analysis.
And you just listed them, correct?
Not all of them. I mentioned one that's pretty significant.
Does the ETA require the commission to approve undepreciated investments regardless if those costs are imprudent?
The ETA does not discuss prudence. The ETA talks about costs that are in rates, that are in base rates as of January 1, 2019. And so those are the costs that are included in the application to be recovered.
So does that mean that your answer is that yes, the ETA requires the commission to approve undepreciated investments regardless if those costs are imprudent?
Ms. Nanasi, there hasn't been a finding of imprudence.
Well, that's interesting because that is what is going to happen in this case. Is that right? There's going to be a determination of prudence or imprudence, correct?
I don't know.
So I'm asking you just about the ETA. The ETA do you believe, is it PNM's position that the ETA requires the commission to approve undepreciated investments regardless if those costs are prudent or imprudent?
And I'll repeat my answer that the ETA does not discuss prudence. The ETA discusses having essentially what the abandonment costs are that are in rates as of January 1, 2019. Those were determined in the last case to be appropriately in base rates, and therefore they were prudent. They were not determined to be imprudent.
We'll get to that later, but I just wanted to ask you, so is what you're saying, you talked with the other attorneys that if something was not present in a statute, then that means that that it didn't apply. So I'm asking, like when you were talking to Mr. Bartel about replacement resources, for instance, and you said, look, the time here is before 2023, then replacement resources must be located in the impacted communities. But if it's after, it doesn't have to be. Remember that whole discussion with Mr. Bartel?
I remember him pointing me to a specific section, yes.
Okay, so I'm just asking you, you were one of you helped author the ETA, isn't that right?
I worked on the ETA in providing draft language with a number of other groups, a number of other advocates, and but I wouldn't call myself an author, no.
Okay, so you're very familiar with the language of the ETA, correct?
I am.
And you said that it allows for securitization of undepreciated investments for a qualifying generating facility, correct?
Right.
And it does not state that the costs have to be prudent. You've also stated that, correct?
That's not what I stated. What I said was that it doesn't discuss prudence. It says that costs that are to be recovered in base rates, that are in base rates as of January 1, 2019. So no, I didn't say anything about a determination on prudence. I said that there is no discussion on prudence.
In 2018, you were working as a lawyer at Cuddy and McCarthy.
Correct.
How did it come to be that you began working on SB 47, the Energy Redevelopment Bond Act that was later filed in the legislature in 2018?
Your question, how did it come to be? Can you explain what you mean by that?
How were you involved in the Energy Redevelopment Bond Act?
I worked as outside counsel for PNM in doing research on securitization around a number of states. Other states have legislation related to securitization, so I had done some research, and I worked with them on discussing some policy options.
When in 2018 did you begin that research for PNM as outside counsel?
I think actually it began in 2017. So I was working on, I worked, and I think it should be in, actually I don't know if the dates are in my resume, but I know that we answered at least one set of discovery from Sierra Club related to this, but, and it was also the subject, I think, of the our response to the motion to strike my rebuttal testimony. But I mentioned in there that I had worked with PNM on the 2017 legislation on consumer disclosure. And so I had been working with them throughout 2017.
So, but I'm specifically asking you about the Energy Redevelopment Bond Act. Is it your testimony that you began working on that in 2017?
I believe so. At some point in that calendar year is my recollection.
Was it after October 31st, 2017, or before then?
That's a good question, Ms. Namasi, and unfortunately, I don't remember the exact dates. I just know that based on the calendar of legislative interim committees and when legislation is due, things start to happen, ramp up, let's say, in that last quarter of the year, most of the time.
You now know that Mr. Eldred and Ms. Vincent Colon were engaged since at least 2019 throughout the first 3 quarters of 2020 in negotiations on the merger. Is that right?
Subject to check. I will take your word for that. I did not watch all of the merger hearings, and I haven't really read any of the merger transcripts or anything like that.
You now understand that Avangrid and Iberdrola have testified that they cannot have coal in their portfolio. Is that correct?
I think that there's been even some documents uploaded to our Dropbox in this case related to their goals on ESG.
And so those ESG, and just for the record, could you state what ESG goals are?
Sure, it's environmental, social, and, or it could be societal, I'm sorry, and governance.
Okay, so if it is environmental, social, and governance goals, are the ESG goals of Iberdrola and Avangrid forbid owning any coal assets in their portfolio?
I would have to look at the exact language of what it says. I don't know if it says forbid, but I know they have some goals about owning renewable energy, clean energy.
But specifically forbidding coal in particular. Do you know that?
Again, I'd have to look at the actual language to see if it says forbid coal. You want to point me to something?
Yes, please. Could you please go to New Energy Economy Exhibit 16.
Mr. Nazi, just for clarification, is this one of the disputed exhibits?
Not the exhibit, just the page that I would like Ms. Sanchez to go to, yes.
Okay. Which is which page?
Pulling it up right now. Actually, I don't think it is the part of the disputed pages actually right now. Give me 1 second, please. I'm sorry. I'm going to come back to it because I can't find my note right now. Oh, no, yes, here it is. Okay. Could you go to page 185? This page is not disputed.
So this has been, and just for clarification, this has already been admitted through Sierra Club's
Yes, sir.
admission. Okay, go ahead.
So it's page listed as page 185 on the top, on the right-hand side. Do you see that, Ms. Sanchez?
Yes, I do.
And sorry, 1 second now. I'm just going I'm not going to ask you that question right now, so we'll just hold off for a second. What is Project Roadrunner, Ms. Sanchez?
I don't know.
If you could please turn to, we will come back to this document, but if you could please turn to your rebuttal and specifically line 17.
All right, my rebuttal. And what page did you say?
17, please.
17?
Yes.
All right.
Did you write your this testimony, Ms. Sanchez?
I did. Of course, I had it reviewed and edited by folks who are much more careful about editing than I am.
It is your testimony that PNM's transfer to sale and transfer to NTEC of the Four Corners is unrelated to the merger. Is that correct?
That is my testimony. Am I supposed to be following some place in my rebuttal on that?
Oh, I might be wrong. Well, it's okay because I thought that it says here, I must have had that page wrong, excuse me. But your answer still stands, correct?
I think you asked me that about whether the sale and transfer of Intech was unrelated to the merger. That's correct.
Yes. Okay. Could you please now, I'm sorry about some of this confusion, but could you go to NE Exhibit 13?
in there.
Thank you. This question was posed by CCAE to the joint applicants in the merger case. And at the bottom on the left-hand side, it says the response date.
I'm sorry, what page
well,
are you on? Because all I went was to Exhibit 13.
Could you go to page 4 of 15 of that document?
Okay.
And on the bottom of that page, for instance, as is on most pages, it says joint applicants' objections and responses to CCAE 1, and it has the case number of the merger case, and it has the response date of December 11th, 2020. Do you see that? And
Could I ask if this is in the Sierra Club admissions and administrative?
It's not.
it is not.
Can you review it, Mr. Gifford?
I will state for the record that this was admitted in the merger case.
Well, I'm going to object to the extent that administrative notice of this has not been moved or accepted.
It has been moved, but it has not been accepted.
Where was it moved, Ms. Nanazi?
Excuse me, I'm sorry.
Where was it moved?
When
In your request?
Yes, in my request, when the denial of the Eldred subpoena was there, I believe that you ruled over the weekend. And then on Monday, first thing, New Energy Economy filed a request for administrative notice. I believe that in PNM's response that they said that they would agree to all reasonable requests. And this was one of the things that I specifically asked for and actually put in that question in the motion that I made.
And I'm looking at your request now. And this is numbered, what, 13, did you say?
Yes, sir.
And okay, uploaded. So request has been made, Mr. Gifford. So are you familiar with this?
I'm familiar with it. I confess, Your Honor, to not knowing what can be asked about Ms. Sanchez about a interrogatory answered by a different party in a different case. So I'm going to renew our objection.
Okay, I'm going to hold off on, go ahead, subject to the objection, Ms. Sanchez, please go ahead and answer. I haven't admitted this yet, but I'm going to allow Ms. Nanazi to use it as a cross-examination exhibit.
Thank you, sir. You know, in this case that the hearing examiner ruled on New Energy Economy and CFRE's motion to dismiss. Do you know that?
I'm sorry, you're talking about the Four Corners case?
This case, correct.
Yes, in the Four Corners case, yes.
And do you know that that ruling occurred on June 14th, 2021?
Sorry, I don't remember dates right now, but.
Subject to check, would you?
Sure, subject to check.
Okay. And so in December 11th, 2020, Mr. Pedro Azagra Velasquez you know that he was the witness for Iberdrola and Avangrid in the merger case, correct?
Yes.
And it states here that he responded, he was the respondent to CCAE's interrogatory. And the question was, are there any other contingencies that must be satisfied under the merger agreement? Do you see that question?
At the top, yes, like the third line down.
Yes. And before the hearing examiner ruled, Mr. In the motion to dismiss, Mr. Zagra Blasquez answered this question, and he stated that that Avangrid's internal policies precluded Avangrid from pursuing this transaction with PNMR in the absence of a clear and achievable path for PNM out of its ownership and operation of coal-fired generation. Did I read that correctly?
Your Honor, I'm going to object once again. This was not part of the admissions that Mr. German negotiated with Ms. Nanasi last night to take administrative notice of, and I don't understand how reading a discovery response to a witness who said she was not involved in the merger is beyond the scope of her testimony, Your Honor.
Well, in fairness to Ms. Nanasi, and I've always been more than fair with Ms. Nanasi, I'm going to overrule the objection, and I'll deal with all the rest of the stuff afterwards, but I want to go ahead and allow this to continue. Go ahead and answer the question, Ms. Sanchez, to the best of your ability.
I think the question that she asked me is whether she read the first sentence in the response correctly, and yes, I believe she did.
And so even if you didn't personally know that the exit of Four Corners was a contingency to the merger, doesn't mean that it was not, in fact, a contingency of the merger, right?
I'm going to object to Ms. Nanasi testifying, Your Honor.
She asked the question. Answer the question.
Sorry, can you repeat the question? I apologize.
You talked in a couple of different areas of your rebuttal that these are two separate, I think you said also I believe in response to somebody, your exact words were that the merger case and the Four Corners case, and I think I'm quoting, you said were completely separate. Do you remember testifying to that before? And I don't remember who was asking you about that.
I do remember saying that, but I also don't remember who it was, but I also remember saying that my understanding was that the conditions that were part of the merger were already fulfilled, that those included the filing of this case as well as the signing of the PSA to NTEC.
Right. But if there were discussions with Mr. Eldred and Ms. Vincent Colon, that it was more than just the filing and the PSA, but that it was in fact this agreement that PNM would sell its interest to NTEC and then earn the securitization amount. If there is that testimony out there and you didn't know about it, it doesn't mean that just because you didn't know about it doesn't mean that it didn't happen, correct?
Your Honor, I'll do this one more time. I'm going to object. This is assuming facts not in evidence beyond the scope of Ms. Sanchez's testimony. And once again, Ms. Nanasi is testifying, not asking a question.
Yeah, sustained. Ms. Nanazi, ask a different question to the same effect, please, and you have 3 minutes and 45 seconds left.
So, were you privy to the merger conversations between Mr. Eldred and Mr. Pedro Velasquez?
I was not.
And when did you find out about the merger agreement?
The day it was announced?
And so, do you now know about conversations between Mr. Eldred and the negotiations between Mr. Eldred and Ms. Vincent Colon and Pedro Azagra Velasquez?
Not.
And you were, and did you read any of the documents that Sierra Club and New Energy Economy uploaded about that in Dropbox?
I did not. There was so much going on in terms of timing and whether things were going to be in or not in that I did not have a chance, in all honesty, to review all of the documents that had been uploaded. I think I only reviewed what the Water Authority had uploaded, which had to do with something related to the merger, but no, I have not looked at Sierra Club and any.
Could you please go to New Energy Economy 8 and then go to page 68 of that document?
Did you say 68?
Yes, sir.
Thank you, ma'am.
Okay.
This is the certification of stipulation in case 16276. Do you recognize that?
Yes, that's what it says at the bottom.
And you read this in preparation for your testimony, did you not?
I am familiar with it. It's been a little while since I've read it in its entirety, to be honest with you. I read excerpts of it.
Could you please read the second full paragraph into the record? And then I have some questions to ask you about that.
Sure. I will
1 minute, Ms. Nanazi. Sorry, Ms.
try to do
Sanchez.
so slowly enough for Mr. Lee. The hearing examiners find that the appropriate remedy for PNM's imprudence in extending its participation in Four Corners and pursuing the $90.1 million of the SER investment and the $58 million of the additional life-extending capital improvements is the disallowance of all costs associated with the investment and improvements.
Could you read the next sentence, please?
This follows the precedent established in PNM's last rate case as a remedy for PNM's imprudence on the balanced draft investment, and as such, it would likely be the appropriate remedy if this case were being tried on its merits.
And you will understand that the hearing examiners in that case, because it was not a hearing on the merits, chose a different remedy. I'm just talking about the certification of stipulation right now, not what the commission ultimately decided.
Right, but when you say because it wasn't determined through litigation, you're referring to the last rate case, so 13-390?
No, I'm talking about, in this case, the hearing examiners decided not to have a full disallowance of all costs because it was not a hearing on the merits, it was a hearing on a contested stipulation. Is that what your understanding is of this case?
I think that's what this section says.
Thank you. But in this case today, it is your understanding that this proceeding is a hearing on the merits of PNM's prudence, and the commission's charge is to protect ratepayers from any any costs that were imprudently incurred. Is that correct?
Objection, Your Honor. This calls for a legal conclusion.
I believe that, Mr. Maderos, if I could, I believe that she goes into this in depth in her testimony. I could tell you it's on page 38, 39, 40, 41. She talks about whether which remedy should be appropriate, if any, if there's a finding of imprudence.
But that's not the way you asked the question.
Is it your understanding that this proceeding is a hearing on the merits on PNM's prudence, and the commission's charge is to hold ratepayers harmless for any imprudent investments by utility management?
Objection once again for legal conclusion, characterizing the scope of this proceeding.
Overruled, and it goes to wait. Ms. Sanchez DeSancho, to the best of your ability as a regulatory policy expert. And this will be your last answer for the evening. Thank you.
Mr. Hearing Examiner, Ms. Nanasi, I don't understand this to be a hearing on the merits the way that you have characterized it. I understand that the hearing examiner did request additional supplemental testimony, which we provided. I also know that several witnesses raised the issue of prudence, which I rebutted in my testimony. But I also know that, and I think we've already had this discussion about what the ETA says is appropriate as an abandonment cost. And I know that there wasn't a finding of imprudence in the last rate case. And I also know that in the order on the complaint that New Energy Economy filed, the commission made clear that there wasn't a finding of imprudence in the last rate case. So I don't know this to be a case on the merits of prudence the way that you have characterized it. So I disagree with that statement.
Thank you, Ms. Sanchez.
Thank you, Ms. Nanazi. Ms. Sanchez, thank you so much. You're excused for the evening. We'll see you tomorrow morning. Have a good evening.
Thank you so much, Mr. Hearing Examiner. Thank you. You too.
Thank you. All right. Now, what I'd like to do before we break for the evening is just to get straight where we are with the outstanding matters. I have an emergency motion to take administrative notice of portions of record in 16-00276-UT pursuant to Commission directive. Mr. Giver, do you know whether PNM is going to respond?
Yes, Your Honor, I believe we were going to respond overnight. If you would prefer oral response, I would suggest, given his centrality to it, we would want to get Mr. German, who is down the hall if we need him more immediately.
I just want to know, we need to resolve the issue. I just wanted to know whether I should be looking for responses, but particularly a response from PNM, obviously, as the party who would be opposing this.
You will get it tomorrow morning, Your Honor.
Okay. This emergency motion, Ms. Nanazi, gives me pause. And one should be careful about one writes. One should always be careful about that. I don't know whether I mentioned the Lincoln drawer to you this morning. Did I?
I don't know what.
You know,
Lincoln?
The Lincoln drawer.
Yeah.
Abraham Lincoln, everybody's favorite president, or well, most people's favorite president, maybe Andrew Jackson, I don't know. But anyway, had a drawer, right? And he'd write letters to generals, and sometimes, or to other people. Sometimes he'd put intemperate stuff in there and think, you know what? Maybe I should put this in the drawer and let it sit for a while and see how it ages and whether I really should release it to the public. Well, just a word to, well, now you know what the Lincoln drawer is in any event. So with that in mind, yes, I am taking this very seriously, as I take everything, but there are some allegations in there that are of significant concern to me. So I'll just preface as we leave for the evening with those remarks regarding this so-called emergency motion, on a motion that's already existing and on something that you filed but didn't file a motion last night, which is the same issue. And that is your email at 5:48 last night. And where you attach three things, right? It's, and let me read very quickly what it says. In revised order partially adopting certification of stipulation, and you cited page 23, paragraph 66, dated January 10, 2018. Last line, it states, in the subsequent proceeding, administrative notice will be taken of the evidence on the issue of prudence admitted in the current proceeding, meaning 16-276 UT. I won't go through the rest of it, but is there any objection to me making that Commission Exhibit 1 in this case? Because I am. Because it was an improper pleading. It was an improper pleading. And I'm going to make that an exhibit here. So preface that for, and then on top of this, for whatever reason, we see at a little after 8 this morning, another emergency motion on the same topic. So that's 3 pleadings on the same topic, Ms. Nanazi. So that will be Commission Exhibit 1. I will download it and prepare it and put it in the proper form, marked and labeled properly in Dropbox as Commission Exhibit 1. Now, again, everybody go back and check your Dropbox folders. I'm getting off the emergency motion and this administrative notice on 16-276. And make sure that your exhibits are properly marked, because even as late as tonight, we still had an issue with that. And Ms. Nanazi, last I checked, there are still several exhibits in there of yours that have not been marked yet. It's up to you whether you want to mark them or not. They will not be admitted unless they're properly marked, though. Also, please do update your indices of exhibits. Sierra Club did that. Thank you, Mr. Marks, this morning. Please ensure that you update your indices or indexes of exhibits so that they are accurate and up to date. And then the last thing is, with regard to this other outstanding dispute over the administrative notice of certain portions of the record in the merger case, I want to understand precisely, Ms. Nanazi, what is in dispute. I understand that we have pages 196 and pages 255 and 56 of the testimony that you were talking about, right? And then we have NEE 13 in addition to that. What else in terms of the universe of disputed documents? I want to review them. I want to make sure. Is there? You know, can you say offhand?
I will in 1 second. So NE Exhibit 13. I believe that everything else, except for those 3 pages and NE Exhibit 13, has been admitted. If you give me, can I just have just 30 seconds? Let me just double check this.
Yes, ma'am.
That's it, sir. Thank you.
All right, so that narrows the universe on that issue. So we'll address that first thing, the merger case documents that are in dispute. And I want to obviously take a look at PNM's response and any other responses on this so-called emergency motion. Third stab at the issue. And then I probably won't rule on it right away because I don't see, tomorrow we have Ms. Sanchez, and then we have, to the extent we're lucky, Phillips, Baker, and Settlers. And also bear in mind, I have to end the hearing early tomorrow at 2. So I mentioned that at the beginning, but unfortunately it hasn't changed. I still have to end the hearing at approximately 2 p.m. tomorrow. So with that, everybody have a great evening.
Can I ask a clarifying question, please?
Yes, ma'am.
So my understanding, and please correct me if I'm wrong, is like for Exhibit 8, the certification of stipulation, I wanted to use it as an exhibit, but I think I don't have to make it as exhibit, like ask for it its mission, because I can just cite to it in the brief. That's correct, is that right?
And yes, and yes, that's correct.
Okay,
and
so
don't, and so we head off some more aggravation. Don't ask for admission of the ROO, the ROO.
exactly, sir. That's
Because
what
because I've already ruled on that.
exactly. And there's other documents, and I think that those are the only documents that don't have an exhibit marking on them, are documents that are either commission exhibits or other exhibits like what you just stated, which I think that's the only other one. So
okay,
but I'll double check to make sure, but I just, because I want to, but I just wanted to have that clarification. So thank you.
yeah, and that's fine. But you know, the part of the reason I want to have that, my commission exhibit 1, is your last sentence is, additionally, we reserve our right to use any of the documents in briefing because we complied with the commission's and hearing examiner's orders. Well, I will see if you complied or not. And if you didn't, and you go ahead and cite things, well, we'll see if they survive being stricken or not. But, and again, after all of this headache over it, query, what is it worth to the finder of fact? Keep that in mind. I tried to say this in several orders up till now, tried to steer the parties in that direction, and it's not quite resonating yet fully. So, but we'll see. But anyway, Ms. Nanazi and everybody else, have a good evening. Mr. Lee, thank you very much.
You bet, Judge.
Thank you, sir. We are in recess until tomorrow morning at 9. Thank you.